stated that the decree holders will not be considered as a financial creditors. And now the recent judgment of Supreme Court, which clearly states that they should be kept in par with other home buyers and they should be treated equally as if they are the financial creditor. So considering them differently from other home buyers will not serve the purpose of the resolution plan, and they should be treated equally with the other home buyers. So basically there are multiple ups and downs what we are overseeing as far as the inclusion of home buyer or inclusion of the allottees. If I say from the language of the RERA, the inclusion of the allottee in the definition of the financial debt, that is section 5 subsection 8 clause F, there are multiple things which are keep on changing and which are keep on running before us. So as far as this entire discussion is concerned, I would like to divide this discussion in three phases. Initially, I would like to have a discussion with regards to certain important provisions of the RERA. By understanding the provisions of the RERA, we can able to identify that what are the remedies which are already available with them in the Real Estate Regulation and Development Act. On the contrary, they have the remedies which are also available in the Consumer Protection Act 1986. Now it is 2019. But now, disregarding the remedies which are otherwise available to the home buyers or the allottees, they are now referring the matters before the Insolvency and Bankruptcy Code. As far as the IBC is concerned, it was 2018 when, on the basis of the recommendation of the Insolvency Law Committee, the allottees have been considered as a financial creditors, and yes, amount which is accepted by a developer or real estate company from the allottee was classified within the definition of the amount which is having an effect of commercial borrowing. So the amount which the real estate entity has accepted from the allottee have got the position, have got the place in the definition of financial debt, and they have been started recognized as the financial creditors. What happened thereafter? The constitutional validity was challenged before the Supreme Court. Pioneer Urban Land and Development, the Pioneer judgment, wherein the Supreme Court has upheld the validity, the constitutional validity of that amendment 2018. So whatever was the included or whatever has been included in the definition of financial debt, or the allottees which have been included or considered as a financial creditors, the constitutional validity which was challenged by the real estate developers, the constitutional validity was upheld by the Supreme Court, but there was a lot of misusage with regards to defining them as a financial creditors of the company. They have started moving an application for the sake of recovery before the NCLT as an adjudicating authority. And again, this was challenged before the Supreme Court, and further amendment which has taken place in the year 2019, that is 28 December 2019, and it was stated that no single allottee holds any locus to move an application under section 7 before any corporate debtor. And there was a amendment which was brought in section 7 subsection 1 second proviso, which states that if you move an application, first of all, an application will be moved jointly by the allottees. So project wise classification was introduced, that at least 100 of such allottees with regards to a particular project, or 1/10 of the allottees with regards to a particular project, whichever is less, only they can maintain a valid application before the adjudicating authority if the allottee wanted to move an application to initiate CIRP. So that was a further development which has taken place. Also, one form which was introduced, that was form number CA for submission of claim. If you are the allottees or a home buyer, even otherwise, if you are a debenture holders or a depositor of the company, you have been classified as a separate class of creditor. and one separate form for submission of claim was introduced. It was 3rd July 2018 when Form CA was introduced for submission of claims. Not only this, once the CIRP commence, within 3 days, the IRP is duty bound to give a public announcement. And when IRP is aware of the fact that this company is having the class of creditor, IRP is duty bound to give the name of 3 insolvency professional, so that the insolvency professional who gets the maximum number of votes from the class of investor, that insolvency professional shall act as a authorized representative and having a representative power before the committee of creditors. So over the period of time, the COC seats have been reserved for this allottees representative, and the representative of the allottees used to represent the says of the COC in the CIRP process. Down the line, the conflict still exists, that though they have got the position, though they have got the locus of being called as a financial creditors, but are they standing neck to neck in comparison with the other secured financial creditor like bank or financial institution? And unfortunately, no. And that's why in the Supratech, NCLAT experimented with the code and evaluated the concept of, given an emphasis on the concept of reverse CIRP, so that the interest of the home buyer should remain secured vis-a-vis the operation of the corporate debtor, and the CIRP shall remain confined only to that project leading to which the default has occurred. Till date, there are multiple disputes with regards to the cases where the developer is somebody else and landowner is somebody else, and the construction over the land is in dispute, or default is pertaining to a project which is project pertaining to a corporate debtor, but unfortunately the land belongs to some other developer. So such nature of disputes are also pending before the adjudicating authority. Always question come before the adjudicating authority whether joint CIRP can be initiated against two separate entity. One is the entity who is owning the land, and the other is the entity who is into the development or who is having the development obligation. There are multiple questions which remain unresolved, that if the land is owned by a proprietor but development is being taken care of by the company or the LLP, in such cases the CIRP can be very well initiated against the company and LLP, but being a owner of the land who is a proprietor, how that CIRP can be commenced because part 3 is not yet enforced. So basically there are multiple things which we are going to discuss. Also, as an IRP or RP, we always have the question before us that how to classify and how to consider the claim, because there are varieties of the home buyer which come before us with their claim. We used to have the home buyers, those who wanted to claim the refund, those who wanted to cancel their booking. There are multiple home buyers, those who have paid the application money but no allotment is made. Multiple home buyers, those who have paid the application money, also the allotment has taken place, but they have not got the possession. There are multiple home buyers, those who have got the allotment later, they have got the possession, but the registration is not done. This is also a nature of dispute, which is right now being faced by the IRPs and RPs who are handling the matters of CIRP of a real estate company. There are multiple disputes pertaining to the fact when the secured creditors are claiming the rights over the apartments, flats, buildings, which are already being claimed by the real estate owners, this home buyers. So as far as this nature of disputes are concerned, that are day in day out being faced by the IRPs and RPN, still at the end of the session we will able to understand that why there is a requirement to have a separate chapter to be incorporated in the code itself, wherein the treatment or the process of the insolvency resolution of a real estate company can be defined, can be clarified. There has to be a procedure, which a separate procedure which has to be adopted for resolving the insolvency of the in this real estate entities. Anyways, will be beginning with our agendas will be divided in the three phases. First, we will be dealing with the provisions of the RERA. We'll be dealing with the important provisions of the RERA. Not all the provisions, but yes, we will be going through word by word the important provisions through which we can able to identify the obligation on the part of the promoter of the real estate entity, and what are the remedies which even otherwise are available to a home buyers or to an allottee if they wanted to avail the benefit under the RERA itself. Because approaching NCLT, an admission of an application by the NCLT against a real estate entity, there is very less chances that allottee will get its residence or apartment or flat for which he is fighting. Because if the CIRP will continue, and suppose if the CIRP ended up with a good resolution applicant who is proposing a resolution plan, probably the same buyer, the same allottee is going to ended up with paying some more amount. So basically, there are multiple challenges before the consumer forum. They are not getting the immediate remedies. Before the RERA, they are not so RERA authorities, wherein there are no multiple orders which are being passed by the RERA authorities, and if the orders are being passed, there is a lack of, you can say, a successful execution decrees which are being passed. So execution applications are again one of the biggest challenge under the RERA, and that's why nowadays the allottees are preferring to move before the adjudicating authority under the insolvency and bankruptcy code to initiate the CIRP. So first we'll be dealing with the RERA. We'll be taking care of certain provisions, certain important provisions of the RERA. We will be back with the IBC, and we will be going through certain provisions of the insolvency and bankruptcy code. We'll study IBBI, insolvency resolution process for corporate persons regulation. We'll be dealing with all those aspects where the allottees have got the position in the COC. Allottees have got the position under section 7, representative of the allottees or the class of creditors to have their own role to play, the limited role of the authorized representative, that will be dealing in the second half. And third half, a general case laws from 2018 onwards up till date, that how the alterations in the code has taken place, and how the judgments of the Honorable Supreme Court, NCLED and NCLT has clarified the role of the home buyers or the position of home buyers in IBC. We'll be starting my discussion with the RERA first. Is my screen visible?
Yes, sir.
Thank you, sir. So first of all, it is very important to understand the objective for which this particular RERA, the Real Estate Regulation and Development Act 2016, was enacted. And when you see the objective, you can able to identify that the home buyers or the allottees, we can say, they have got the authority before which they can go, they can place their dispute, and to get their dispute adjudicated. When you see the objective of the code, the objective of the code is all about for the regulation and promotion of the real estate sector, one of the most unorganized sector in India. And the enactment was with an aim to regularize and to promote the real estate sector, and to ensure the sale of plot, apartment, building, as the case may be, or sell of real estate project in an efficient and transparent manner. to protect the interest of consumer in the real estate sector, establish an adjudicating mechanism. So this is one of the alternative now available with the allottees or home buyers for speedy dispute redressal, and also to establish the appellate tribunal to hear the appeals from the decisions and directions or the order of RERA, an adjudicating officer, and for the matter connected therewith or incidental thereto. Meaning thereby, as far as if I'm the allottee, I have to see the financial health of the real estate entity. So, disconsidering that if I will be moving before the adjudicating authority under Section 7, even though if I will be eligible to move an application under Section 7, because we are 100 or 1/10 of such allottees pertaining to a particular project, even though our applications get admitted, but now it will be a proceeding before RAM. Meaning thereby, the chances which were available otherwise to get the amount of compensation or interest within this law, or the possibilities which were there otherwise to get your possession of apartment and flat, you have missed the opportunity by moving such an application under such a law whose objective is the resolution of the insolvency and not to grant you the compensation. So it is very important that you being an allottee, you being a home buyer, you have to check that what is an objective of the code or what is an objective of a statute under which you are moving, and what remedy you will get at the end. Just because you have got the right under the law to move an application, and you are moving an application, because many a times the prayers are also very important. If you move an application under this real estate regulation and development act, your prayer is to the point that you want a compensation, you want the amount to be paid along with the interest, or you want possession to be made up till this date. And if the possessions have been delayed, you will be entitled to get the interest up to the date of possession. So that is a kind of the prayer which you have when you move an application before the adjudicating authority under the RERA. But when you move an application before the insolvency and bankruptcy code adjudicating authority, that is NCLT, whatsoever may be the intent of your application, but your application will always be carrying one prayer, that is to initiate CIRP, which is not going to be advantageous if you move an application against an insolvent entity. Okay, but a solvent entity, it is always advisable to avail the remedy available under the RERA. As far as the allottees are concerned, we are going to see the same definition when we will be dealing with section 5 subsection 8 clause F, which talks about allottee in relation to a real estate project means a person to whom plot, apartment, or building, as the case may be, has been allotted, sold, whether freehold or a leasehold, or otherwise transferred by a promoter, and include the person who subsequently acquired the said allotment through sale, transfer, or otherwise, but does not include a person to whom such plot, apartment, or building, as the case may be, is given on rent. So, as far as the allottee is concerned, it is there under Section 2, Clause D, which clearly states that in the real estate project, a person to whom a plot or apartment or building, so this definition is not only confined to a flat or an apartment, but including a plot, has been allotted, sold, or otherwise transferred by the promoter, and including the person who subsequently acquired the said allotment through sale, transfer, or otherwise, but that does not include a person to whom a plot, apartment, or building is given on rent. So this is one of the vital definition from the viewpoint of the insolvency and bankruptcy code. I will be dealing with section 3, which mandatory requires a registration. When you see section 3, we'll be dealing with all the relevant section, and then we will be back to the IBC. When you see section 3 of the RERA, it clearly states that no promoter shall advertise, market, book, sell, or offer for sale, or invite person to purchase in any manner any plot, apartment, or building, as the case may be, in any real estate project or part of it, in any planning area, without registering the real estate project with the RERA established under that. So basically, Section 3 talks about a prior registration of real estate project with real estate regulatory authority. This mandates that if any of the promoter who wanted to propose, or who is where the area of land proposed to be developed does not exceed 500 square meter, that is an exception. Or where the number of apartment proposed to be developed but does not exceed 8 inclusive of all places, that is an exception. Otherwise it is mandatory that promoter is under an obligation that he cannot advertise, he cannot market, he cannot book, he cannot sell, he cannot offer for sell, he cannot invite person to purchase in any manner with regards to plot, apartment, or building in real estate project unless and until that project gets the registered with the RERA authority. So this is one of the mandatory requirement as far as section 3 of the RERA is concerned. When you see section 4, it talks about that promoter shall make an application to authority for registering of the real estate project in such form, manner, and such time as accompanied by such fees as may be specified. Now, why this is important? Because when you will be moving an application under section 7 of the insolvency and bankruptcy code, from this you can able to establish the default. Let us check this. So when a promoter will move an application before the authority, that is real estate regulation authority, the RERA authority will ask for this document. First is brief details of his enterprise, including name, registered address, type of the enterprise, particular of the registration, name and photograph of the promoter. So this thing will be in the public domain. A brief details of the project launched by him in past 5 years, whether already completed or being developed, as the case may be, including current status of the project, any delay in the completion. So I have to give a brief with regards to my current ongoing project or the past project. I would give the authenticated copy of the approvals and the commencement certificate from the competent authority in accordance with the law as may be applicable for the real estate project mentioned in the application. And where the project is proposed to be developed in phase, the authenticated copy of the approval and commencement certificate from the competent authority. So that is what I have to place it before the authority. That is the RERA. The sanction plan, layout plan, specification of the proposed project or phase thereof or whole project as sanctioned by the competent authority. The plan of development, works to be executed in the proposed project, the proposed facilities to be provided thereof, including firefighting facilities, drinking water facilities, emergency, and other renewable energy. So basically, you have to give it a complete set of your proposed project, location detail of the project, with clear demarcation of the land dedicated for the project, along with the boundaries, including latitude and longitude of the end point of the project, pro forma of the allotment. This is very important. This is very important that when you will move an application for getting your project registered, you have to mention that what is going to be the pro forma of your allotment letter, what is the pro forma of the agreement for sale, and the conveyance date proposed to be signed with the allottee. So this is very important. The number, type, and carpet area of the apartment, that is pertaining to the size, number and areas of garage for sale in the project. So garage is also having its specification in the definition part. Name and address of his real estate agent. I would like to say one more thing, that RERA also mandates these agents to get themselves registered. So if any particular projects, if the real estate company has engaged few agents, so the agents are also duty bound to get themselves registered with the RERA, and the name of these agents are required to be placed before the RERA authority, and it is there in the public domain. Name and address of the contractor, architect, structure engineer, or any other person connected with the development of the proposed project, and see the declaration which are required to be signed by the promoter, stating that he has a legal title to the land on which the development is proposed, along with legally valid document with authentication of such title if the land is owned by other person, that the land is free from all encumbrances, or as the case may be, detail of the encumbrances on such land, including any right, title, interest, or name of any. And this dispute you will find in the IBC. Land belongs to somebody else. The development is being taken care of by some other entity. The landowner is financially very stable and solvent, but since the developer has committed a default, the land owner, the owner of the land, is also facing the heat of this CIRP. So this kind of disputes are also there before us when we will be dealing with this topic in the time to come. The time within which he undertakes to complete, so there calls a default. When such application is made, this application is required to be made with this undertaking. The time period within which he undertakes to complete the project or phase thereof, as the case may be, very important, because from this detail you can establish that there is a delay in possession or there is a default. That 70% of the amount, this is very important, that 70% of the amount realized for the real estate project from allotee. So whatsoever amount i have I have received as a booking amount from the allotee, from time to time shall be deposited in a separate account to be maintained in a scheduled bank to cover the cost of construction and land cost, and shall be used only for that purpose. And whenever I will withdraw the amount, I have to take a certificate from a chartered accountant and from an engineer and an architect. This is provided in this proviso that promoter shall withdraw the amount from separate account to cover the cost of project in proportion to the percentage of completion of the project. So this is something which was not there before the RERA. And that's why even after the commencement of the RERA or enactment of the RERA, the disputes are multifold. So one can able to imagine that what was the level of the unorganization in this real estate industry before the commencement or before the enactment of the RERA. Provided further that the amount from separate account shall be withdrawn by the promoter only after it is certified by engineer, architect, and a chartered accountant in practice that the withdrawal is in proportion to the percentage of completion of the project. Provided also that the promoter shall get his account audited within 6 months from the end of financial year by CA, and shall produce a statement of accounts duly certified and signed by CA, and it shall be verified during the audit that the amount collected for a particular project have been utilized for the project, and withdrawal has been in compliance with proportion of the percentage of completion of the project. He shall take all the pending approvals on time, and he has furnished such other document as may be prescribed under the rules and regulations. So basically, in a nutshell, what we were understanding is when you move such application for getting your project registered, these are the information, these are the declarations which you are supposed to submit, and out of the submission, tomorrow allotee can able to identify, can make out a default that there is a delay in possession. Section 5, which talks about granting of registration. So authority will grant the registration within 30 days. On receipt of the application, the authority within a period of 30 days grant registration subject to the provisions of this act and rules and regulations made thereunder. Provide a registration number, very important now, including login ID and password to the applicant for accessing the website of the authority, create his web page, fill therein the details of the proposed project. Reject the application for the reason to be recorded in writing if application does not conform to the provisions of the act, but before rejecting, an opportunity will be given to the promoter. If the authority fails to grant the registration or reject the application, as the case may be, within 30 days the project shall be deemed to have been rejected, and authority shall within a period of 7 days of the expiry of the said period of 30 days provide. So if the authority fails to grant the registration or reject the application, as the case may be, as provided under subsection 1, the project shall deem to have been registered, not rejected, and the authority shall within a period of 7 days of the expiry of the said period of 30 days, that is up to 37th day, provide a registration number and login ID and password to the promoter for accessing the website and to create the web page. So basically, you need to keep your portal updated with regards to your project, with regards to the information pertaining to your project. When you see the extension of registration, because of the COVID, we have seen that multiple possessions have been lapsed. The due dates of possessions have not been, you can say, complied by the promoter of the real estate company. And that's why you will find some sort of, you can say, some sort of understanding pertaining to this, what we call a force majeure clause. So registration granted under section 5 may be extended by the RERA authority on an application made by a promoter due to force majeure in such form and on payment of such fees as may be specified by the regulation made by the authority, provided that authority may in reasonable circumstances without default on the part of the promoter but based on the fact of each case and for the reason to be recorded in writing extend the registration granted to a project for such time as it considered necessary, which shall in aggregate does not exceed a period of 1 year. So there is always a limitation pertaining to the extension which will be granted in absence of the default made by the promoter. Revocation of registration is also a power with the RERA authority. The authority may, on receipt of the complaint or suo motu in its behalf, or on the recommendation of the competent authority, revoke the registration as granted under Section 5. If the RERA authority is satisfied that the promoter has made a default in doing anything which was required under this act or rules or regulation made thereunder. So on this grounds also the registration may be revoked, or promoter has violated any of the terms and condition as granted as terms and condition which was imposed at the time of granting of approval, or promoter is involved in any kind of unfair practices or irregularity. So basically the authorities are having this power to even revoke the registration of the promoter. This is an explanation which states that unfair trade practices is a practice of making any statement, whether in writing or by visible representation, which falsely represent that the services are of a particular standard, represent that the promoter has approval or affiliation which the promoter does not have in actual sense, makes any false or misleading representation concerning the services. So this is getting your apartment booked or a flat booked or a building booked by giving this kind of statement. Promoter permit the publication of any advertisement or a prospectus, whether in newspaper or otherwise, of services that are not intending to be offered. The promoter indulge in any fraudulent practices. So basically, these are the grounds on the basis of which they have the power to, you can say, revoke your registrations. uh, Certain more sections to be focused upon. This is what we have seen, that registration of real estate agent, that no real estate agent shall facilitate the sale or purchase of or act on behalf of person to facilitate sale or purchase of any plot, building or apartment, as the case may be in real estate project or part of it, being the part of the real estate project registered under 3 by the promoter any planning area without obtaining registration under this section. So obligation is not only on the builder, obligation is not only on the real estate developer, but also on the real estate agent, a broker through whom the sale or the intended sale is being made. As far as the next important thing is concerned, this is section 11, functions and duties of the promoter. You can see from this particular section, you can able to identify that how the RERA has brought in the transparency, or how the default can be established once the promoter, a real estate entity, actually makes a default. You can see this functions and duties of the promoter under section 11 of the RERA, which states that the promoter, upon receiving its login ID and password, this is upon getting the project registered under section 5, the promoter shall create his web page on the website of the RERA authority. Enter all the details of the proposed project as provided under subsection 2 of section 4 in all the field as provided for public viewing, including details of the registration granted by the authority, quarterly up-to-date list of the number and types of apartments or plots as the case may be which are booked, quarterly up-to-date the list of the number of garages booked, quarterly up to date the list of approval taken and approval which are pending subsequent to commencement certificate, quarterly up to date status of the project, such other information and document as may be specified by the regulation. Meaning thereby, it is not the case now that you get your project registered, you get your bookings done, and there is no accountability towards the stakeholder. So here the accountability is before the authority. Here, the accountability is towards the authority as well as to the stakeholder, as well as before the allottees from whom you have accepted the booking amount. The advertisement or the prospectus issued or published by the promoter shall mention prominently the website address of the authority, wherein all the details of the registered project have been entered, including RERA registration number. The promoter at the time of booking and issue of allotment letter shall be responsible to make available to the allottee the following information. So when I am going to allot the letter or when I will be entering into an agreement for sale, it is important for me to make this information available with regards to sanction plan, plan layouts as approved by the competent authority, stage-wise time schedule of completion of the project. Promoter shall be responsible for all the obligations, responsibilities, and function under the provision of this act. Now, meaning thereby, even if the ownership of the promoter get transferred, even if the ownership of the promoter get transferred, suppose a proper, you can say a project which was being taken care of by ABC Associates or ABC and a company, and suppose if the partners are moving out of that partnership firm or the LLP or the company, the incoming promoter will be responsible for all the obligation of the erstwhile promoter, which we are going to see. The promoter shall be responsible for all the obligations, responsibilities, and functions under the provision of this act, rules, regulation made thereunder. To the allottees as per the agreement for sale, to the association of allottees. So, after a certain number of booking, it is important to have an association to be formed, as the case may be, till the conveyance of all the apartments, plots, and building, as the case may be, to the allottees, provided that the responsibility of the promoter with respect to structural defect, very important, the responsibility of the promoter with regards to structural defect or any other defect for such period as may be referred under section 14 shall continue even after the conveyance date of all the apartments, plots, and building, as the case may be, is allotted or are executed. So obligation with regards to structural defect will continue even after the conveyance date have been executed. Promoter shall be responsible to obtain the completion certificate, occupancy certificate as applicable from the relevant competent authority as per the local laws. Promoter shall be responsible to obtain the lease certificate if the project which is developed is on the leasehold land. Shall be responsible for providing maintaining essential services on reasonable charges till the taking over of the maintenance of the project by association of the allottees. To enable the formation of the association or society or a cooperative society, as the case may be, of the allottees or a federation of the same under the law applicable. So basically, it is all about the obligation with regards to the promoter. Execute a registered conveyance deed of the apartment, plot, or building, as the case may be, in favor of allottee, along with undivided proportionate title in common areas to the association of allottees or competent authority. It is again an obligation on the part of promoter to pay all the outgoings until he transfer the physical possession of the real estate project to the allottees or association of the allottees, including land cost, ground rent, municipal or other taxes, charges for water or electricity maintenance, including mortgage loan, interest on the mortgage, and other encumbrances. This is very important. Where the promoter fails to pay all or any of the outgoings collected by him from the allottee or any liability, mortgage loan, or interest thereon before transferring the real estate project to such allottee or association of the allottee, as the case may be, the promoter shall continue to be liable even after the transfer of the property to pay such outgoings and penal charges. So I can say, as far as this RERA is concerned, there are a lot of the remedies or there are a lot of obligation which are already hammered upon the promoter of the real estate entity. And if the promoter of the real estate entity or the real estate entity is financially stable and sound, there are multiple grievance redressal mechanism which are already provided under this code itself. This is important. This is important. The promoter may cancel the allotment only in terms of the agreement for sale, provided that the allottee may approach the RERA authority for relief if he is aggrieved by such cancellation and such a cancellation is not in accordance with the terms of agreement for sale, unilateral and without any sufficient cause. For this reason, if you are approaching the NCLT against a very solvent real estate entity, a solvent promoter of the real estate entity, ultimately that will not serve the purpose. And that's why I said, as far as the RERA Act is concerned, and as far as the IBC is concerned, your prayers are going to be very different in both the statute. If you will be moving an application before the NCLT, in the IBC, before the adjudicating authority, irrespective of your intent of moving such application, your prayer is only confined to initiate CIRP. Whereas before the consumer forum or before the RERA authority, if you will be moving an application, you will be able to move your application with the real intent for which you wanted to get your issue resolved. Section 12, obligation of the promoter regarding veracity of the advertisement or prospectus. So this is something which again makes a purpose of the code. So basically, as far as the RERA is concerned, it clearly casts an obligation upon the promoter to bring before the public only the things which he is going to offer. He cannot personate where a person makes an advance or a deposit on the basis of the information contained in the notice, advertisement or prospectus, or on the basis of any model apartment plot or building as the case may be, and sustain any loss or damage by the reason of incorrect false statement, he shall be compensated by the promoter in the manner as provided in the act. The remedy are all there, provided if the person affected by such incorrect false statement contained in the notice, advertisement or prospectus or model apartment plot or building as the case may be intends to withdraw from the proposed project, he shall be return his entire investment with interest and the compensation in the manner as provided under the act. This is again very important, that what promoter can accept as a booking amount and what he cannot. No deposit or advance to be taken by the promoter without first entering into an agreement for sale. So without agreement for sale, he cannot accept any amount beyond 10% of the cost of the apartment. This is provided in section 13. When you see section 13 of the code, the promoter shall not accept a sum more than 10% of the cost of the apartment, plot, or a building as the case may be, as an advance payment or an application fees from person without first entering into a return agreement for sale with such person and register the said agreement for sale under any other law for the time in force. Meaning thereby, if you are going before any real estate company, then that promoter of the real estate company is not in a position to accept any amount more than 10% of the cost of the apartment, plot, or building as the case may be, as an advance payment or an application fees from you without first entering into a return agreement for sale with you and register the said agreement for sale under any other law for under any law for the time in force. Meaning thereby, this is something which is in the interest of the home buyer. The agreement for sale referred in subsection 1 shall be in such form, and this is what we have seen at the time of registering my project. The pro forma of allotment letter and the pro forma of agreement to sell is something which I have to upload with the RERA authority. I have to submit to the RERA authority. I have to furnish to the RERA authority. The agreement for sale referred in subsection 1 shall be in such form as may be prescribed and shall specify the particular of development of the project, including the construction of building and apartment, along with specification and internal development work, external development work, the date and manner by which the payment towards the cost of apartment, plot, and building, as the case may be, are to be made by the allottees, and the date on which the possession of the apartment, plot, or building is to be handed over, the rate of interest payable by the promoter to the allottee, and to the promo in case of default, and such other particular as may be prescribed. So this is something which is there in the code. As far as again section 15, obligation of the promoter in case of transfer. So this is what I said. During the continuation of any project, if I want to step out in the capacity of the promoter of that real estate entity, there are certain obligation, and there are certain obligation which are in the heads of the incoming promoter also. Section 15 states that promoter shall not transfer or assign his majority right or liability in respect of real estate project to third party without obtaining prior written consent from two-thirds of the allottee except the promoter and without prior written approval of the authority. So meaning thereby, if promoter wants to transfer or assign majority of the rights and liability in respect of any real estate project in favor of third party, then this is not possible without seeking a written consent from two-thirds of the allottee. And as far as this two-thirds of the allottee is concerned, that shall not include promoter and without prior written approval of the RERA authority. Such transfer or assignment shall not affect the allotment or sale of the apartment, plots, or building as the case may be in real estate project made by the erstwhile promoter. This is very important for the purpose of this subsection. The allottee, this is very important, please take care of it. The irrespective of the number of apartment or plot as the case may be, booked by me, booked in the name of my family, in the case of other persons such as companies, firm, or association of individual, by whatever name called, booked in its name or booked in the name of the associate entity or related enterprise shall be considered as a one allottee. In the Companies Act, we do have a provision of ownership of the shares in joint name. So when the shares are held or when the shares are held in a joint name, the joint holder will be treated as a one. And similarly, here also, this allottee will be regarded as one, will be treated as a one as far as the counting is concerned. On the transfer or assignment of being permitted by the allottee, two-thirds of the allottee, as well as by the RERA authority, the intending promoter or the incoming promoter shall be required to independently comply with the pending obligation, such as provided under the provisions of the Act, rules, regulations, and pending obligation as per the agreement for sale entered into by the erstwhile promoter with the allottee. Provided that any transfer or assignment permitted under the provision of this section shall not result in extension of time. So one cannot assign rights, one cannot assign liability, one cannot take a step out and transfer the rights and obligation with an intent to seek any extension. So any transfer or assignment permitted under the provision of this section shall not result in extension of time to the intending promoter to complete the project. And he shall be required to comply with all the pending obligation of the erstwhile promoter. In the case of default, such intending promoter shall be liable to the consequences of the breach or delay as the case may be, as provided under this act, rules and regulations. So basically, with an intent to get out of the condition, with an intent to seek any kind of leverages or liberties with regards to completion of the project, such an assignment or transfer will not serve the purpose. Obligation of the promoter with regarding insurance of the real estate project, not so important for this discussion. Transfer of title, this is something which is important, that promoter shall execute a registered conveyance deed in favor of the allottee along with undivided proportionate title in the common areas to the association of allottees or competent authority as the case may be, and hand over the physical possession of the plot, apartment, or building as the case may be to the allottees and common areas to the association of allottees or competent authority as the case may be in real estate project, and other title documents pertaining thereto within specified period as per sanction plan. Provided that in absence of any local law, conveyance deed in favor of the allottee or association of allottee or competent authority as the case may be under this section shall be carried out by the promoter within 3 months from the date of issuance of occupancy certificate. After obtaining an occupancy certificate and handing over the physical possession to the allottee, it shall be the responsibility of the promoter to hand over the necessary documents and plan, including common areas, to the association of allottees. After going through all the provision, what I can take a pause here and can say one thing. As far as the remedies are concerned, again and again, I would like to say this is altogether a different thing that your the flat or the apartment which you have booked and that real estate entity itself is in CIRP, then you don't have any other option left except filing of your claim and be a part of the COC. But before moving an application under Section 7, one has to go through an intent of the RERA law, an intent of the code, because lot of the remedy which a person, a allottee, if the allottee may not even able to get by moving an application under the IBC, but RERA is having a sufficient provision to give him the nature of relief which he is expecting or which he is praying for, which is praying for. Return of the amount and compensation. This is something which is very important. Section 18, and multiple allottees, and almost all the allottees are having a grievance pertaining to Section 18 only. If the promoter fails, from here the dispute starts. From here, the application are generally moved before the authorities or before the consumer forum or before the adjudicating authority of the IBC. If the promoter fails to complete or is unable to give the possession of an apartment, plot, or building, here the dispute start, or here the grievance of the allottee starts. If the promoter fails to complete or unable to give the possession of an apartment, plot, or building in accordance with the terms of agreement for sale, as the case may be, duly completed by the date so specified therein, or due to discontinuation of its business as a developer on account of suspension or revocation of registration, then he shall be liable to demand to allottee, liable on demand of the allottee in case the allottee wishes to withdraw from the project without prejudice to any other remedy available. And that is what you will find in section 88 of this RERA, that remedies available in this RERA is in addition to and not. This is very important. When you see section 88 of this particular RERA, this is provided under section 88, that the remedies which are available to the allottees under this act are in addition to and not in derogation of the provision of any other law for the timing for. This is very important. Meaning thereby, the allottee holds all the right to move his application, to make his case before the RERA authorities, or even he may go before the consumer forum, or the allottee may also invoke section 7 of the IBC, because RERA Act does not restrict any application if made before the consumer forum or if made before the NCLT. Section 88 clearly states that the provision of this act shall be in addition to and not in derogation of the provision of any other law for the timing in force. This is section 18. Again, coming back to 18, which says that he shall be liable on demand of the allottee in case if he fails to give the possession in accordance with the terms of agreement for sale, or in case due to discontinuation of his business as a developer on account of suspension or revocation of the registration under this act, the promoter shall be held liable on demand of the allottee in the case the allottee wishes to withdraw from the project without prejudice to any other remedy available to return the amount received by him in respect of that apartment, because any such amount so received by him in respect of that apartment, plot, or building is now considered as a financial debt under the IBC. Provided where the allottee, now this is the another nature of allottee who don't want to withdraw or cancel. So provided where the allottee does not intends to withdraw from the project, he shall be paid by the promoter interest for every month of delay till the handling over the possession at such rate as may be prescribed. The promoter shall compensate the allottee in case of any loss caused to him due to defective title of land on which the project is being developed or has been developed in the manner as provided under this act, and the claim for compensation under this subsection shall not be barred by limitation provided under any law for the timing in force. So very important. Claim for compensation under this section shall not be barred by limitation provided under any law for the timing in force if the promoter fails to discharge any obligation imposed on him under this act or rules or regulation made thereunder, or in accordance with the terms and condition of the agreement for sale. He shall be liable to pay such compensation to the allottee in manner as provided under this act. But not only this, if you are an allottee, there are certain duties on your part also, and that is what you will find in many section 7 application when the reply is being made by the corporate debtor. When real estate entity defend any section 7 application, they also bring on record the breach of duty on the part of the allottees. Allottees are also under certain obligations. If many a times it is witnessed in the courtrooms that the stand taken by the corporate debtor, the stand taken by the real estate entity is that the applicant is not the allottee per se, and he's just a speculative investor. You will find this when you will be overseeing a dispute with regards to a real estate entity pre-CIRP stage. Section 19 cast certain duties on the part of allottee also. They have the rights, the promoters do have their obligations also, but there are duties on the part of the allottees, and that duties are supposed to be taken care of, or there are duties which are required to be taken care of by the allottees. Section 19, the allottee shall be entitled to obtain the information. So there is a doctrine which we call a doctrine of constructive notice. So that is what all it's all about. The allottee shall be entitled to obtain the information relating to sanction plan, layout plans, along with the specifications, approval by competent authority, and such other information as provided under this act, rules and regulation made thereunder, or agreement for sale signed with the promoter. So first of all, the other person, the allottee, should be vigilant enough. Allottee shall be entitled to know the stage-wise time schedule for completion of the project, including the provision for water, sanitation, electricity, and other amenities and services as agreed to between the promoter and allottee. The allottee shall be entitled to claim the possession of apartment, plot, or building, and the association of allottee shall be entitled to claim the possession of the common area as per the declaration given by the promoter under Section 4. Under Section 4, when promoter moves an application before the RERA authority for registering its project, it is important for the promoter to mention that by when, after what, within how much days after getting the occupancy certificate, this possession will be given, or one is entitled to claim the possession of the common areas. The allottee shall be entitled to claim the refund of the amount paid with interest at such rate as may be prescribed, and compensation in the manner as may be provided in this act from the promoter. The promoter fails to comply or is unable to give the possession of the apartment, plot, or building, as case may be, in accordance with the terms of agreement for sale, due to discontinuation of his business as a developer on account of suspension or revocation of the registration. The allottee shall be entitled to have the necessary documents and plan, including that of common areas, after handing over the physical possession of the apartment. So you are not only entitled to get the physical document of your apartment, but also you are entitled to get the necessary documents and plan, including that of common areas. Every allottee who has entered into an agreement for sale to take apartment, plot, or building, as the case may be, under Section 13 shall be responsible to make necessary payments in a manner and within time as specified in the said agreement for sale. So basically, this is something which is going against you as an allottee. So suppose if you have not made a timely payment, if you have not shared the necessary payment with regards to registration charges or municipal taxes, water and electricity charges, maintenance charges, ground rent, then in that case, even though you are moving an application even before the RERA authority or before the NCLT, but such an application will go against you, because as a allottee, you also have a duty. That duty casts an obligation on you to make necessary payment in a timely manner. If not, you shall be liable to pay interest at such rate as may be prescribed for any delay in payment towards any amount or charges to be paid. The obligation of the allottee under subsection 6, liability to pay interest under subsection 7, may be reduced when mutually agreed to between the promoter and allottee. That is different thing. If the real estate entity is waiving the interest or penalty, if not, you are liable to pay if you fail to make the payment, a statutory payment, within a definite timeliness as agreed in the agreement to sell. Every allottee of the apartment, plot, or building, as the case may be, shall participate towards formation of association, that is cooperative society. Every allottee shall take a physical possession of the apartment, plot, or building within 2 months from the date of occupancy certificate. Every allottee shall participate towards registration of conveyance date of the apartment, plot, or building, as the case may be. So the game is not Moreover, the obligation is not only up to the promoter, but there is also an obligation on the part of the allottee to perform his part of job. When you see section 31 says any aggrieved person may file a complaint with the authority. If you are an aggrieved, you always have the option in this act to put a complaint before the RERA authority or the adjudicating officer, as the case may be, for any violation, contravention of the provisions of the Act, rules, and regulation made thereunder against the promoter, allottee, or the real estate agent, as the case may be. So basically, what you can say, when you see the RERA, this is all very clear that you have the remedies available under this law. Functions of the authorities, it is provided section 32. Functions of the authority shall include, this is something which is not so important, but at the end, what I can say at this moment is, when you see there are certain provisions which are made under the RERA itself, which cast an obligation on the part of the promoter to perform his part of duty. Vis-a-vis, there are certain obligation on your part, there are certain duties on your part, and those duties are also, it will be bring in the attention of the court or before the judicial authority when such application with a malicious intention is made before the real estate promoter. And this is what, as I said, that section 88 is something which clearly give them a leeway, which give them an option, which give them an opportunity, which give them enough liberty to move application wherever they want, because section 88 talks about that whatever may be the provisions of this act, these provisions of the act are in addition to and are not in derogation of the provisions of any other law for the timing in force. But most importantly, the applicant need to understand the real intent of his application, his prayers. If I'm the real estate entity, if I'm the allottee, if I'm the home buyer, I am not actually interested that this real estate entity goes in insolvency. I'm actually not interested that whether the CD is in financial, or I am not at all interested with regards to the financial health of the real estate entity. My first priority, my foremost priority is to get the compensation if I'm not satisfied. If I'm canceling any, if I'm canceling any agreement, I'm supposed to get the compensation. I should get compensated. I should get my amount back with interest. So this is my limited prayer. Otherwise, my intent is always to get the possession, a timely possession. That is my intent. And when you know that the real estate entity or the real estate company against which you are intending to move, they are financially sound, they are financially stable, the possessions have delayed, the possessions are delayed, or some, what we call, the activities of promoters are something which are going against you or against the right and interest of the home buyer, then in that case the multiple remedies are per se available under this RERA, and there is no need to move an application before the NCLT, because as I said, the application either it will get rejected or admitted. If rejected, you will be remediless under the IBC, and again you have to invoke the remedy which are available under the RERA or under the Consumer Protection Act. And if admitted, then it will be go in rem, meaning thereby once insolvency will commence, you should understand that you are just a home buyer, you are just an allottee, and the company is big, having a multiple creditors. They will submit their claim, and we never know whether this resolution process will ended up with resolution or whether it will go to insolvency. But one thing is for sure, the possession is further delayed now. So after going through the RERA, I will take a pause here, and I will say one thing. If in case if there are certain discussions which are required from the purview of RERA, we can have a discussion on the same, and thereafter we should go to the insolvency and bankruptcy code and insolvency resolution process for corporate persons regulation 16, and then we will be moving with certain case laws which can demonstrate the development within the law.
I have a couple of questions here.
Yes, sir.
Can I? Thank you for your presentation, and certainly it is very informative. One is that, from a overriding perspective, does the IBC code override the RERA in case of conflicting provisions, or the other way around? And
Absolutely,
second,
yes.
the IBC is the non-obstante clause holds here over RERA. Is that what you're saying? Hello.
Hello.
Yeah. So IBC overrides RERA Act, is it?
Absolutely.
Okay. Second, the act that you were going through
This is
right
what
now.
we will see in the while discussing the pioneer urban land development case, where
Okay.
it is Supreme Court has clearly mentioned that RERA will not come in between the IBC, and it is the
Right.
IBC as a court which will overrule the RERA in case of conflict, irrespective of whatever is stated in Section 89 of RERA. Section
Okay.
89 of RERA is all about the non-obstant clause, but it is the IBC which will prevail, and it is what decided by Supreme Court in Pioneer.
The
Yeah.
same
And my
question
second
will be.
question is that this act that we were going through, this RERA is a state legislation, right? So when you are talking about this act provisions, is it particular to a particular state, or
No, no.
are we
This
talking about
is
the
basically
central?
the central law, which
Okay.
are subordinated with the state law. So when we talk about the RERA, then
Right.
all the state have their own act, which is in
Correct.
line with the RERA. So in Gujarat, we have a Gujrera. So
Right.
Gujrera will get all the basically when you see the powers of the RERA, the Gujrera will get all its power, or Aloti under this Gujrera also will having all their obligations and their rights as derived from the RERA. So basically, the state will be having its own power to make the regulations or rule pertaining to the act, but it is the act which will survive and which will prevail while constructing or while drafting a particular state law pertaining to this particular act.
Sir,
So you
this,
cannot have any provisions in the state act which is against or conflicting with the provisions in the central act.
No.
Right. Right.
sir,
Okay.
I would like to ask one question. The same
Yes.
behavior will be the Consumer Protection Act. Suppose one order has been passed by the Consumer Court, and
Okay.
the case is pending before the the CRP has been started by the NCLT. In that sense, the order which has been passed by the Consumer Court, they are started the execution proceeding also in that case. So, what will be the remedy with the IP in that case?
May you come again with your question because there was some disturbances.
Acha. I want to
So
say
as you referred that Alotti has approached the consumer forum.
Consumer Forum and the order has been passed in his favor.
Okay.
For the recovery of the amount and the allotment of the plot. The
Huh.
plot should have to be given. And the execution
He
proceeding has been started by the consumer court also.
Correct. Being an IRP or RP,
Hmm.
you are only going to see from the eyes of that person being an allottee. That's it.
Ah, ah,
Irrespective of the order which is passed by the consumer forum, because in order to execute that order,
ah,
he have some other alternative to approach authority or to approach the court to
hmm,
getting his order executed.
hmm.
But being an RP or being an IRP, I am not going to consider, you can say, I will not segregate his, or I am not going to give a different treatment in comparison to what treatment I'm giving to other home buyers or other allottees.
No, no,
For me,
I'm not giving any other treatment to the home buyer, to
hmm,
that home buyer. Question is that the execution proceeding has been started by the consumer court. So
hmm.
definitely the property which is situated at the site will be affected by that order when the execution proceeding will be started by them. We are filing the application before them that you cannot take any action till the matter is pending before the
But how
NCLT.
can, if the moratorium is commenced, how can this order will prevail?
Moratorium is there, so that order will not prevail, but they are doing the work on that.
They cannot. Basically, once the moratorium is commenced, how that order will survive or how that order can even get passed?
Yes.
The order has already been passed by them.
No,
If
no, there's
order
a
is
state.
already passed before the commencement of CIRP, that is different thing. But once CIRP,
During the CRP, they have passed the order. Even
it
after.
cannot be. It cannot prevail. Section 14 will overrule this order.
The second question is that suppose some authority like the income tax authority or sales tax authority is there, They are also passing the order against the CD.
But where the execution is being made,
They will start execution thereafter.
they are not. So what is the purpose of moratorium then?
Yes.
My question is exactly the same. I am saying
They
to
cannot.
them, uh,
See, you cannot initiate any proceedings, and all the proceedings which are pending before any other forum or before any other court of law will comes to a standstill position once
but
the company's applications get admitted or once CIRP applications get admitted.
Moratorium includes decree and
Sir,
orders.
Absolutely, yes.
they say
Sir,
they have a power to decide the quantum of the amount which is to be recovered by them. So they
That is
are,
different thing.
uh,
That is different thing. What amount they have derived, that is different thing. But as far as in order to execute that order,
uh,
they cannot take encumbrances, or they cannot, you can say, seize your property, or they cannot initiate the recovery proceeding if CIRP is commenced.
problem is
Whether it
that,
is
I mean, here is one more problem is that the CD is not providing a record. We are not in a position to submit anything before the authority concerned, and they are deciding ex parte judgment again, that you are not filing the reply, and the CD is not providing. We have filed the application before the court under section 19(2). Even thereafter, the order has not been passed. So in that situation, what the thing we can do? They will decide the application, they will decide their case, and the demand will be raised by them. है ना?
See, once CIRP is commenced, if you are not getting necessary cooperation from the corporate debtor,
Uh,
the promoters of the corporate debtor or erstwhile management to what we call a suspended management, in that case, the only thing which is available is to move an application before the adjudicating authority
that
and
is
to
already
take
pending.
order from the NCLT, where an NCLT will direct the income tax department or any other statutory authority not to proceed against the corporate debtor with which affect the procedure of the CIRP, which impact the CIRP process.
sir, I also have a small query, sir.
Yes, sir. Yes, sir. Sir, your
In
voice
case
is
of
breaking.
yes, sir. My question is relating to RERA. It is necessary for a project that promoters have to get completion certificate and occupancy certificate. That is the provision. But sir, in one case, what is happening without completion of the project, building construction project, there is some small area specified for shops. Say 10 shops are there. They have sold these shops already and get it registered. Now, whether commercial activity can start without getting the completion certificate and occupancy certificate?
Absolutely no.
If it does, then what remedy the IT has?
Remedy is all available in the RERA. Go section 31, invoke section 31, initiate action against the promoter, because occupancy certificate certifies that area, that shop or the apartment or the flat or a building is eligible to be worked upon, or is eligible wherein you can stay, and there is what we can say that structure or the stability of that structure is something which is certified while issuing that occupancy certificate or completion certificate. So without that, in case if this is being allotted or the position is being allotted and you are permitted to work upon that premises, then always tomorrow, in case if anything wrong happen, you will not be in a position to pray before the authorities if you will not move before the authorities at an appropriate time.
Can I move to executing authority under IBC for that?
For what reason?
Because
Here you don't have any. Here there is no there is no default as such. Default with regards to debt. There is no default per se pertaining to an
the
amount.
project is already under IBC. I am IRP, sir.
Okay.
And some other CIRP is already going on there. But
Okay.
some shops have already been sold and registered, and they have started commercial activity, and they want
So
to
in
start.
that case, how their claim even survives?
They are
If
not claiming at all. But I want that there should not be any commercial activity because it
no.
affects the.
You cannot restrain them. If prior to the commencement of the CIRP, if registry was even done, you cannot restrain them from that property because they have paid you the price. You have given allotment. You have given them possession. You have also get their conveyance deed registered, and after that, now you will be approaching the authority to get the plot or to get the premises vacated because now it is no more a property of the corporate debtor.
But when the construction is going on, untoward incident may happen because there will be crowd and it will affect the construction and marketability of the project
It
also.
will. So they are going to be remediless. This is never going to be practically possible.
But who will be responsible if some accident takes place during construction work?
You move an application. You need to move an application against the promoter before the RERA to initiate necessary actions against the promoter. But if you will say that this property should be considered as a part of the CIRP or this property should be considered as a debtor's property, then ultimately this
No,
will
no,
harm.
no.
Okay,
No,
just for
I
the
don't.
sake of this question, just for the sake of this question, that tomorrow some unexpected incident if may take place, then in that
Yes,
case, better you should move an application before the authority only. RERA,
not in NCLT.
not in NCLT.
Why?
This is
Because
not a
my
subject
concern
matter of. This dispute is not subject matter of the. This is
not
not
a
a
dispute.
subject.
Not a dispute, sir. Affects the marketability of the project because the buyers will not buy the project because there will be hurdles.
Agarwal ji,
Correct.
legal advice you
NCLT,
can take
So
separately.
if
Please,
crowd,
let's move
NCLT is
on with
not a
the.
court.
Yeah.
NCLT is not a court to give all directions. You have to approach the appropriate authorities.
When already the sold have been, when the properties have been sold, when the shops have been sold, when you have got the money, now you are concerned about that premises for which the occupation certificate or completion certificate is not issued. How
yes,
your application will make some value addition to CIRP when the
but some
project for which you, I will
but,
say the project which you are worried
but
about
how
is.
construction will be completed?
But as you said, that construction is completed and shops have already been
Not
allotted.
completed. Not complete. Project work is still going on, but shops are complete.
Shops are completed.
Project is not completed.
So for project, you can
Construction work is
always,
still going.
for project, you always have the
Nagar sir,
remedy before the RERA.
may I please say something?
Just a minute, please. Yes, sir.
Yes,
Sir,
sir.
Nagar sir, complete.
individual advice you can please take offline if
No,
possible.
it is
We
not
can.
individual advice. It is not
No.
individual advice.
Let him
Let's
clarify.
let's
Let
Let him.
Mr. Nagar clarify.
Yes.
I think since the OC has not been issued, then IRP can go to the RERA and saying that without getting the OC, the registration has been done. So for the time being,
absolutely.
the commercial activity can be stopped. You know, but
Yes.
but that cannot become the property as he has
That cannot be
clarified.
the property of the corporate debtor.
Corporate
Property will be a buyer's, no doubt about it. But it affects the construction activity. Some
I got
accident may
your,
take place.
I've got your concern, sir. I've got the entire concern. Since you have not received the occupancy certificate or completion certificate, your limited
Yes.
grievance is pertaining to the impact of the project cost or
Yes.
impact of the
Yeah.
valuation on the corporate debtor. You can
Yeah.
very well move an application before the RERA. Sir,
Yes.
even if you will approach the IBC, the honorable adjudicating authority will give you that this is out of that jurisdiction to decide what they
Yes.
are going to decide upon.
They are not full-fledged courts, giving orders on everything. Just one clarification, Mr. Nagar. The
Yes, sir.
order, the amount stated in the order issued by the Consumer Forum or the RERA becomes other debt for the RP to be considered. Is it? The stand is
Absolutely. There are varied views. Initially, it was stated by the Supreme Court that it should not be considered as a financial debt.
Yes.
Now there is a recent order which is passed by Supreme Court a week back, which has
Yeah.
stated that they will be kept in par with the other home buyers, and
Yes.
they will be treated equally as if they are the financial creditor. But
Ha.
one thing is very clear, that on the basis of that decree, they cannot move Section 7 application.
But RP will consider them as a home buyer or as other creditor.
As per the last order of Supreme Court, which was passed just a week back,
Yeah.
which was a matter which was arise out of the order passed by NCLT Mumbai bench, it
Yes.
is clearly stated that because in that resolution plan, those who have got the decree have been treated separately from other home buyers.
Yes. That is what
Right.
we have done in past.
So matter was reached to Supreme Court, and Supreme Court has recently clarified that they will be keeping in par with the other home buyers, and treatment with the decree holder shall not be have a separate treatment per se with regards to other home buyers. So
Meaning thereby they become home buyer now.
they will
They,
become a home buyer.
so once they become home buyer, they will fall in the class of financial creditors
Class of financial creditors.
because now there cannot be separate treatment.
Absolutely, yes.
The earlier judgment become redundant. This judgment becomes
Absolutely, yes,
more
sir.
effective now.
Absolutely, yes, sir.
Okay. Thank you so
Sir,
much.
what is the definition of class of creditors under IBC?
Class of creditors we will be reaching shortly, sir. That is something which is there under section 21 of the Insolvency and Bankruptcy Code. Class of creditor not only includes the home buyers or allottees, that also includes a debenture holder. They also form a specific class. Also includes the depositors. They also form a specific class. And when we see the class of allottees, the class of creditor also includes the home buyer or the allottee. So class we are going to deal under section 20 of the 21 of the Insolvency and Bankruptcy Code. So class of creditor have to separately file its claim, for which a form is prescribed. Like when we file a claim before the IRP or RP as an operational creditor, there is a prescribed form B, form C for financial creditor, but for a class of creditor, they have designated a separate form, which is form number CA, which was inserted on 3rd of July 2018. So class of creditor will not only includes the allottees or the home buyers, but that will also includes a depositor or a debenture holders.
Yeah, yeah.
Or if some individual unsecured financial creditors are there exceeding 10 number, whether they will be treated as class of creditor.
Absolutely no, sir.
Why? Where
Because
it is defined that it can be
this,
only
sir,
depositors or home
we
buyers.
we are reaching to that, sir. As we have studied a para-wise understanding of the RERA immediately after
Okay,
this
okay,
discussion, we will be reaching with the
okay,
IBC,
okay,
sir. Yes,
Just
sir.
one clarification, sir. See, recently there was a judgment by some, I think, Madhya Pradesh High Court.
Yes,
Uh,
sir.
the fault on the part of the LOT, they have not, or the orders were not passed full by the full bench, not signed by the
Absolutely.
full bench. No, this is a catch-22 situation because if there is a small default by the LOT, he has not paid some charges because the LOT sees no construction is happening, no work is happening. So how can you now RERA say that they will not accept the application because the
This
LOT
is
has also defaulted?
it was a big blunder since it was not passed by the full bench, because now whatever the remedy which the allottees have got till date from the authority will all comes to on paper. So basically this is something wherein a clarification is required.
No, I'm sorry, my two questions got mixed. The one question was that if there is a small default on the part of the LOT, he or she has not paid his charges or dues. But on the other hand, the builder is not constructing, not discharging its obligation. Now, can the RERA reject the application?
Sir, section 19 what we have studied that cast in certain obligation on the part of the allottee also. No doubt you have the remedy to claim an compensation during
But but
what
the
what
but the proportion of default will not be considered because he is a bigger defaulter. See,
absolutely. See, default with regards to the promoter and default with regards to allottee. Promoter is in default, and
yes,
promoter is in default before those allottees, those who have made a timely payment of all the charges, timely payment of all the amount which is prescribed in the agreement to sell. But suppose if there is one of the allottee who
yeah,
fails to fulfill his obligation, If that particular allottee will move before the RERA authority, then authority will first of all ask that what are the obligation on your part which has been complied upon.
No, I agree, but my submission is the allottee has not defaulted to the extent. See, suppose out of 20 installment, he has paid 18, and 2 he has not paid because he sees construction is not happening. He doesn't want to put his further money at risk.
So in that case, the one important aspect which will come is why he moved an application after that default which is caused from his side. He must have moved the application before the RERA authority prior to that default.
Okay, but you see, every individual is not that enlightened or legally equipped to take timely action.
This is one of the impact which many of the litigants used to face, and
Yes.
always the limitation law which will come and which always stuck such kind of application, because see, always the promoter is going to put his allegations also. Promoter is also going to defend such kind of application where he is having its say that what default the other side has committed, and it is up to the authority to decide.
Yes, yes. But in my limited understanding, the promoters can get away by just pointing out the small defaults on the part of the allottee, whereas
Right, sir.
his default is very big. You know.
Correct.
One question, sir.
Yes, sir.
RERA passes order for refund of money before commencement of CARP. Whether that person will be treated as unsecured financial creditor or home buyer.
If the order is passed, he will be considered as if he is just recently said, if a person is having a decree in his favor.
Yes.
If person is having a decree in his favor, in that circumstances, he will get a similar treatment as if he is a class of the financial creditor, what the other classes, that is again as a home buyer only.
He will be
But
treated as
yes,
home buyer.
you will find the separate class of home buyer even. First, you will find the home buyer, those who have cancelled the agreement to sell, and those who are willing to claim just the amount which they have paid and interest thereon. Second, you will find the nature of home buyer who have paid the application money but allotment is not done. You will also find the home buyer who have paid application money, allotment is done, but possession is not received. And you will also find the home buyer who have paid application money, allotment is received, possession is received, but registration is not done. Here in this case,
But there is a clear distinction, either unsecured financial creditor or home buyer. What is he?
unsecured financial creditor.
Okay.
By decree, he will not get any status of secured financial creditor in any circumstances. And when the allotment is already taken place, then it is altogether a different case. Here in this case, he will be treated as an unsecured financial creditor. But whatever
Not
may be
a home buyer.
no, but whatever may be, yes, sir.
Not a home buyer. He will be unsecured financial creditor only.
Unsecured financial creditor.
Okay.
Now, as far as the code is concerned, let me.
Sir, I want to ask one more question.
Yes, sir. Yes, sir.
My question is that if suppose the agreement has been done by the promoter with the home buyer, who has applied for taking the houses, number of the houses from the promoter, but the flat was not allotted to him, only the agreement was done. So he will be treated as a home buyer or not?
He will be treated as a home buyer only.
He will be treated as home buyer only.
Yes, sir. Is this file visible?
Yes, sir, visible.
Now, when you see the first amendment which has taken place, and that was on 6th of June 2018, and that is there under section 5 subsection 8 clause F. Supreme Court has ironed out the creases with regards to its constitutional validity. But yes, this is section 5 subsection 8 subclause F, leading to which the home buyers have been classified as a financial creditor. Not so secured, but they have been classified in par with the bank and financial institution in terms of the nature of debt, and that is the financial debt. This is the definition of financial creditor, and this is the definition of financial debt under subsection 8 of section 5, which talks about any amount which is raised under any other transaction, including forward sell or purchase agreement. So if the amount is raised under any other transaction, including forward sell or a purchase agreement having commercial effect of borrowing, an explanation was also inserted to this, and that was on 6th of June 2018, which talks about the amount raised from an allottee. The definition of allottee will derive its meaning from the RERA only. That is section 2 clause D. The amount raised under any transaction, including forward sell or purchase agreement having commercial effect of borrowing, and any amount. So explanation talks about amount raised from an allottee under a real estate project shall deem to be an amount having commercial effect of borrowing. So if I'm the promoter or I'm the real estate entity and I've accepted an amount from an allottee or from the person who booked the apartment or a flat or a building, then whatever amount which I have received shall be considered as if it is having a commercial effect of borrowing, whereas I shall be under an obligation to hand over the possession in within a given timeliness, the timeliness which I have already mentioned while getting my project registered. So this is 2018 amendment which talks about the amount raised under any transaction, including forward sell or forward purchase agreement, and having the commercial effect of borrowing. This explanation was added that amount raised from allottee under a real estate project shall deem to be an amount having commercial effect of borrowing, and in this particular phase the allottee and real estate project shall derive its meaning from RERA. The another change which has taken place after this, because during this phase I have seen 2018 2019 multiple home buyer in their own individual capacity, they have started moving an application before the adjudicating authority to initiate CIRP. And that's why the lobby of the real estate or the promoters of the real estate company, they moved before the Supreme Court, and thereafter a further amendment which has taken place on 26th of December 2019, 28th December 2019, that it has come up with certain threshold limit, and threshold limit is there in section 7, we can find in second proviso. So recently there was a question pertaining to the class of creditors, and we are going to discuss the same in section 21. So first of all, provided that for the financial creditor referred to in clause A and clause B of section 21 subsection 6A, an application for initiation of CIRP against the corporate debtor shall be filed jointly by not less than 100 of the creditors in the same class, or not less than 10% of the total number of such creditor in the same class, whichever is less. It is now pertaining to, as I said, debenture holders or depositors, provided that for the financial creditors referred to in clause A and clause B of subsection 6A of 21, we will be dealing into this. An application for initiation of CIRP against a corporate debtor shall be filed jointly, not less than 100 of such creditors in the same class, or 10% of the total number of creditor in the same class, whichever is less. In the Companies Act, there is a provision under section 71 which talks about issue of debentures. Under the Companies Act, there is a provision under section 73 to 76 which talks about depositors. And in such circumstances, when they form a separate class of the creditor, such an application can be made only jointly, and such an application has to be made by at least 100 of such creditors in the class, or 1/10 of the creditors, total number of creditor in the same class, whichever is less. Now, here it comes the home buyers, this allottees. Provided further that for the financial creditors who are the allottees under the real estate project, and here they will be classified in a project wise, a tower wise, where the financial creditors who are allottees under the real estate project, an application for initiating CIRP against the CD shall be filed jointly by not less than 100 of such allottees under the same real estate project, 100 of such allottees under the same real estate project, or not less than 10% of the total number of such allottees under the same real estate project, whichever is less. So this was inserted on 28th of December 2019. This is something which was quite important, because after inclusion of section 5 subsection 8 clause F, that even a allottee will be treated as a financial creditor, and whatever amount which is due to an allottee, or whatever amount which the real estate company has accepted from the allottee, that amount shall form a part of the financial debt. There are multiple home buyers who moved an application to initiate CIRP, and the real estate owner ended up settling with such kind of application. But thereupon, the amendment has taken place that if the application is not in compliance with this sub proviso 2, then this application has to be complied with the requirement of subsection 2 within 30 days. Otherwise, such applications got dismissed as withdrawn. Where the financial creditor, who are the allottees under the real estate project, an application for initiation of CIRP or initiating CIRP against the corporate debtor shall be filed jointly by not less than 100 of such allottees under the same real estate project, or 1/10 of the total number of allottees under the same real estate project, whichever is less. And this is what you will find: where an application for initiating CIRP process against the CD has been filed by a financial creditor to in first and second provisos, and has not been admitted by adjudicating authority before the commencement of Insolvency and Bankruptcy Amendment Act 2020, such application shall be modified to comply with the requirement of first or second proviso within 30 days of the commencement of the said act. Failing which, such application shall deem to be withdrawn before its admission. So this was something which has amended the IBC to a certain extent in the interest of the real estate entities, keeping the right of the financial creditor, keeping the right of the home buyers or allottees intact. But the only difference was, a single home buyer cannot move such application, a single debenture holder cannot move such application, or single depositor cannot move such application. And if such application is required to be made, it has to be in compliance with first proviso or second proviso of section 7 subsection 1, which talks about, in case of allottee, at least 100 of allottees under the same real estate project, or 1/10 of the total number of such allottees under the same real estate project, whichever is less. This was one of the amendment. And thereafter, going through section 21, wherein we are going to deal with the class. This is section 21. This is section 21, which talks about committee of creditor, and this is section 6A. Section 21, subsection 6A. And here the query pertaining to the class of creditor will get resolved. Where a financial debt is in the form of securities, like a debentures, as I said, or a deposit, and the terms of the financial debt provided for the appointment of trustee. In debenture, we have a debenture trustee. In deposit, we have a deposit trustee to act as the authorized representative for all such financial creditor. Then such trustee or agent shall act on behalf of such financial creditors. You can see subsection 6A clause A, where a financial debt is in the form of securities or deposits, and terms of the financial debt provided for example, if the company has issued debenture, and there was a debenture trustee, and there was an agreement with the debenture trustee, which is known as debenture trust deed, or company has accepted deposit, and there was a trustee known as deposit trustee, then in that case, that trustee or agent shall act as the authorized representative for all such financial creditor, and such trustee or agent shall act on behalf of such financial creditor. That is one thing. Second, if the financial debt is owed to a class of creditor exceeding the number as may be specified, other than the creditor as covered under clause A or subsection 6, the interim resolution professional shall make an application to adjudicating authority along with the list of all the financial creditor containing the name of IP other than IRP to act as their authorized representative, who shall be appointed by the adjudicating authority prior to first meeting of the committee of creditors. So this is the another class owed to a class of creditor exceeding the number as may be specified, and we will be dealing with the same in regulations. As far as the remuneration part is concerned, the remuneration will be paid as per the debenture trust deed or deposit trust deed if there is any trust deed which is subsisting. If no such case is there, and if it is a case of a class of creditor which is there in clause B, then under clause B of subsection 6A shall be specified which shall be form a part of the insolvency resolution process cost. So we will be dealing into the same in regulation. Also, there is section 24, which talks about all the meeting of the committee of creditor shall be conducted by the resolution professional. The resolution professional shall give notice of each meeting of the committee of creditor to the members of the committee of creditor, including authorized representative. So, members of the committee of creditor, including authorized representative, referred to in subsection 6 and 6A of 21, provided that absence of any such director or partner or representative of the OC, as the case may be, shall not invalidate the meeting anyways. But 25A is quite relevant. The authorized representative under subsection 6 or subsection 6A of section 21 or subsection 5 of 21(4) shall have right to participate and vote in the meeting of the COC on behalf of the financial creditor he represent in accordance with prior voting instruction of such creditor obtained through physical or electronic means. Basically, authorized representative is having a very limited role to play, and his limited role is just to represent the class of creditor before the committee of creditor, not even representation before the adjudicating authority. Mark my words. It shall be the
Sir,
duty of the. Yes, sir.
should I interrupt for a moment, sir?
Sir, can we complete this and thereafter we will be reaching
Okay.
to that discussion?
Okay.
Because 25A is the only section in the IBC which is going to deal with the topic. Otherwise,
Okay.
yes, sir. So I will be dealing with your question immediately thereafter. Section 25A, the authorized representative under subsection 6 or subsection 6A of section 21 or subsection 5 of section 24 shall have right to participate and vote at the meeting of the committee of creditor on behalf of the financial creditor he represent in accordance with the prior voting instruction of such creditor obtained through physical or electronic means. It shall be the duty of the authorized representative to circulate the agendas and minutes of the meeting of the committee of creditor to the financial creditor he represents. So this also includes the consortium finance. So in case of consortium finance also, there is a concept of the authorized representative, but whatever may be the fees payable to the insolvency professional who is representing or the authorized representative who is representing the bank, that shall not form a part of the CIRP cost. Only the fee which is payable to the authorized representative of the class of creditor, which are the home buyer, they will be the amount shall form a part of the CIRP cost. The authorized representative shall not act against the interest of the financial creditors he represent and shall always act in accordance with their prior instruction. If the authorized representative represents several financial creditor, then he shall cast his vote in respect of each financial creditor in accordance with the voting instruction received from each financial creditor to the extent of his voting shares. Provided further that if any financial creditor does not give any prior instruction through physical or electronic means, the authorized representative shall abstain from voting on behalf of such creditor. This is important as far as 25A subsection 3A, notwithstanding anything to the contrary contained in subsection 3, the authorized representative under subsection 6A of 21, that is the class of creditor we are dealing with. The authorized representative under subsection 6A of 21 shall cast his vote on behalf of all the financial creditor he represent in accordance with the decision taken by the vote of more than 50% of the voting shares of the financial creditor he represent who have cast their vote. So basically, this is something which is very important, that being the authorized representative, he is not only confined to remain present in the COC, but also there is a provision with regards to the meeting of the class of creditors. Again, I would like to read this. Section 25A, subsection 3A, notwithstanding anything to the contrary contained in subsection 3, the authorized representative, because subsection 3 talks about the representative shall not act against the interest of the financial creditor he represent and shall always act in accordance with their prior instruction. If the authorized representative represents several financial creditor, then he shall cast his vote in respect of each financial creditor in accordance with the instruction received from each financial creditor to the extent of his voting share. And suppose if any of the financial creditor has not given a prior instruction, then authorized representative shall abstain from voting. But now when it comes to the matter of class of debenture holders or depositors or allottees, home buyers, then notwithstanding anything to the contrary contained in subsection 3, the authorized representative under subsection 6A of section 21 shall cast his vote on behalf of all the financial creditor he represent in accordance with the decision taken by voting of more than 50% of the voting share of the financial creditor he represent who have a cast their vote, meaning thereby there is a binding obligation on the part of the authorized representative and other dissenting financial creditor within that class itself to vote to pass a resolution in accordance with the majority decision which is taken by that creditors in the class meeting. But this is something which is also provided in 12A cases, which talks about withdrawal of application. Provided that for a vote to be cast in respect of an application under section 12A, the authorized representative shall cast his vote in accordance with the provision of subsection 3. Subsection 4 talks about the authorized representative shall file with the committee of creditor any instruction received by the way of physical or electronic means from financial creditor he represent for voting in accordance therewith to ensure that the appropriate voting instruction of the financial creditor he represent is correctly recorded by the interim resolution professional or resolution professional as the case may be. So as far as the voting is concerned, there is a divergent views as far as subsection 3 and 3A is concerned. If I'm just a representative of Bank of India and you are representing ICICI in one of the consortium finance, then in that case, the authorized representative shall not act against the interest of the financial creditor is representing. But if I'm the representative of the class of home buyers, or I'm the representative of the debenture holders or depositors, then in that case, notwithstanding anything to the contrary in subsection 3, the AR under subsection 6A of section 21 shall cast his vote on behalf of all the financial creditor he represent in accordance with the decision taken by the vote of more than 50% of the voting shares of the financial creditor he represent who have cast their vote. So this is something which is there up to the court. Now, when you see the regulation, and then we will be moving to the discussion. So there is regulation 4A. When you say regulation 4A, is my screen visible? I hope my screen is visible to all of you.
Yes, sir. Yes, sir.
So when you see
Visible, sir.
4A, that cast an obligation upon the IRP. So being an IRP, there is an obligation on my part that I should give a public announcement within 3 days from the commencement of CIRP. And out of the records which are available with me pertaining to the corporate debtor, and even otherwise, if I'm dealing with, or if I'm the insolvency professional acting as an IRP of a real estate company, then always there is a possibility that this class of creditor will be one of the major claimants as far as the CIRP is concerned. So in such circumstances, on examination of the books of accounts, this is regulation 4A of IBBI insolvency resolution process for a corporate persons regulation 16. On examination of the books of accounts and other relevant records of the corporate debtor, the interim resolution professional shall ascertain the class of creditor, if any, for representation of the creditor in class ascertained under subregulation 1 in the committee. The interim resolution professional shall identify 3 IPs who are not his relatives or related party, having their addresses registered with the IBBI in the state or union territory as the case may be, which has highest number of the creditor in that class as per their address in the records of the corporate debtor. And provided where the state or union territory does not have the adequate number of the IP having address in nearby state or UT as the case may be shall be considered. So I will name 3 insolvency professional, and this insolvency professional will be the one to whom the allottee, while submitting its claim, will select his choice. Eligible to act as a RP, willing to act as the authorized representative, like when we give form number 2 to act as an IRP. Similarly, there is form number AA to act as an RP, and similarly there is form number AB for seeking their consent. So this is provided in regulation 4A sub-regulation 3. The interim resolution professional shall obtain the consent of each IP identified under sub-regulation 2 to act as the authorized representative of class in form number AB. So this is one of the precondition when you give a public announcement in form number A, and if you have identified that this company is having a class of creditors, then you are supposed to give the name of 3 insolvency professional, so that while those class of creditor will submit their claim, they have to identify their choice of their authorized representative, and the authorized representative who have got the highest number of vote will be the person appointed by the adjudicating authority, and that person shall represent the class of creditor. This is regulation 6, which talks about a public announcement, and we are aware of this, that public announcement immediately after my appointment, but not later than 3 days. This public announcement should be in form A, published in English and a vernacular language, published on the website of the corporate debtor and website of the board. But this is important. In the public announcement, the IRP will offer choice of 3 IPs identified under regulation 4A to act as the authorized representative of creditors in each class. This is the requirement. And when you see form number CA, this is something which is brought in with effect from 3rd July 2018. This is the claim by creditors in class. A person claiming to be a creditor in a class shall submit claim with proof to the IRP in form CA, which is there in Schedule 1. The existence of debt due to a creditor in class may be proved on the basis of records with IU or relevant document including agreement for sale. You can able to identify that which nature of or which class of creditor we are talking about. Agreement for sale, letter of allotment, payment receipt, or such other document evidencing the existence of debt. A creditor in class may indicate its choice of the IP from amongst the 3 choices provided by the interim resolution professional in public announcement to act as its authorized representative. So when you are submitting your claim as a class of creditor, always you have to substantiate your claim by the way of agreement to sell, which is there we have studied in RERA, or if the allotment has taken place, then later of allotment, if you have made the payment through payment receipt. And while submitting your claim, you have to submit your claim within 14 days. If not within 14 days, you can still submit within 90 days of the commencement of CIRP. And when I will be submitting my claim, I have to indicate my choice of IP amongst the 3 choices provided by the IRP, which is there in the public announcement, which was published in form number A. So this is regulation 8A. Now we can deal with your part, your point. Yes, sir. What was your point? Anyways, we can deal with regulation 16A, which talks about certain fee structure. The interim resolution professional shall select the insolvency professional who is the choice of highest number of the financial creditor in the class in form CA received under sub-regulation 1 of regulation 12 to act as the authorized representative of the creditors of the respective class, provided that the choice of the choice for an insolvency professional to act as the authorized representative in Form CA received under sub-regulation 2 of regulation 12 shall not be considered. So 12.2 talks about when you file a belated claim. Ultimately, when you will be filing your claim within 14 days, then only your choice will be considered and not belatedly. So this is what regulation 16A subregulation 1 talks about, that IRP shall select the IP who is the choice of highest number of the financial creditor in the class in Form CA received under sub-regulation 1 of regulation 12 to act as the authorized representative of the creditors of the respective class. But suppose if you fail to put your claim within 14 days, still regulation 12.2 permits you to put your claim belatedly within 90 days, which is recently amended, that the choice of for an insolvency professional to act as the representative in Form CA received under sub-regulation 2 of regulation 12 shall not be considered, because by that time already your representative could have been appointed. The interim resolution professional shall apply to the adjudicating authority for appointment of the authorized representative selected under sub-regulation 1 within 2 days of the verification of claim. So the journey is, once CIRP commences, within 3 days, IRP has to give a public announcement. Thereafter, within 14 days, one has to submit its claim. After submission of the claim, within 7 days, the IRP has to verify the claim. And after this 21 days, within 2 days, the committee of creditor once constituted will be submitted to the adjudicating authority. So the point is, the interim resolution professional shall apply to NCLT for appointment of the authorized representative selected under sub-regulation 1 within 2 days of the verification of claim received under sub-regulation 1 of regulation 12. Any delay in appointment of the authorized representative for any class of creditor shall not affect the validity of decision taken by the committee. So this is again very important. If there is a delay caused in appointment of the AR for any class of creditor, such a delay shall not affect the validity of the decisions which are taken by the committee of creditors. The financial creditor in class representing not less than 10% voting share may seek replacement of the authorized representative with insolvency professional of their choice by making a request to the IRP or RP, as the case may be, who shall circulate such request to the creditor in that class and announce a voting window open for at least 24 hours. So they also have a right to replace their representative. The resolution professional shall apply to adjudicating authority for the appointment of the authorized representative who receive the highest percentage of the voting share of the finance. This is quite general, but this is the fee structure. The authorized representative of the creditors in a class shall be entitled to receive fees for every meeting of the COC attended by him in following manner. So if the number of creditors in class is up to 100, 10 or more than 10 up to 100, 30,000 per COC meeting. 101 to 1000, 40,000, more than 1000 is 50,000. So this is a part of the CIRP cost. See, if the debenture trustee is the representative of debenture holder, that shall not form part of the CIRP cost. Deposit trustee is a part of the representative of the depositor, that shall not form a part of the CIRP cost. Similarly, if you are representing IDBI bank or SBI bank, that shall not form part of the CIRP cost. That expenses will be borne out of by the bank only. But when you are representing a class of creditors, this is particularly with this. In that circumstances, the authorized representative of the creditors in class shall be entitled to receive fees for every meeting of the committee attended by him in following manner. So if it is up to 10 to 100, 30,000, 101 to 1,000, 40,000, more than 1,000, 50,000. And as far as this is with regards to COC meeting, and with regards to the meeting of the class of creditor, the authorized representative shall be entitled to receive the fees for every meeting of the class of creditor convened by him in following manner. So 10 to 100, 10,000, 101 to 1,000, it is 12,000, more than 1,000, 15,000. So this is pertaining to the meeting of the class of creditor, and that is pertaining to the meeting of the COC. The payment of fees to the authorized representative shall form a part of the CIRP cost in respect of two meeting with the creditor he represent corresponding to the meeting of the creditors. The fees for any additional meeting beyond 2 meeting corresponding to a meeting of the committee shall be form a part of this. So this is something where I would like to, I will not go much beyond this, but yes, we'll say one thing as far as the home buyers are concerned or the allottees are concerned. They, after being categorized as a financial creditor, after being categorized as a financial creditor, though not considered as a secured financial creditor, but have got a seat in the COC through the authorized representative. Yes, I would like to have a discussion upon with regards to this phase of the IBC, and then we will be dealing with pioneer judgment, or we will be dealing with certain more judgments which are relevant for our discussion.
But some persons has deposited some FDR with the company, and authorized representative has been appointed by the court. So for that authorized representative who has been representing to the FDR holders will also get the fee.
See, if the company has accepted fixed deposits,
Ah,
if company has accepted fixed deposit and there are the depositors in the company, if there is a provision of any deposit trustee or some deposit trust deed is in existence, in that case that trustee will be considered as a representative, and the fees payable to trustee shall form a part of not a CIRP cost, and that will be incurred in a manner as provided in the deposit trust deed and not as per the slab which is provided therein.
suppose karo he has been appointed by the court as a authorized representative.
Then he
And
will be
he-
considered. If it is
then-
if he's appointed by the court, then always whatever is the amount payable to him as a part of the fees, it shall form a part of the CIRP cost then.
Suppose there's a home buyer is there, and suppose the 100 home buyers in a company, and they have been claim has been admitted. And now voting has started. The vote is to be given by them. Only the 5% is giving the voting. Only the 5% is are giving the voting. In favor of the resolution, 3 home buyers is giving the voting, and 2% are giving against the particular resolution. Then the resolution will be treated as a passed.
See, basically what happens here, the important aspect is, first of all, those who have attended the meeting, right?
Will only the vote.
Yes. So basically, whosoever have attended the meeting of that class of creditor, whatever resolution is passed by more than 50% of the voting share stakeholders, that will be the reason which the representative is going to pass in the COC meeting. And the
Suppose,
dissenting,
my question is that suppose the 100 home buyers is in the company.
in
They have
numbers, they
filed
are 100.
100, but the voting is only given by the 10%,
Okay.
and the resolution is passed by the 10%. है ना?
So basically, you mean to say there are 100 number of the home buyers in the
Voting is
meeting
only.
only. In the meeting, only 10 were present, and
Ah,
all 10 have passed the resolution in favor of the plan.
ah.
Okay.
Then the resolution will be treated as a pass or not?
As it will be treated as if it is passed.
Uh,
Unlike the scene in COC,
Unlike the.
unlike the modus what we have in the COC. In the COC, we used to say that those who are present must be having at least 66% of the voting shares.
No, they are not the 66%. 10% is there.
No, sir,
And-
I'm talking about the COC meetings. I'm not
no,
talking about
No,
the
the
class
voting
meeting.
is based on present and voting. It is based on
Correct.
present and voting system.
Pardon, sir?
Okay.
That counting of the 66% is what they are discussing, sir. Present and voting का बारे में बोल रहे हैं. Anyway, it is subject to discussion always.
Are we talking about the COC meeting or a class meeting? For a class meeting, I will say present and voting.
For COC meeting, what about it, sir? The denominator should have 100%.
See, as far as in the COC meeting, I must say that as far as the COC meetings are concerned, it's always the one who holds 66% voting share, whether they forms a majority in that meeting or not.
Sir, absent people?
They will be considered as if they remain abstain from the voting. Now, suppose if those who were not present in that meeting, they themselves own more than 66% voting share. In that case, one cannot say that those who remain present, the voting percentage will be calculated out of those who remain present only.
But again, sir, continuously they don't participate and they don't vote. Then how does it happen, sir?
Ultimately, what happen in such circumstances, if the COC is constituted with few of its member, collectively they are owning 100% of the voting share, and majority of the, generally it never happens, because the one who holds the majority stake always dominate the CIRP process up to the date of approval of the resolution plan. But suppose if they are not participating, always the one who are participating will be moving before the adjudicating authority to decide upon such situation under 60 subsection 5.
सर मेरा क्वेश्चन ये है, सपोज करो एक कमेटी के अंदर होम बायर्स का स्टेक 80% है और 20% फाइनेंशियल क्रिएटर्स है.
ओके,
अब 80% में से मान लीजिए 200 आदमी है, उसमें से मान लीजिए 20 ही आदमी वोट करते हैं.
हाँ, तो वहां पे सर मैंने कहा कि दोज हु रिमेन इन प्रेजेंट एंड दोज हु हैव वोटेड, like in case what we have in general meeting, the shareholders meeting, when a company is going concern, disregarding the total number of the shareholder and the voting percentage, we used to consider the voting of those who remain present and those who have voted, and not those who have remain abstained or those who are not those who are not. So basically we are going to consider the vote of only those particular stakeholder, those who have participated in the voting and those who have voted.
So through AR, any which ways, 80% are present and voting. So obviously it will be passed, sir, as
Absolutely.
the AR is deciding.
No doubt, no doubt.
And this is the last thing which I wanted to just have with you. Is this visible?
Yes, sir.
Yes, sir,
It is
visible.
visible.
It is visible, sir. It is visible.
Now disappeared. Yes.
Yes, sir. When you see this, this is just a small presentation with regards to whatever has been discussed. But I would like to focus upon some important aspect. So this was the initiation of the CIRP against JP Infratech Limited, which has brought the concern whether the home buyer should be categorized as a separate class or whether they should be termed and treated as a financial creditor or not. So it was the initiation of the CIRP against the JP Infratech Limited, brought to fore the issue of treatment of the home buyers under the Insolvency and Bankruptcy Code. Immediately after the insolvency petition was admitted before the NCLT Allahabad bench, a PIL was filed before the Supreme Court seeking relief for the home buyers. The Supreme Court initially granted a stay on the order of the NCLT, but while lifting the stay, the court has directed that the resolution plan should contain necessary provision to protect the interest of the home buyer. Also directed Prakash Limited, which is its holding company, to deposit 2,000 crore with the court. So that was the journey from where it began. The ambiguity on the classification of home buyer as a financial or operational creditor pointed out in the JP case prompted the IBBI to amend the Insolvency Bankruptcy Board resolution process for corporate persons to introduce the concept of other class of creditor. That is what we were dealing with. That was 3rd of July 2018 when form number CA was introduced. Other creditors who are not entitled to initiate CIRP, but yes, they can file as a separate class of creditor. November 2017, the Insolvency Law Committee was constituted with the mandate of making recommendations on issue arising from the implementation of the IBC. One of the key recommendations of the committee was that in order to enable home buyers to participate equitably in CIRP, they should be treated as a financial creditor owing to the unique nature of the financing in real estate projects. So this was 6th June 2018 when IBC Amendment Ordinance 2018 to amend the IBC pursuant to the ordinance, amount raised from the home buyers have been brought within the purview of financial debt. Home buyers as an operational creditor. So there was a great quantum of the ambiguity pertaining to their class. Home buyers as an operational creditor. NCLT principal bench in Vinod Avasthi case versus AMR infrastructure, while considering the case whether the applicant home buyer would be an operational creditor of the respondent company, the NCLT has observed that the operational debt may arise out of the provision of goods or services, or arising out of the employment or dues under any other law payable to government. In case an assured return was payable, this is something from where they have been classified as a financial creditor. In the case an assured return was payable every month by the respondent to the applicant till the date of possession of the flat, which the respondent failed to pay, the NCLT observed that in the instant case, the debt had not arisen out of any of the aforesaid category. Neither it is arising out of the supply of goods or services, or arising out of the employment or any due payable to the government. And that's why to consider it as an operational debt would not be suffice. In this regard, it may be noted that the operational debt is defined as a claim in respect of the provision of goods and services, since the phrase used in the definition is in respect of as opposed to for. It can be interpreted to mean that claim can be either by a provider of a goods or services or by receiver of a goods or services. In New Power Renewable Private Limited and Cap Infrastructure Private Limited, Chennai bench of NCLT observed that the operational debt should be given a purposive and contextual interpretation. In this case, the corporate debtor had received an advance from the petitioner for rendering services in respect of setting up of a wind power project, but had failed to perform the services and agreed to refund the advance amount. NCLT observed that the petitioner had advanced money to the corporate debtor for providing services, construction services, civil services, and held that the petitioner falls within the meaning of operational creditor. Also, it was stated the operational debt is interpreted as aforesaid the home buyer who have claimed for refund of the amount paid towards an under construction unit to be said as operational creditor. So that was the ambiguity. Also, one more thing, another argument which was not made in the aforesaid case was that the flat would be treated as a stock in trade in the books of the builder, and thus the amount payable in respect of the same may be treated as an operational debt. So that was a kind of argument. Home buyer as a financial creditor in case where the contract is between the home buyer and developer, provided for payment of assured return to the home buyer until handling over the possession of the unit. It has been held that the amount disbursed by the home buyer was against the consideration for the time value of money, and that the corporate debtor had raised the amount by the way of sell purchase agreement having a commercial effect of borrowing. In some of these cases, the annual return filed by the corporate debtor, the amounts so raised from the home buyer were shown as a financial cost, and these cases the home buyers were held to be the financial creditor. This amendment we are aware of. They have been classified. The amount is classified as a financial debt. They have been considered as a financial creditor, and this was the Nikhil Mehta's case. The reason in the Nikhil Mehta's case gained the legislative recognition while the IBC Amendment Ordinance 2018. Through this ordinance, the home buyers were deemed to be the financial creditor under IBC. It was further clarified that the current definition of financial debt is sufficient to include the amount raised from home buyer or allottee under the real estate project, and hence they will be treated as a financial creditor. And Supreme Court has cleared the air. The constitutional validity of this amendment, though it was challenged before the Supreme Court, but in Pioneer Urban Land and Infrastructure versus Union of India, it was clarified by the Supreme Court that home buyers do have remedies under various other statute. But yes, Section 88, which we have studied, the 88 of the RERA is in addition to and not in derogation of remedy available under other law. The three bench headed by Honorable Justice Rohinton Nariman disposed of the batch of 150 petition filed by the real estate developer challenging the constitutional validity of the amendment. The Supreme Court held that the RERA has to be read harmoniously with IBC. In event of conflict, the IBC shall prevail. After analyzing the submission made by both the parties, the Supreme Court held in the Pioneer Urban case that the money raised by developer from the home buyer is done with a profit making motive, and therefore it was held that it has the commercial effect of borrowing, and hence it is to be included within the definition of financial debt. Supreme Court in Pioneer Urban Land and Infrastructure Limited and Union of India has upheld the constitutional validity of the IBC Second Amendment. Through the amendment, the real estate allottees, home buyers, however, brought in within the ambit of the financial creditor under the IBC, an amount accepted by the company from such home buyer have got the position in the financial debt. But again, there was a further challenge, and the challenge was made with regards to, so there was two tests which, or three tests which the Supreme Court have decided: real estate developer vis-a-vis operational debt in comparison to the general cases wherein the person who supply goods or services the creditor, and in real estate contract the developer who is supplier of the flats or apartment in fact the debtor, in much as the home buyer find its own apartment. So this is something which is important in comparison to the general cases wherein the person who supply goods or services is the creditor. In real estate contract, the developer who is the supplier of flat or apartment is in fact the debtor, in as much as the home buyer have find its own apartment by the way of advance payment. So this is one of the difference. We used to say that if we are the supplier or if we are a service provider, then we are the creditor. But in the real estate contract, the developer who is the supplier of flat or apartment is in fact a debtor to that home buyer who fund his own apartment by the way of advance payment. Interest oblique stake of the operational creditor in corporate debtor, unlike the case of the home buyer who is vitally concerned with the financial health of the corporate debtor, for otherwise the real estate project may not be brought fruition. And operational creditor do not have any interest in the stake in the corporate debtor. Time value of money. In real estate project, the money is raised from the home buyer against the consideration for time value of money. Both the home buyer and the developer gain and benefit from the time value of money, even though the payment may be made in installment. On the other hand, in an operational debt, there is no consideration for time value of money, since the consideration of debt is the value of the goods or services either sold or availed from the operational. So this is what the Supreme Court has decided, and then it was concluded that the constitutional validity was upheld. Documentary evidence for the due amount. So, unlike in case of an operational debt, the documentary evidence for the amount being due and payable by the real estate developer is available in form of the information being provided compulsory under RERA. So, two-step scrutiny. If any application is made by the allottee, then establishment of prima facie case under Section 7 is on the allottee first of all. In terms of Section 4 of the RERA, every developer or promoter is required to submit all the important information related to real estate project to the RERA authority. Armed with this information, the home buyer can approach tribunal to trigger CIRP and needs to at least make a prima facie establish that the default exists in relation to amount due and payable to the home buyer. So out of the information which is available with the RERA authority in a public domain, I have to demonstrate and I have to showcase that how the real estate promoter or the real estate company or the developer has committed a default, and then the onus will shift to the developer to contest or to rebut that application. So once the home buyer made a prima facie case, the onus will shift to the promoter and real estate developer to show on the basis of the agreement that the applicable RERA rules regulation, the home buyer is himself a defaulter and would therefore not be entitled to any relief, including payment of compensation or refund, which will then entail a dismissal of the application under 7 of the IBC. So basically, in Supreme Court in Urban Pioneer case, Supreme Court has identified certain things. These are quite relevant. Insolvency Law Committee has found as a matter of fact that delay in completion of the flats or apartments has become a common phenomena, and that the amount raised from the home buyers contributes significantly to the construction of such flats and apartments. It was important, therefore, to clarify that home buyer are treated as a financial creditor so that they can trigger the court. Second, it is difficult to accept the argument that RERA is special enactment which deals with the real estate development project and must therefore be given a precedence over the code, which is only a general enactment. At the time of introduction of the explanation to 5F, the Parliament was aware of the RERA and applied some of the definition to the code. The RERA is in addition to and not derogation to other law. That is what we studied. The process of harmonious construction of RERA and the code must be the RERA and code can be coexist, and in event of clash, the RERA must give way to the code. RERA therefore cannot be held to be a special statute, which in the case of conflict would override the general statute. So IBC will prevail. The code is meant to be a proceeding in RAM. This is very important, which I was again and again trying to demonstrate, that code is meant to be a proceeding in RAM. So once a allotee moves an application before the tribunal and once the applications get admitted, it is a proceeding in RAM, which after being triggered goes completely outside the control of the allotee who has triggered that. Thus, any allotee or home buyer who prefer an application under 7 of the code take the risk of his apartment not being completed in the near future. If the petition is admitted under the code, the allotee may never get refund of the entire principal, let alone the interest on account of the elaborate insolvency process. On the other hand, if such allotee were to approach under RERA, it is more likely that the project would be completed early or full amount of the refund and interest with compensation or penalty will be awarded. So you should be very vigilant enough before you move an application. You need to see the financial health of that real estate developer. Only an allotee who has completely lost a faith in the management of the real estate developer would come before the NCLT under the code. When a person supplies goods and services, such person is a creditor, and a person who has to pay for the goods and services is a debtor. But in real estate developer, the developer who is the supplier of the apartment is a debtor in much as the home buyer allotee fund its own apartment. That is what we studied. In real estate project, the money raised from allotee is being raised as a consideration for the time value. The fact that the allotee makes such payment in installment, which are coterminous with the phase of completion of the real estate project, does not have any less make such as. So this is just the observation of the Supreme Court in the Pioneer Land Judgment. Based on the fundamental differences between the real estate developer and supplier of goods and services, the legislature has focused upon and included the real estate developer as a financial creditor. Included the real estate developer, it should be included the allotee as a financial creditor. Home buyer allotee can be assembled with the individual creditor like debenture holder or fixed deposit holder who have advanced certain amount to the CD. Given the fact that the allotee may be entitled to claim the compensation in event of the breach of agreement with the developer, the allotee gets a right to have the seat on the COC. The information published in the website of the RERA can be the basis of establishing a default relating to the amount due from developer. It is also open for the developer to point out that this is very important. Also open for a developer to point out that the allotee is a speculative investor and not a person who is genuinely interested in the property. The contention that wholly one-sided and futile. So basically, this is up to the developer which has to prove. Otherwise, in IBC, whether you are a speculative investor or not, you all will be classified under the blanket definition of a financial creditor. 2019 ordinance, as I said, that now single person cannot move an application, and that's why there was an amendment which has taken place that at least 10% or 100 of the total home buyers of that project who can move an application. 2020 amendment. The important is Supra Tech, which I would like to begin with. This is something I was waiting to have a discussion with. Project-wise insolvency or a tower-wise insolvency. And this is quite natural because when a real estate company goes in CIRP, there are multiple projects which are running across the country. Every project do have its own creditor. Every project do have its own stakeholder. And right, just because of a default pertaining to one project has taken place, that should not give a right to other creditor to submit its claim with regards to a default in a particular project. So supratech insolvency is something which one has to study about, because when we see supratech insolvency, there is nothing which is there in the code itself which empower NCLAT to permit such kind of practice. But again, you will find in Supratech there is a provision of the reverse CIRP. The recent decision of the NCLAT in the matter of Ram Kishore Arora versus Union Bank of India and other concerning bankruptcy of Supratech Limited has once again erupted the issue of inclusion of reverse CIRP for real estate companies under the Insolvency and Bankruptcy Code. As provided under IBC, the object of the CIRP is to maximize the asset available. However, in the real estate cases, to protect the interest of home buyer, only the particular project of a builder is subject to the insolvency process by adjudicating authority, and rest is kept outside the scope of CIRP. The same being regarded as a reverse CIRP. So basically, your insolvency process shall confine to a particular tower. Your insolvency process shall confine to that particular project in response to which a default has taken place or pertaining to which a default has taken place. Recently, Supratech was declared bankrupt by NCLT on application filed by Union Bank for a default of 432 CR. However, the NCLT granted some relief to Supratech. Favored project-wise insolvency, the committee of creditor would be constituted only for the disputed project, that is Eco Village 2, which is there in the Greater Noida, and would be under the insolvency process, while remaining project would be constructed by the promoter as a going concern. So this is quite opposite to what we see in CIRP, because when CIRP start, we used to call the management as a suspended management, and all the activities comes to a standstill condition. But here in this case, the remaining project would be constructed by the promoter as a going concern in the supervision of the IRP. So this is quite important in the supervision of the IRP. Reverse CIRP, a peculiar concept. A concept of reverse CIRP does not find its place in the legislative text. On the contrary, in some places it harms the spirit of IBC. The IBC clearly provides for insolvency of the corporate debtor, and there is no concept of any project-wise insolvency. Apart from that, section 14, which talks about moratorium on activity of the CD, while reverse CIRP allow continuation of the other project. With the amendment to IBC 2019, homebuyers are included in the category of financial creditor, and amount raised from allotee under the real estate project is a financial debt under section 58F of the IBC. As such, the insolvency cases against the real estate developer have increased, although limit of 10% or 100 member to file section 7 application against the builder prevents the opening of the floodgates. In case of CIRP, as per IBC, when a moratorium period operates, the activity including construction by builders are halted. This is disadvantageous for both builder as well as home buyer. The objective of the home buyer is to get their dream home, and their focus is not on effectuating the bankruptcy of the builder. Therefore, the concept of reverse CRP was evolved by NCLT to save the business. And this is what it generated out of the SR case or Swiss ribbon case. In Swiss ribbon case, the tribunal, basically the scheme of IBC has rightly been summed up in Swiss ribbon as an effort to maximize the value of the corporate debtor assets through restructuring by allowing it to operate successfully as a going concern. However, the Supreme Court in SR Steel noted that IBC being an economic legislation, the denial of the right to experiment is fraught with the serious consequences. So basically, it is nothing but an experiment through which the valuation of the corporate debtor or maximization of the valuation of the corporate debtor is the paramount. NCLAT, relying upon the observation made in SR Steel, did an experiment in Flatbuyer Association versus Umang Realtek Private Limited to introduce the concept of reverse CIRP. This judgment has been considered contradictory to the legislative intent, as through this it being suggested that the resolution plan reach finality without approval of third party resolution plan, which is contradictory to section 29 of the IBC. While the judgment was a welcoming step for the prosperity of real estate business, the right of the allottee, it is contradictory to the scheme that was contained. So basically, in Supratech, the ultimate intention of the NCLAT was to restrict the CIRP to that project, restrict the creditor of the project to form a part of the COC, let other project to continue, led the promoter of the corporate debtor to continue with its other project. So this was an experiment. 2 years after the evaluation of this concept, the legality and as well as the practicality of this again came up in Supratech case. Taking a practical approach, this evaluation is better solution for the insolvency of real estate developer and builder. The regular CIRP would not work efficiently because the allottee as a financial creditor will not be able to appreciate the resolution plan put before them. In addition to this, there can be no possibility of haircut in case of the claim of allottee. Hence, regular CIRP may not work in the situation. If builder goes into liquidation, the hope of getting possession of every project of the builder will go in vain. However, the disadvantage is also there. A disadvantageous situation may occur in case of project-wise insolvency. If the developer knows that insolvency proceeding will not have an impact on other project, it may have a reckless approach towards a particular project and may try to siphon off the funds toward the, and that's why there is a mandatory requirement. There is a mandatory requirement that there should be some regulation to be brought in before, or there should be some kind of amendment to be brought in the IBC, so that this reverse CIRP find a place in the statute itself. While focusing on the reasoning provided by the court in Supratech case, the stress has put on the protection of the right of home buyer. While the experiment by the court to ensure business efficacy is considered as a good move by the industrialist, the same shall not go beyond the legislative intent of the makers of the IBC. In the year 2018, 29A was added in the IBC with the intention of strengthening the corporate governance by restricting the participation of the promoter on the restructuring process, as the same would restrict the backdoor entry of the promoter. But this reverse CIRP in Supratech case has allowed one of the promoter to act as a lender to assist the corporate debtor in completing the construction of the flat outside the CIRP. Here, the court act of putting more prominence on the business efficacy and right of the home buyer over legislative intent in the name of experiment could turn into a dissent. So basically, there are two views, but one view is that reverse CIRP may maximize the value of the asset and may protect the best interest of the home buyer. The rationale behind the concept of reverse CIRP was that although the developer of various projects may be the same, but financial creditor and operational creditor would be different. Since the other project have no strings attached to the distressed project, there is no need for all the project to be involved in CIRP to maximize asset. However, it is very much important to weight both the side in given case before arriving to a conclusion, and same is with the reverse CIRP. The right and welfare of the builder as well as home buyer must be considered, and that too within the permissible limit of legislative text. The impulsive reasoning of the court to allow reverse CIRP in the real estate cases is erroneous on the grounds that in case if the promoter failed to adhere the guidelines provided under reverse CIRP, the original CIRP will be initiated and same would waste the time of the tribunal. Moreover, the power of the judiciary is to decide the case under the scheme of the legislation. But I can say one thing which I found it very appropriate in this reverse CIRP, and this is pertaining to the fact that if the IRP will be allowed to have the overall monitoring, if in case of reverse CIRP, the IRP will maintain certain standards of not intimating those authorities with regards to initiation of CIRP, which will adversely affect the functioning of CIRP. The bank account or the bank account operation of the real estate entity shall remain under the control of the IRP and RP, and all the withdrawal will be made after the due permission of the IRP and RP. As far as the resolution process is concerned, let promoter be exclusive person to decide upon who will be his lender, what will be the time frame within which the project will be completed, and how the resolution, like what we have in this, you can say a PPIRP. So as far as this reverse CIRP is concerned, it depends upon case to case. In not all the cases, this reverse CIRP will work because there are multiple builders who have only limited project and they have committed with default with regards to all their project. In such circumstances, to club the CIRP is the only alternative rather than keeping it isolated to one or only two projects. So let's see how Supratech will come out of the CIRP, out of this reverse CIRP mechanism. But I will say there is multiple difficulty which is being faced by the IRPs and RPs, more particularly with the claim of this home buyers with regards to the decree which are coming up through a home buyers, or moreover the dispute with regards to a developer and a landowner, especially when a developer has committed a default, and since the development has taken place over the land which belongs to some other entity which otherwise is financially stable, such kind of dispute can only able to resolve through a means of a very dedicated regulation in the IBC parcel. There has to be a specific chapter which can deals with this all concerns which are presently being faced by the adjudicating authority, and not only the adjudicating authority but also this IRP, RP and liquidators are facing immense heat out of such disputes. I will be putting this before you all in order to have a further discussion in case of some areas to be discussed upon.
There are the two projects.
Correct.
One is the home buyer, and other project was got constructed by the government department. So two projects. One CRP was started for the one project, but both the project was taken to the CIRP. Now the government department wants that their project should be separated from the CIRP, because the 90% project is already completed of them, and they want to say that they will complete the project, therefore they should be taken out from the CRP. It is possible to be done.
It is possible, and this is what the Supreme Court has even evaluated, that an adjudicating authority, the intention of the legislature is to maximize the value of the corporate debtor. The ultimate aim and objective of this reverse CIRP is to keep the other projects alive, to keep the other project isolated from the one which is in distress. So suppose if one of the project has already reached to its conclusiveness, and when there is no probability of default, there is no possibility when possession may get lapsed. In that circumstances, the project by CIRP may able to assist that, in your case, as one of the real estate project wherein the government is one of the partner. In to have a project by CIRP, one of the tower or one of the project can be safeguarded from the consequences of default which is made by other project.
But here the promoter is not going to complete that project. That project will be completed by the government department itself.
See,
In the case of the Supertech, the promoter was interested in to complete the other project.
absolutely.
So whether it will be allowed by the court.
See, in that circumstances, what happened, it is also important to see the locations, because see, if there are multiple projects which are going on at a different location to
Both the
fetch,
projects is situated in the same location.
in
Only
that
the land
circumstance,
is
in,
marketed.
in such circumstances, to isolate a project which will not derive any benefit, so taking the advantage of the reverse CIRP in this situation may not equally work. As you
Because
said
of
that,
that, both the projects are situated in the same place, but both the projects are different. Both the projects
though
are different.
though both the projects are different, but when the possibility of completion is not there and default are pertaining to both the project, in that case the consolidation of both the project will take place, and ultimately CIRP will run against the corporate debtor and not run on project wise. So basically discretion is given to the adjudicating authority to consider this particular case on the basis of the fact of the case and the basis of whatever may be the position and situation pertaining to each project.
But in this case, the government department wants to complete that project, and they have filed this application. If they are not the home buyer, that is why they should be kept away. If we will permit to them, that you can do your project
There
yourself.
is a, there is a
But
proving.
question is that what the expenditure is to be done will be borne by them, but the CRP cost which has been expended so far will be distributed among them, and they have to make the payment of that also.
Correct.
So it is possible to be done by the court.
Absolutely, yes, sir.
Sir, I have a question. May I
Yes,
ask
sir.
you?
Yes, sir.
My name is Josie Stephen. My question is actually with regard to the arbitration awards. See, some of the home buyers, if they have some, arbitration award, like for example, some compensation of, rental loss or something given by an arbitrator, where to classify them? That will be still considered as a financial debt, or it will be some other classification?
So as far as the classification of claim is concerned on the basis of the arbitration award is concerned, it shall see it is based out of the adjudicated process. This is what I have mentioned somewhere in between the session also, like a decree holder. Correct. So
Yep.
this is altogether, yes, this is altogether a case wherein you have got the arbitration award, or your disputes have been adjudicated by and before the arbitrator. Just because you are holder of the arbitration award, you will not be treated or classified as a financial creditor.
So where you will be put
Excuse me,
as?
sir.
I mean, you will not be put as financial creditor.
See, basically, you will be having a claim. Your claim is already established. Your claim has already been adjudicated. But here the basic feature of the time value of money is completely absent.
Okay.
Considering you as a financial creditor, ultimately that will defeat the purpose of the code. So everybody will go, even an operational creditor will go, will invoke the adjudication clause, will get the arbitration award, and will be filing its claim as a financial creditor. So that will not serve the purpose. You will not be treated as a financial creditor in this circumstances.
But for a home buyer, the basic nature of the claim of a home buyer is,
Is
as a
the financial debt.
creditor only.
And that's why the recently in the last week itself, Supreme Court has clearly stated that if you are holding a decree, though you cannot move an application under section 7 as a financial creditor, but yes, your treatment in the resolution plan should not be separated from other home buyers, and you will be treated as if you are your locus will remain as a financial creditor.
Yeah, so that means if you have a decree, if you have an arbitration award wherein the award is basically for, the rental loss, etc., for a home buyer, then can we
Financial
treat
creditor.
that home buyer? Then that home buyer cannot be treated as a separate claimant, right? Could be a
Absolutely,
financial
yes.
creditor only.
Yes, sir.
All right. Thank you.
Hello. Hello.
Yes, sir.
Sir, I want to discuss something separately from you, so I can have a phone number of you. I can take your phone.
Absolutely, yes, sir.
What is number?
We'll be sharing with you, sir.
Acha, ठीक है.
Sir,
Yes, sir.
there is, there is a judgment dated very latest, Vishal Chilani and others versus Debashish Nanda. This is the Supreme Court judgment. Hello.
Yes, sir. Yes, sir. You're audible, sir.
Unfortunately, I've just downloaded because I was just reading. I was just, you tend to have a look at the news which keeps on coming to you once you're in a Google, and they use their artificial intelligence to give you the information relating to IBC. So I think 2 or 3 days back, I happened to go through one news wherein it was saying in case you are a decree holder, then even I think you will be classified as a financial creditor. And I just
Absolutely, yes, sir. It's a recent judgment of the Supreme Court. Earlier,
Yeah.
there was an ambiguity that you will not be treated as a financial creditor.
No, earlier there was a Tripura High Court judgment which was upheld by the Supreme Court, which stated that in case you are the decree holder, then Supreme Court said yes, you will not be the FC. But this judgment, I've just downloaded it.
When you see that judgment, the RP has given a two separate treatment to the home buyers, those who have not opted the decree, and the home
Okay.
buyers, those who have opted the decree.
Okay.
So, absolutely, yes, sir. So, as far as the resolution plan is concerned, it was directed by the Supreme Court that resolution applicant should not consider this two person separately for the sake of distribution of the amount in the resolution plan.
My point is very simple. It's very interesting that you said is that there are few people who have opted for the decree and few people who have not. What exactly does it mean in simple? Thoda confused ho gaya main.
Got it. So basically, what from the viewpoint of resolution applicant, I'm talking about two viewpoints. From
Yes.
the viewpoint, yes, from the viewpoint of the resolution applicant, if I have to submit a resolution plan, I will be submitting the resolution plan on the basis of the information memorandum.
Yes.
Whatever information which IRP or RP is going to give it to me, I will submit
Yes.
my plan. So while
Yes.
submission of the plan, I will not treat this decree holders and home buyers separately. Both decree holders and
Yes.
home buyers, they will be considered unsecured financial creditor. Will be having their say after secured financial creditor, but before government dues.
Okay.
I want
One distinction you should also have is, let us say it is still under arbitration and it is, or in a sense, or is it sub judice with any forum, then
Correct.
that will be a contingent claim subject to the decree
Which
coming
has
in
not
their
reached
favor, then which will
finality.
become, yeah, which is finality. Correct.
So I'm again coming to your particular question, Mr. Singh.
Yes, sir.
So from the viewpoint of the resolution applicant, I will consider them with a similar locus. I will not give any bias treatment to the home buyers or to this decree holder. Now, from the viewpoint of me as a decree holder, I can very well submit my claim not as a separate class of creditor. I will remain out of that class and I can still submit my claim as a financial creditor.
Okay. I just
Now,
happened to give a very cursory look. I think this is what you are saying is there. This judgment
now
is.
from the viewpoint of IRP or RP, when you will be submitting a decree in order to substantiate your claim,
Hmm.
I will either consider you as a decree holder as a financial creditor, or else avoid decree. You have to submit your claim in the capacity of the home buyer. So basically, you cannot fill yourself in a similar jar that I am the home buyer, but since I have got a decree, I should get priority over the other home buyers.
See, more than the priority or category, I think the main issue what we face in IRP or RP is whether it is a category as a home buyer or decree holder doesn't matter to the RP. What matters is what amount should be admitted. Because
Absolutely.
his entitlement is say 10 lakh rupees, but he's having a decree of 20 lakh rupees. The question comes to IRP whether the 10 lakh as per the books of account should be admitted, or if somebody is having a National Consumer Forum order of 20 lakh rupees, whether that amount should be admitted. That's a bigger question.
Absolutely.
Because if you admit 20 lakh rupees claim of decree holder, other home buyers, they say that
It will go against the interest of other home buyers. Correct.
the concern, the issue major here is not a category, but the amount that what amount should be admitted by the RP or IRP. That's
Because
the main
on the
concern.
one side, the amount is adjudicated by other forum. Absolutely, yes, ma'am.
So you are saying the decree, if the decree holder is submitting the claim as per the order that has been received from the RERA or NCDRC anywhere, that amount RP can admit that amount.
Absolutely, yes.
But
As it is decided upon.
in the plans, what SRA is doing is they are saying all those decree will set aside and they will be treated as the home buyers only as per the books of account, what amount was due to them.
But then they further challenge it.
That's
This
what I'm saying.
round of litigation keeps on running.
Hmm.
So they generally get a better benefit if they go for an execution of that decree rather than filing this claim as a stakeholder.
Viniji, please excuse me. I just wish to get a clarity from where Manisha ma'am left it, because I could not connect the dots. Now, from RP's perspective, which claim do we admit, whether it is the decreed or the otherwise?
See, I will always come up. See, if I'm the decree holder, I will always come up with that decree because now it is adjudicated upon. And the claim is
an amount is more than what he's entitled
amount
as
is more than what I can claim as a home buyer.
Sir, when we underwent the training, 4-5 years back, the first thing that was told to us, like the word which is save your skin. So what I'm saying is very simple thing. What am I as an RP supposed to do? Whether
You
I
as an
admit
RP is going to save your scheme by admitting his claim as a home buyer.
as a home buyer.
That's it. But that will
That's
give
a
you
better
another
way.
round of litigation. He will go against you before the adjudicating authority. Let
Obvious.
the adjudicating authority to decide.
That is for the litigating authority to decide. That is obvious. Somebody is feeling aggrieved upon by my
Whenever a person is going to submit a claim, you have to verify the claim from whatever is the information available in the books.
Wonderful. Thank you, sir.
Thank you.
Already done, some decision on that. How can RP override it because he's supposed to be a neutral party?
ये तो सर ऑडिबल ही नहीं है.
Sir, may you please be loud?
I'm saying if some authority, be it arbitration or RERA, if they have given an adjudication and they have allowed a decree, how can RP override that? And being a third party, neutral party, he should be admitting what is allowed by the courts.
So you are not audible, but what I can anticipate out of your question is a adjudicated claim once placed before the IRP or RP, how the IRP or RP is going to consider whether IRP or RP is going to consider that adjudicated claim or the claim which is available in the books of the corporate debtor. Sum and substance of your question is this only?
Correct. This is.
Yes, so this is what I recently said, that being the insolvency professional, if I'm acting as an insolvency resolution professional or the resolution professional or a liquidator, what I will do is whatever papers I'm going to get, because in the arbitration proceeding, I was not a party. Somebody else was representing corporate debtor. In the consumer forum, I was not the party. Somebody else was representing the corporate debtor. That was a suspended management. I will restrict my verification of claim only up to an amount which I can verify from my naked eyes from the books of accounts.
Sir, does that verification should not be with the certified copy of the order which the RERA is giving, which is a much.
But what happens when the person reaches to RERA or when a person reaches to consumer forum, he get necessary compensation and interest and you can say apart from his primary claim, he get the necessary compensation over and above the same.
Amount is much higher than the amount.
Because he has made.
And that's why ultimately what it impact the interest of the other creditor. So in that circumstances, many a time the COC go against the RP for my removal.
It's happening.
But sir, they have made efforts to reclaim their money.
See, one thing is very important, that again the concept again comes before us. It's not a recovery mechanism. The company is in insolvency. You are claiming an amount much beyond what is stated in the company's books. So considering the present status, you know that whatever claims you are going to submit, you will get a haircut out of it by the resolution applicant. So I am going to consider whatever amount is standing in the book. Suppose in case of any ambiguity, I'm going to refer all the documents which you have placed before the arbitrator or before any adjudicating authority. Then only I will say that you substantiate your claim. Otherwise, your claim will be substantiated from whatever information I'm having and available with the books of the corporate debtor.
I think there was some regulation section also that discuss about this decree or order amount somewhere. I read. I don't remember the section right now, but it is somewhere in the act as well, all the regulations. The treatment.
Vinit ji, I am Rajesh Kurup. I, in my humility, feel that are we missing the wood for the trees? Because Section 14, does it not come to the aid and assistance of the RP? Because it says moratorium. Once Section 14
Yes.
comes into play, then anything
absolutely,
which
yes, sir,
transpires
absolutely.
thereafter has it not to be, ignored. Unless and
Absolutely.
otherwise a decree or order has been secured before Section 14.
Yes. We are considering that only, sir. We are keeping these questions and answering these questions, presuming the faith or presuming this particular fact that such a decree or such an order they have got from the court or the authorities prior to the inception of.
Sir, in which case I think that that is settled, because unless if you don't give regard to an order or decree that has been passed through a due process of law, that is by a judicial process, then you see you are undermining the whole thing. No.
Yeah, that is what
Where does the sanctity of Section 14 also does come into play? Section 14 draws a line. Anything which has transpired earlier there too, that has to, if it has to work against the interest of the CD, means that has to.
Absolutely.
That is what I feel in my humility.
Absolutely, yes, sir. So once EIRP is initiated, there is no question of you entertaining any such kind of award or decrees. You're right.
So in the same breath, we have to say that once for Section 14 has come into play, subsequent thereto, you see, you can ignore that. And in the same breath, we have to say that anything which has transpired earlier thereto, you have to give due regard to the same, because that has come to settle by due process of law, by judicial process. How you can undermine that? That is what I feel in my humility. Unless and otherwise, this is decided one way or the other by the apex court.
But many times it happens. Many a time it happens when award is passed. I mean, immediately thereafter, the CIRP commence. So there is no time frame which was available with the corporate debtor even to challenge the same.
Absolutely, the appeal could have been filed by the CD because
Could have been filed, but because of initiation of CIRP, that is pending.
separate amount.
Sir, don't we agree on something that it should be as on date of CIRP what is available? As on CIRP what is available is the decree. So it's not like you would have challenged it in some forum, you would have gone to next stage. All that is fine. But today, I don't think RP should admit the old claim. He should. That's my view. Maybe somebody might differ.
You are not audible, sir.
Comes here, can SRA after acquiring this company, can SRA later file the appeal against this? Will limitation
I just want to say something.
Yes, sir.
Sir, the decree amount can be considered by the RP, as you rightly said, if the books of accounts of the corporate debtor also confirm the same. Along with the interest calculation which the court has taken into account. But if the decree amount is say for 50 lakhs and with interest all his claims becomes 30 lakhs, the RP should not accept 50 lakhs. Otherwise it will be the right, as we rightly said, the right of the corporate debtor was impaired because of Section 14. So in my understanding, the decree amount or the amount calculated by the RP on the basis of books of accounts, either of the lower of the two should be considered.
Lower of two should be considered.
This is my view. You can confirm, sir.
The other party will feel aggrieved, will approach adjudicating authority again. So basically,
the other party always has a right to approach. But I should be fair as RP. I should be fair in my conduct while admitting the claims. Absolutely. I should have some basis. If a particular court has passed a order which is not tenable, which could be challenged, and the amount is not in line with the books of accounts or law, then I have a right.
Absolutely, yes, sir.
It cannot be the court has given an order for 2 crore, whereas the amount payable is only 1 crore. How can I accept?
Absolutely, yes, sir.
Let them go to the adjudicating authority,
And neither SRA can file an appeal later because once a process is over, then I don't think there will be any question left for making the appeal. So
absolutely, yes.
Anybody having this order 2 days before the nature CRP is benefited by 20-30 lakh rupees unless there are other home buyers. They will never.
Yes. Because at times we find there are certain orders which do not make sense. So every order cannot be taken with 100% sanctity, the same amount, with due respect to the court orders. SRA as such will not have any right later on, because once the SRA has submitted the resolution plan, it is on the basis of the admitted claims,
Absolutely, yes, sir.
And he has mentioned how much he will pay to whom. So the first question is the admitted claim have to be settled either by the RP or by the adjudicating authority if they are challenged. That's all. This is my understanding. Go ahead, sir.
I think we can move further.
Yeah, please go ahead. Vinitji, you can go ahead, sir. Further.
Sir, I must say that in case if any questions are there, we can have a discussion upon, and I will rest my session here.
I wanted to yes. Views on this as well. There are many, in the real estate sector, usually they just structure that, the landowning company is different from the developer company. And right now, before the NCLT and NCLT, there are many cases, which are pending for the approval because the authority has moved an application for filing objection on the plan approved, because they say as per their record, the land owning company is the lessee of the land, and the CRP
Correct.
has for the developer company, and now this is going to apex court as well. So
Absolutely.
just if you have some views on this, that how this can be dealt
And
with.
this is where I said that there is very much a requirement that some content should be, or some regulation should be brought in within the ambit of law in this regard. Because what happened, as rightly said, that landowner is somebody else. I have started construction over that land. There is a default which is actually committed by the developer. But when CIRP is commenced, the landowner's property gets tagged.
Absolutely.
Many a times there are reverse situation wherein the landowner is basically a investor or one of the partner in that corporate entity of that developer. So basically I have my divergent views whether a joint CIRP can be initiated or not. This is one of the question.
We tried this as well, but we failed because of this, limitation act was, was into, because of that, they could admit that petition joint also. Then we also apply, argued for the lifting of corporate bail, because both the companies are having same set of shareholders, directors.
Same set of shareholders, same directors, correct.
And CLT didn't even, lift the corporate bail. Ultimately, it is going to apex court right now to decide, what should be the fate, because
But
both the
what I believe is at that stage, it is quite difficult to separate a land from a project.
Yes.
Absolutely, because what NCLT says is that based on a 100 rupees stamp paper, just a JDA you're having with two companies, you cannot claim that land which is owned by somebody else. And there where I argued that on the basis of this 100 stamp paper only, the developer company without having the land has collected crores of rupees. So if
There's
that's
also a nature of dispute wherein the landowner is putting a claim before the IRP and RP as an allottee.
But just one clarification, the claim of the landowner, in most of the cases, the government authorities or development authorities are the landowners. I think it is decided they will be treated as an operational creditor, not financial creditor.
Absolutely, yes. Absolutely. It is decided.
The question the authority has raised here is that, as per their record, the company against which CRP has been initiated is not appearing in the record at all. So what they is their claim, they never participated in any of the meetings of the COC. So they want their entire dues.
Absolutely, yes.
I think this entire CRP process, the plan approval, everything is, in void, because this company doesn't have power to do that, because the company doesn't own the land. This is the arguments before the court.
But in case the landowner is an independent company having same promoter, same management, then
CIRP can be initiated against the landowner.
Then the only solution is the joint CRP of both the companies.
For joint insolvency.
That is the practical solution. That is the practical solution, because the entire stake of the landowner is also the one.
Generally, when this happens, they try to come before the adjudicating authority for cancellation of their joint development agreement. But once the moratorium starts, this is what I said, that they cannot separate the land from the property of the corporate debtor.
Then the whole objective, the first objective of the company will fail. Nah? If the land is gone, then where is the project? Nothing is there.
Absolutely, yes, sir.
Build, absolutely. And they know the company to which they have given the money. They are not aware which is the actual land owning company.
So absolutely, it was just a you can say legal technical arrangement these two entities made. Otherwise, for all practical purposes, it is one. There can be separate SPVs, but all practical purposes, it is one company, company.
But these arguments didn't work in the NCLT. We also proved that entire payment made by the landowning company to the authority is taken by the developer company only, because the Homebuyers money that has gone to the landowning company and then to the GNDA. This is very much apparent from the bank statement as well. The point is NCLT doesn't have power to lift the corporate bill. Something they said ultimately it has gone to the Supreme Court. Now let's see how it will settle.
See, the answer to this is with as far as Indian legal system is concerned or lawmaking is concerned, these things are intentionally left unattended, so that let it take its own course of time, and in the meantime, whatever advantage people want to take, it can be allowed to take it. Just one clarification, Nagar Sahab.
Yes,
in the category of class of financial creditors, as you were mentioning, suppose there is a real estate case and home buyers are different category. Those who have paid application money, they have not been allotted. those who have paid application money, allotment money, they have been allotted. And there is a category, those who have paid for the installment and they have been given the punishment, but registry is not done. So my question is, should we appoint a separate AR for different category or one AR?
Only one AR, sir.
One AR.
Sir, I also have one query
Yes,
about
sir.
this class of creditors. Sir, section 21, 6A, B says that where a financial debt is owed to a class of creditor exceeding the number as may be specified other than the creditors covered under class A or subsection 6 of the interim resolution provision shall make application to adjudicating authority. So it does not say that class
New
of creditors.
allottees.
Yes, sir. It
Correct.
does not say,
But
it
you
does
can.
not confine. It does not confine to class of. It should be financial creditor. It should not be a home buyer or depositor or debenture holder.
I second
If
your point, sir. I back your
suppose
point.
unsecured financial creditors, individual unsecured financial creditors are 100 in number, then whether they will not categorize as a class.
Absolutely no, sir. You please go through the format of Form CA once.
Yes, sir. What is in that, sir?
You please go through it, sir. When you see 6A clause A, B, it is very much confined to a class of securities. And yes, you can easily derive its meaning that it is specifically, when you see CA, it is specifically meant for the allottees.
Yes.
You rightly stated that you cannot make a point out of section 21 6A clause B, but when you see the class of creditor for which the form has been brought in by the ministry on 3rd July 2018, you will find all the data and details are pertaining to the allottee.
So suppose individual financial unsecured financial creditors are 100 in number, they will individually be dealt. So it will be very difficult in COC.
So, sir, unsecured financial creditor who are not a class of security holder or who are not the allottee, one cannot consider them as a class of creditor. The concept of class of creditor was originally, which was brought in for the allottee initially. And when you see debenture,
where it restricts that they cannot be class of creditor, where it is restricted.
So you mean to say that if I am the unsecured lender and there are thousands of such unsecured lender, they shall form a separate class?
I mean to say that, sir. Where it restricts. Which clause or which section restricts that only the home buyer or security holders or debenture holders will be class of creditor? Which section restricts, sir? Suppose there are 1,000 individual unsecured financial creditors, should they not be categorized as class of creditor? Because it says only about financial debt.
Yes, it is. Basically, the meaning is deriving from section 7, reaching to section 21, and then reaching to regulation.
Yes. Nowhere it is restricted, that it will be restricted to home buyers or debenture holders or security holders. It should be financial debt. Or class of creditor is not defined anywhere. It says about financial debt only.
So you mean to say there will be one more class of creditor which will be there along with the debenture holder, depositor, allottee, and that will be the class of unsecured financial creditor.
Individual. Yes, sir.
Individual.
Yes, sir. I meant to say that.
Individual means non-corporate.
Non-corporate.
But how can we make distinction?
Or even corporate can be included, but is armed.
Corporate, non-corporate, every other financial creditor you mean to say unsecured.
Yeah. Which section restricts? Suppose there are 100 or it is very difficult to enter in CO2. 100 people. It is also purpose to enter in CO2 that one AR will represent that.
I think we need to dissect the definition. Maybe we get something there.
See, basically, what he said is very correct from the viewpoint of section 21, subsection 6A, clause B, because there is no
Yeah.
specification pertaining to allottees or home buyers.
Yes.
In clause A, there is a specification pertaining to the security holders
Yes.
or a debenture holder or depositor, but there is no specification in
Yes.
section 21, 6A, clause B.
Yes.
And because of no specification, he is of that view that it is not only restricted or confined to the home buyers, and that includes any class of other financial creditor.
Yes, sir. I mean to say that.
Got his point.
So whether it what should be the view?
My view, see, I differ considering the established mindset of the financial creditor as a home buyer, and that form CA, the way it is defined or the way it is prescribed. I am not of that view that this unsecured creditor, individual or body corporate, they shall form a separate class per se.
Sir, hello, sir.
Yes,
My
sir.
view is, see, you can only address this matter in one way. That is because IBC, on the face of it, quite unlike, distinguishing between financial creditor and operational creditor, unless and otherwise you go into the niceties of, the asset allocation and things like that, distribution, the secured and unsecured does not come into the fore. I mean to say, on the face of it. So here, there is nothing in common, quite unlike a home buyers or debenture holders, nothing in common vis-a-vis the unsecured creditors. Why do you want to classify, or what distinguishes them? Apart from the fact that they are all financial creditors, what is it that is in common between X or Y individual?
First of all, yes, the term of
It
acceptance
can only
are
be
not
addressed in
same.
that way, because
The term of default is not
the
same.
distinction
Correct.
comes only in terms of financial creditor and operational creditor. So secured and unsecured, it is only for the niceties, working part of it. So that is what this can only be addressed in that way.
No, I'm not talking about secured or unsecured.
No, I got your point. But what Rajesh sir has suggested is very correct, because there is no common point of similarity, or there is no
Nothing
uniform
in
term.
common. You go to debenture holders, there is something in common. Go to the home buyers, there is something in common. What distinguishes this as a common one? Nothing. Apart from the fact that see, there may be different ways of bringing in similarities. That won't work, because what is it that the IBC foresees? As I say, try to impress. On the face of it, you only need to go as to a classification whether they are a financial creditor and an operational creditor. There is a clear definition for operational creditor.
Sir, may I submit something? The one purpose of appointing authorized representative is to represent somebody from a bunch from a crowd of people. Say there are 100 people, that will be a problem in a committee of creditors. So one person will represent them, and for that, unsecured financial creditors, if they are say 100 or 200, it will be very difficult to conduct the suit. That may be the one object. Hello?
Yes, sir.
So finally, what is your decision, sir?
Sir, my call is still confined to that this unsecured creditor cannot form a separate class. You have your own views, but this is what I feel, that as far as the class of creditor is concerned, there has to be some uniformity with regards to the term of the debt which the company is supposed to pay to this category of creditors. Every unsecured creditor to have separate terms of the lending or separate reasons of the lending. But when you see debenture holders or depositors or what we call this home buyers or the allottee,
Exactly.
they have some uniform reasons of
terms and conditions that governs their contractual relation. That is what that makes the difference.
Absolutely, yes, sir. Anyway, sir, It was a pleasure to be a part of this discussion.
Thank you so much.
Thank you very much, sir.
Thank you, sir.
On behalf of all the participants and ICSA IIP, thank you very much, sir, for such a nice and wonderful session.
Thank you very much.
Thanks.
Bhagat ji, where are you settled, sir? At Mumbai, Ahmedabad, or where?
At Ahmedabad, sir.
Ahmedabad. Okay.
Now there
Thank you.
is lunch break till 1:30.
Thank you very much.
So we re-log in or we continue to remain logged?
It's our choice.
I think we can reload this.
I think this is probably the 8th or 9th session on real estate insolvency that I can remember, which ICSI IIP has been conducting. It also goes to show the importance of this sector, the issues that plague this sector, the very peculiar features of the participants and stakeholders in the real estate insolvency. And also the evolving nature of learning that we are getting. As time passes, we hope to understand things better and hopefully reach better resolutions. Now, it's about 7 years now since the IBC has come into force. And I think it's time to sort of do something different, even in terms of the sessions on knowledge sharing. So unlike the standard methodology of somebody, faculty, whatever name you give, making a presentation, trying to tell what he or she knows about the subject, and then maybe taking a few questions at the end, we will try to do something different. Let us today just bring up all the questions or the issues that we have faced, either directly or because we have read about it, or somebody we know has experienced such issues in the real estate insolvency process. Let us discuss them as an open house. And let's hope that we come out of this session more enriched than what we started with, all of us. So there is nobody here to teach, nobody here to study, but we all try to share knowledge that we have and the opinions and also the perspectives that we would like to bring to each of the issues. So just to kick off the session, and for no other reason, I have listed out a series of questions that came to my mind and which we will take up one by one. After each question, it will be an open house. There is nothing that I am going to say more than what collectively all of you know. So let us keep it that way. Anybody and everybody at any time, just intervene. All you have to do is use the raised hand symbol and I will recognize you, and then you can intervene to pose a question, make a comment, maybe provide a clarification or give an opinion, whatever. Okay. So if I think you are all agreeable to that, we will start with the session. Okay. I presume you are able to see the PPT and
Yes,
we'll
sir.
go ahead. Yeah. So as I said, I have made about 17 or 18 questions or issues that based on my direct experience with real estate insolvency and also the interactions that I have had with various IPs and other stakeholders in this sector, that these are the issues that we need to probably look more into depth, maybe try to find solutions if there are unresolved questions, and in general understand the matter better so that we can do a better job next time around. Okay. So the first question that comes to mind, and this is because it is so different from all other members of the COC when they vote, is that now creditors in class, which includes allottees, are bound by the present and voting principle. The question that is posed is that is it discriminatory when it comes to comparison with other FCs? And related to that, because it's about voting, what are the practical issues which are faced by authorized representatives or RPs when conducting the voting process? And how are they sort of addressing it today? So system same, it is open house and anybody can just, butt in and say whatever you want to say. You can express your opinion on whether the question, of course, the first question, present and voting principle, is it discriminatory when compared to other FCs? Yes, anybody wants to say anything?
Sir, good afternoon to you. This is Bhumi.
Good afternoon, ma'am.
How are you?
I'm fine. Nice to see you again. Yes.
Thank you very much.
Bully.
So I thought, since nobody is responding, I thought, let me talk about this.
Yes.
Number one, in the case of class of creditors, especially the home buyers, the AR, once he is present in the COC meeting, he is representing 100% of the class. And he is present. And also the IBC provision says that if 51% of the members vote for the resolution or vote against the resolution, it is accordingly voted by the AR. So if they are voting for the resolution with 51%, then it's going to be 100% voted because that's what he has to do. So the present and voting means he is physically present, number one, and voting is 51%. So this present and voted becomes irrelevant in my opinion, actually. Because AR as a rule, AR has to be in the COC to represent the class of home buyers. However, the second thing is practically what happens when we put it for voting. Let us say there are 100 home buyers, and who are supposed to vote in the list of the creditors, and 80 home buyers will log in and 75 will do voting, either vote yes or no. Another 5 will log in and they will not do anything. So we treat the another 5 numbers as abstained from voting. Another 20, 80, 100 minus 80, 20 people have not voted. They have not even logged into the system. So the present and voted is basically, out of 100, only 75 are present and voted. Balance are either abstained or not voted. But that's all. But in my opinion, in the class of creditors, it is irrelevant. That present and voting is irrelevant because of this 51% voting and also the AR present. This is my view, sir.
Yes, thank you. Anybody else wants to say anything, add to that, concur with it, differ with that opinion? Okay, let me just expand a little on this. Present and voting here means not whether AR is present and voting, but the principle of present and voting, which is different from the voting of the COC as a whole. In the COC, what the principle used is vote share, positive vote share, which means that if some resolution requires 51%, that means 51% of the total vote share must be for that resolution. And abstention is counted as negative. In the present and voting system, which is what normally is used in AGMs, etc., the system is whoever is present, out of that the majority. So the creditor in class voting, here this principle is adopted, and of course this has come because of certain very, very relevant practical issues, especially JP. We all know that they have about 25,000 allottees and not even 250 turn up to vote. And then it becomes a problem as to how do you calculate the vote of those who are absent. So this is one. I mean, it is the principle of using the present and voting methodology for a creditor in class came out of practical difficulties. It has not come out of any substantive, measure of justice or to, do better justice. So it has its plus that those who turn up to vote, this is how our political elections take place. Those who turn up to vote, majority of that you have to get to be the winning candidate. But because resolution is so important, so the question that I was trying to raise as for just for discussion is that, like for 12A, the present and voting is not applied deliberately, and it has to be 90% of the total vote share. Similarly, for certain critical resolutions, should there be a minimum approval threshold by vote share even for creditor in class? Like, let's say if you take parliamentary election, voting for certain like constitutional amendments. Now it has to be 2/3 of present and voting and simple majority of the total members, which means there are 2 thresholds to be passed. Now that we have gone over 6-7 years, has the time come to relook at it? And besides the current principle of majority vote, should there also be a minimum vote share threshold for the creditor in class for any resolution to be taken as approved? Maybe not all of them. Maybe the routine ones need not be covered by that. But the way 12A is covered, should the approval of resolution plan, for example, also have such a minimum stipulation? That was the question.
The rule would be prone to misuse, sir.
Even now it is. Anish, you know how it is, how it works.
No, I'll tell you why. Because, in case there are certain parties who would not are against a plan, could then subvert this by saying, there's not enough voting by, one class of creditors, and then the entire creditor community then suffers because of certain homeowners. So I don't know.
Yeah, it's a tough call because for whatever it is like a balloon, you press somewhere, something else comes out. So for every thought that comes to our mind, there is always a downside when it comes to allottees. Because of the very nature of those stakeholders, individuals, not necessarily fully aware of provisions, and at the end of the day, just rightly so, bothered about their money, which is invested, hard-earned money, so to say, which is very different from institutions who are voting. The benefit of being impartial is there, but at the same time, there is the fact that it is not their money, mostly. So,
no, ultimately they are also fiduciary also, that they are managing.
Yeah, we know how that works. We know how that works. So yes, I mean, as I said, both sides of the coin, there are arguments. So since now we are at the 7-year itch stage, so I thought one of the questions which we could look at, not necessarily that there has to be any change, we could come to the conclusion nothing else is required at this stage. But an issue that came to my mind, and that maybe not, maybe at least for the approval of the plan, would it make sense to keep at least a minimum threshold? At least, just as an example, I'm saying at least 1/3 of vote share, if not 66, half of that should be there, because the misuse happens the other way too. And we have seen that in JP. Yeah, very few really turn up to vote. And one can say
No,
that.
because I see even in a small, housing society committee election, we are having only, in where I stay, there are 220 members. But for a office bearer office election of only about 3 or 4 members, hardly anyone comes in to, stand for the committee. There are, out of the 220, it's probably 10 or 12 who are taking interest in the affairs of the society. And I think having the, like you said, parliamentary election, or let's say not, it's the general election, like for example state legislature or the Lok Sabha. We have, again, it's basically a present and voting system.
Yeah.
First past the post. That has been co-opted for the general public, which is represented here by a homeowner. And you could have various categories of homeowners. You could have the urban upper class, middle class, or it could be slum rehabilitation. So you can't have one size fits all. This is probably a golden mean. Let's put it this way.
Yes. Yeah. Yes, Anilji.
Yeah, both the options have downside and upside. We cannot have a perfect situation because home buyers are not well equipped with their rights, and they are not even courageous enough to take the right decision also. No, they are not guided also. So they are separated. So that class of home buyers who are misguided by the promoters or some other sect, they get united. Others are always individual, separate.
True. Yes. Yeah. Yeah. I mean, it's a very vulnerable class.
Yes.
At the same time, it's the Parliament and Supreme Court have gone beyond the remit to classify customers as financial creditors. It's a deeming fiction that allottees are FCs. Otherwise, they would be OCs in normal course.
So what we can propose or we can think of that how best the justice can be delivered to them.
Yes.
That's all. How best under the circumstances, So if the minimum threshold is required, then it should be so that they will be forced to vote and participate. As the gentleman was saying, we see in every society the active participants are very less, but their expectations are very huge.
Yeah, very true. Very true.
They want society to be maintained like the best society of the country, but they don't want to contribute.
Yeah. I know.
So that is a practical situation. We have to learn to live with that.
Yes, we have to learn to live with it. Absolutely. Okay. Related to this, of course, now more practical is anybody facing any issues when conducting the voting, either as an AR or as a RP? And is there any experience to share on how such issues were resolved or not resolved, either?
So the two issues which I faced while conducting the real estate insolvency, one was that they were always not decisive, so they wanting extension of time. The more time should be granted. Second, there was a confusion earlier, which is now clarified, whether each home buyer should be voting or AR should be allowed to vote on behalf of them. So now, when the clarification came that they have to vote, then the casting vote has to be by the AR, where the majority of the home buyers have voted. Casting vote has to be in that line. So I think these were the two challenges: extension of time and the decision. So I think the role of AR, which is now supposed to be increased, is very important. AR was the least paid, doing thankless job.
Yes.
In fact, in real estate insolvency, AR should be at par with the IP. He is the one who is to convince and who is to guide. IP takes a back seat.
Yes.
So you go and talk to your AR. The AR should guide. Okay, what is in their interest? What should be the decision? What are the facts? You know?
Yes. In fact, one part of this today's session I have kept exclusively for AR roles and responsibilities.
Yeah,
And
I
we
think
will
that
come
is,
to that in detail because
that is very important. That
in
is very
fact,
important,
you
sir.
have hit the nail on that the AR is the fulcrum of a successful insolvency resolution in real estate.
Very true, sir. Very
I
true,
agree
sir.
with that. Yes.
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 But can I say something more?
Yes, madam. Yes, go ahead.
See, my experience with this real estate sector industry is that, see, in all the cases, wherever I have handled, there's an association of home buyers. This association consists of 90 to 95% of the home buyers involved in that project. So, in fact, many of the home buyers ask, when we are there, we will represent the home buyers, why an AR is required. So I had to say there's it's an legal requirement. So what I have understood is that even if, in fact, the association insists that they attend the COC meeting, they don't believe they trust the AR, and his ground level knowledge is very limited compared to the association's knowledge, who has been fighting in this system for the past 7-8 years. And so I bring them as the core committee members of the association as special invitees. They are part of the COC in discussions to ensure transparency and to ensure a fair play. Yeah. And any voting or anything, it is basically decided by the association. If the association core committee says you do this or don't do this, everybody falls in line. They don't care the AR. AR does not have much of hold in all these cases. That is what I have understood. Legally, we bring him here and he is there. And to that extent, I would say even the involvement of the AR is very less, because he knows there's an association, it will take care of it. And easy way for the AR is to say yes to the association. That is what is happening. In fact, in one of my assignments, the AR, in fact, the home buyers want the flat. They don't want the law. They don't want the compliance. That is RP's job, not home buyers thing. And the AR supported an association who wanted an illegal thing to be done. Means basically colluding with the promoters. At some point of time, they understood, no point in fighting the case. So let me collude with the promoter, bring some indirect entry and do it. And the AR is supporting that. I am saying it cannot be voted because it's not as per law. The AR says no, it has to be voted because the home buyers association is asking for it. So I really don't know. This AR is becoming, in fact, I literally wrote to IBBA saying that they should make it very clear that AR has to adhere to the IBC code. It is the requirement. That's why an IP is appointed as an AR. In spite of that, if they decide to take an easy way out of supporting the association and say whatever association says, I will say. That's all. Very simple. Yeah. And it is in fact, the court should say that, AR also should follow the IBC code and comply with the provisions. It's not only the RP.
Yeah. Yes. In fact,
hello. Just 1 second, I want to say that. So AR's role is, it is basically, I see as a redundant role, practically what is happening. That's my view, sir. Thank you.
Yeah, two things you asked for. One, as far as the applicability of the code of conduct, it is applicable to the AR. There is no doubt about that, because the assignment of an AR is under the code and automatically every IP is covered. So no need of any separate circular. In fact, a couple of disciplinary actions against ARs, I think this will be more effective than having a circular.
Exactly, but I'm not sure whether anything is.
No, somebody has to complain. Yeah. Okay, first, that can also be the RP. Second part, what you mentioned about the association is something very, very useful, and in fact, across real estate insolvencies, there have been both types of experience, but largely, if there is an association which is existing and which is reasonably cohesive among themselves, then it definitely helps in, crossing over at least the usual nitty-gritties of the resolution process.
Very true.
Yeah. It's a great help. Yes. And in such a situation, it would be my opinion that the AR should act like the counsel for the association, not a representative only, but also a counsel. Because as association knows about, let's say, like the COC and the RP. Now the COC is for commercial, RP is for the compliance and legal. Similarly, AR should be for the compliance and legal and leave the commercial wisdom or to the allottees or the members, which is how it should be anyway. Okay.
Very
Anybody
true.
wants to say anything?
No, very true. I agree with you, sir. Even in the case of COC, RP has to guide COC to take a commercially wise decision.
Yeah.
You know, COC may not be having this specific information about the company or the project which they are handling. COC members may not be knowing. All through their life, they have run the banks. They have not run the industry.
Bilkul. Yes.
So
Yes.
there are inherent weaknesses in the the people who are representing financial creditor in COC, you know, which
Yes.
we will deal with. It's a separate topic because the people who are coming to represent financial creditors should be in the know of law and should have sufficient amount of experience to take commercially wise decision, you know.
Yes. I agree that yes, the RP and IP has a big role to guide the committee. Similarly, the AR has probably an even more important role because ultimately banks and institutions can fall back upon their legal department and their
Yes.
the allottees don't have any such you know, luxury. And so the role of the AR becomes actually more. And to that extent, Bhuvneshwari madam, I would say that rightly done, the AR can be a huge positive force multiplier.
Yes, sir. Yeah, sure. Thank you.
Of course, if the AR is corrupt, that is equally true for any position in the world.
For that matter, anybody who is corrupt.
Anybody who is corrupt will.
So that is a different issue, you know.
Yes. Yes.
Nobody. That is a precondition.
Yes. So we will come to the next set of questions that I sort of came to my mind. See, the CRP is against the city as a whole. I mean, that's what it is till as of now, because it is for against the company. However, the application by allottees, now this is very, very specific, you know, in section 7, that as per the proviso, only 100 or 10% of the allottees of the same real estate project can take the company to insolvency proceeding. Now, if that is so, and because this is the part which is still unclear in terms of the last 7 years experience, in a way, the code is already saying that each project allottees are a class by themselves. In a way, by saying only those of the same can join together. Now look at the other provision that if it comes to general FCs, any two or more can join together. They don't have to be of, I mean, there need not be any commonality between them. One could be a working capital financier, another could be an NBFC giving maybe vehicle loans, and the third one could be a term loan lender, and they can all join together. And they are all treated as one, you know, sort of class, so to say, not creditor in class, but similar category. But when it comes to allottees initiating a Section 7 application, there is a very, very specific limitation or restriction imposed. Now, the question being put up, does it by implication mean that allottees of separate projects are a class by themselves?
Sir,
Can we take that interpretation? Yes, ma'am.
Yeah, in fact, I think it is the Supreme Court verdict 2-3 years back in the case of Manish Kumar, wherein this 10% they clarified that it pertains to a particular class. It's not the creditors as a whole. This is my memory. I don't have the order.
No, that is okay. We are not talking about that. No. Madam, let me just clarify what I'm trying to say. That in a Section 7 application, if it is to be moved by allottees, the 10% or 100, whatever is that lower, they have to be of the same project. That means if a CD has 10 projects, like a large CD, okay, then allottees across projects cannot join hands. Like,
I agree.
okay, that is not allowed. That is very, very specifically barred. If so, now I'm talking about the corollary interpretation that comes out of this. If they are treated separate for initiating, then does it imply that they are separate even for voting?
For voting, yeah.
That means project A allottees have one AR and one, they are a separate class by themselves. Project B is different. And there is a reason for this, because different projects could be at different stages of issues.
Yes, yes.
And completion. Some of them may be, nearly complete, just paper formality remaining. Some may have not even had a foundation stone being laid, and the two categories of voters, it's impossible for one, first of all, they don't understand their own needs properly.
Yeah.
To understand somebody else's situation is stretching, credibility a bit too far.
Yes.
Yeah, in fact, that is the reason I think, IBBA was and the MCA was about to do the regulations, separate legal provisions and regulations with respect to real estate industry, which is still in the pipeline. However, but as of now, it is the CD as a whole, COC as a whole, voting as a whole, which maybe that is the reason.
No, that is practice. My question is not about practice. Practice can be wrong for centuries because of wrong understanding.
I'm talking about the law. Law
No,
is,
and I'm also talking about the law. The question I am raising is, where does the IBC say that each project cannot have a different care? Where does it say? For example, okay, let me just complete. Suppose you have debenture holders. Okay, public debenture holders. You have deposits, fixed deposit holders, and you have allottees. Now, one thing is clear, these three are separate classes.
Correct.
So if allottees are then of project A and B, why cannot they be separate class when the most important proviso of that is section 7 says that they are different? Correct. If they are different at the time of initiating, doesn't the same differentiation carry forward to voting? And here I am in a way referring to not in the same context, but similar context to the Chalani judgment, recent one. Okay. That once an allottee, always an allottee. We will come to that also. Okay. So these are just being put up for thought. Okay. We are not talking of solutions here, but opening the mind to possibilities which may already be existing and we may not even be using them.
Yeah, two things. In fact, you are initiating a good thought process. If there are 3 projects in a company, we can have 3 different set of co-home allottees, project A, project B, project C, and their voting can accordingly be considered. That is very good thing, number 1. Number 2, what is practically happening in Bangalore? In fact, I am party to one of the things where with respect to a CD, if a particular home buyers of a particular project is making application, nowadays they are admitting only that project.
Yeah, but there is an issue with that. Okay, we will come to that, Umang Realtek, how valid it is in law. It's there as part of one of the questions. But on the same topic, if you look at, the real RERDA, we call it RERA Act, but it is actually RERDA. There is a D silent. Now, in that, it is a mandatory requirement that 70% of money of each project has to be used only for that project.
Yes.
This is mandatory. There is no
yes.
Okay. And only 30% is a float given for general corporate purposes, because there could be expenses of an overhead nature. So already RERA is clearly saying each project is different. They give a different registration number. They hear issues relating to allottees project-wise. Each one is treated as a separate case. That if there are 2 separate registration numbers under RERA, then each application is they are to be heard separately. They may be common issues, but still to be heard separately. Now, if you look at the definition of allottee in the word allottee used in IBC, it's very explicit. It says as defined under Real Estate Act. No separate definition of either the term allottee or the term real estate project, which means these definitions, they are borrowed from there, and the definition there will apply. That means certain features of this sector, which are under RERA, should also apply to IBC as long as they are not in conflict. 230 comes only when there is a conflict. Okay. And at least my reading of today, as of now, IBC, it does not prohibit separate AR. It's never been used as different, because we are like Koluka Bell, you know, we know only how to go round and round. So even if the yoke is removed, we will continue to go round. But that practice, that is, you know, slave of habit. But the question being put just so that for thought, okay, for understanding, for maybe even experimenting tomorrow, if the opportunity presents to any one of you, okay, try this. Worst case, what? Somebody will say no, or NCLT will say no, but at least, you know, you would have opened the mind to this. Because frankly speaking, each real estate project is a project by itself.
Yes.
There is no commonality between them. Even if they are wing A and wing B in the same plot of land, even then there can be different issues.
I think since the project-wise insolvency has been sort of permitted or allowed, so having separate COC or separate AR for project-wise makes a lot of sense. You know, it makes more sense rather. You know.
Yes. Others, please. There are, I think, 68 people present. So let's hear a few more voices. We would love to hear. Maheshji.
Hello.
Mr. Narayan, go ahead.
Yeah. Sir, I have one, sir. My experience, let me share. In Bangalore, NCLT, what has happened is one project was there. It was admitted to CIRP as a CD as a whole. Okay. Then after some time, they said that it would be project wise. Before they decided anything, one of the project guys in this went out and said, our project should not be covered in this particular CIRP. The NCLT allowed it, and that particular project, out of two projects, one project went out. There remained only one project in the CIRP. That was the one which was on which the CIRP was going on. Now the owner of the land of the second project now has gone and said that this is illegal. So this thing also should be excluded. Now NCLT is considering excluding that also, in the sense that it is an indirect way of getting out of CIRP totally, because both the projects go out of CIRP. There are only two projects. One project was 70% complete. One project was only 20% project. 70% project complete guys said that we want to get out. They went out. NCLT permitted them to go out, saying that our project is not covered in this. The balance 30% remained. Now for that 30%, the landowner was somebody else with certain valid reasons. He has gone to NCLT saying that land belongs to me and it does not belong to these guys, so it should be excluded. It also should be excluded. Now, assuming that if the NCLT considers this man's request, what does it imply? That are we getting out of CIRP totally, and is it permissible under law?
Interesting set of facts that anybody and everybody can go and say that I don't want to be included. Well, as the law stands today, if somebody is permitted to go out at their whims and fancies, it's not legal as the law stands today. Unless the apex court says otherwise, but the understanding
one more thing, sir. Yeah, I got your point. But I think there's a judgment which says that RP cannot appeal against the decision of the NCLT.
Yeah, I will refer to that region issue. Okay, where it's an interim order because it dealt only with one part.
RP is affected here.
Yeah, the balance is to be dealt with. But that is flowing from a different angle. Okay. So that is nothing to do with what type of judgment is there. But the fact that an officer of the court can he go in appeal against his superior unless he is personally affected. So the Supreme Court order in that case said RP not being an adversely affected party, because it cannot be unless, of course, the judgment, I mean, the lower tribunal order is in relation to RP's personal issues, fees, expenses, any strictures passed against RP. RP is supposed to be neutral and cannot be going in appeal against anybody else. I mean, because they're not supposed to be adversely affected. That was the judgment. Okay, that's different. We are not talking of that here. The fact is whether in general, can anybody and anybody say, put me in and put me out? Then it will be like a, you know, what do you call, a mela. I chalo dekha kuch kharida kuch chale gaye. Can't be done. So bad practice, yes. A very specific case where the initiation itself is based on grounds other than resolution of insolvency. That means some malified grounds. Then Section 65 applies. It can be set aside. But those are very, very limited grounds.
Right. It said that one of the majority of the home buyers in a particular project formed an association, went and said that our project is not, and it is not the subject matter of CIRP. Honorable NCLT agreed with that.
Then
they
it
said that,
can.
yes, you are out.
I mean,
you are no longer part of it.
By
RP in the
itself.
process had spent money. Majority of the money was spent on the project which went out.
No, let's give the other. Let's give other example. There is a company which has an outstanding, let us say, debt, all FC, OC, everything put together of 1,000 crores. And one OC with a 1 crore default goes and gets petition admitted. And maybe 700, 800 crores creditors say it should not be. Can they say so? Does the NCLT even have the
I don't know, sir.
jurisdiction to
You
say
tell
no?
me, sir, here we have a judgment.
Judgments will be there, but judgments are not final. Till Supreme Court says it is final, so one can always disagree with it. What I am saying is, I am saying, in my opinion, it is not in line with law.
I agree with you, sir. I agree with you. The question is the remedy available. I can't as
remedy
an
is appeal. There is
I
only
can't
one
appeal,
remedy
no,
in
sir.
law.
Who's to appeal? I can't appeal as an RP. Now they say
No,
RP
you
is
don't
not
have to
personally
appeal as an
affected.
RP. Affected party should appeal. Why are you as an RP interested in continuation or not? If the NCLT says band karo, khatam.
Okay.
RP's job ends with that.
The question is, sir, if both the projects go out, who's going to pay the RP's fees?
That's a different issue. That's a different issue. Don't mix up the two.
For that he can appeal. He can ask.
You appeal only to the extent of getting because that is, as I said, personal issue, you have the right to appeal.
Yes.
General issue of IBC, not.
So indirectly, NCLT can close down a CIRP against CD by saying that both projects are excluded.
So whether they are right in doing so or not is a different issue altogether, but that is not
Right
for
now, that is
RP to
happening.
appeal.
So,
that is not for RP to appeal.
So nobody
creditors will go now. Creditors will go. The whose project is affected adversely, they will decide and they will go to the appeal.
It has happened where admission has been rejected at NCLT stage. The affected creditor has gone to NCLAT and got it restored. Happens every other day. उसमें कोई नया तो है नहीं.
It will be just like that only. But here, in most of the cases, sir, the landowners is one entity and land development rights is other entity.
That's a different issue. We will come to that separately because it's equally tricky issue.
So
I will just go through what I have already have. Then we will, because we have significant time, we will come to other things also. Please keep that in mind. Park it and we will cover that. Okay.
Okay, sir.
This too happens, and 3-4 of these are put together as a group. So say there is an OC of a real estate corporate debtor. Okay. The CD runs out of money, cash flows are tight, gives in lieu of the outstanding amount a space, flat, shop, whatever. Okay, makes him an allotee. So does he become an allotee? He started life as an OC, then became an allotee. So an allotee is by definition deeming fiction an FC. So does an OC become FC? Just parking it, okay, one. Now suppose it was an unsecured FC to begin with, let us say, not an OC. Also happens. Friends and relatives, builders do this very often, private loans, okay, very common. And then unable to pay, then given flat or shop as a payment in kind. So is that person now an allotee? Then related to that, if such an allotment is done, would it tantamount to be a preferential transaction? If it is at a discounted price compared to the general price, especially because the payment has been delayed 3-4 years, time value of money on the original debt, would it be an undervalued transaction? Okay. So these are very common issues. So if anybody has faced them, please share your experience. There are no final answers here. Let me make that clear. There are no final answers yet. There is no, definitive judgment which says one way or the other. There have been orders which have held both sides. Some which say yes, some which say no. Or opinion. If you don't have any direct experience, what do you think? What is your opinion?
No. I had some experience in real estate case. So the point is that number one, the conversion of OC to financial creditor and secured creditor is not an illegal act. So that will be given legal sanctity. And at the same time, if it is for a lesser consideration, and it will be considered as a undervalued transaction also. And if it is in preference to other creditors, it will be treated as a preferred creditor also, preferential transaction also. That is the way I think it.
Yes. Any other opinion? Different, in support, clarificatory? Yes.
I think you can conclude by your version.
No. I'm just putting, as I said, there are no direct final answers here.
I know, but
because these are questions. See, after 7 years, we are going to have only tough questions left. The easy ones have all been answered.
Yes.
Okay. So I thought let this session be about the tough questions.
Yes.
To provoke thinking. That, we go back and think and see what could be an answer to this.
Since more responses are not coming, we can build up consensus. What should we?
The consensus could be that logging in is of 70, attendance may be only of 5.
That is again, as you were saying,
allocating.
Yes. Go ahead.
So allocating an apartment to an OC, there is no real flow of money happening here. So in order to qualify under financial debt, there has to be a time value of money, and 58F has to be satisfied. So in case of an OC, in lieu of the payment, if he's getting a flat allocated in his name, I think that will be, considering him as a financial creditor would be a wrong step. I mean, my personal opinion.
See, if you look at the definition of financial debt, all of them, money doesn't actually flow. There are some where there is no flow of money. For example, a guarantor. There's no money which flows from the guarantor. It's a future liability in case the first one defaults.
But OC has supplied goods and services.
Yeah.
The goods and services are they are bought against money. So that money was payable by the corporate debtor. Corporate debtor has converted that debt into a financial debt. You know. So he is accepting the consideration. He is a corporate debtor has already accepted the consideration in the form of goods and services. Amount is already determined.
Yes.
No, whether the OC has given any money to the CD, that is the question. He has not given any money to the CD. He has given goods or services to the CD, in lieu of which the CD is giving him, a flat. Does not mean that money has flown from OC.
Why the corporate debtor is giving? Because suppose the goods of 100,000 were supplied. The corporate debtor is not able to pay. Okay. Now the 100,000 is getting converted from OC to FC. He's saying, okay, now I will pay you. I'll give you allotment.
Giving a flat, for the payment which he has to make. Giving a flat to the OC does not mean that.
Mr. Joshi, don't get carried away by what is given. Okay.
Yeah.
It could be consideration in law, can be in cash or kind.
Yes.
There is in general, there is no bar except in very specific instance. Now, how payment is made and what is money?
Can I, sir? He becomes an allottee. The moment he comes under the definition of allottee.
Does he? That is the question raised. Is he an allottee?
He becomes an allottee.
Your opinion is that the moment, you get a flat allotted, you are an allottee because something.
Once you are an allottee, you are an FC.
Okay. Yeah. If you are an allotee, automatically you are the deemed FC anyway.
Legal status of the OC has changed. You know.
So has it?
Yeah, it is possible, sir. It's permitted. It's permitted.
It changed? Yes. Okay. Now.
It is permitted. Change is permitted.
One side.
Whether has it changed is a question.
No, the payment of consideration in kind is not illegal in law. That part is there is not much of an issue. At what price and whether in preference, those are other issues. We will park them separate. Let us assume that those issues are not there. So payment in kind at the fair value has been done. Now, does it make that person an allottee? That is the question. And there are two answers to this. Okay. The first one, because you got an allotment, you became an allottee. Fine. That is one answer, which also has an appeal. There is no doubt about it. The literal interpretation would say yes, an allottee. The other is, okay, this is why allottees have become FCs in the first place. Now, they have not become FCs because they were always FCs to begin with. No, it's a deeming fiction. It is by statutory fiat that a status is being conferred, which was not there and is never there. Let us take another example just to make things clearer. Suppose you are buying a ship, huge thing, or an aircraft. Okay. The customer has to pay enormous amounts as advance. Sometimes 100%. Now, does that customer become an FC because he has paid 100% advance or significant portion advance? Answer is no.
No.
That person, a customer, is always an OC as per the expanded definition of operational debt. Not what it was initially, but expanded.
It was not given for a debt. It was given for purchase of a ship or aircraft.
Here you are purchasing a flat. You are giving an advance. How do you become an FC? No, let me complete.
Okay.
Why this came about? Okay, this is not in law. This is created. This is that's why it's called deeming fiction. You know, it's created by law. It doesn't exist in reality. And the reason was social. It was not legal. The reasoning behind the government also supporting what was actually pushed by the Supreme Court. Okay, in the JP case. JP case didn't start with IBC. It started many, many years earlier as a writ petition. Chitra Sharma is arising from a SEBI issue with JP. Okay. So, in that, because of the numbers involved, this was like, let us give them a benefit, which is not to be enjoyed by the others, only by them. So, when the creditor in class definition came, it included genuine FCs who are, let's say, debenture holders or, deposit holders, but also this deeming fiction called allotee. An allotee is not an FC.
ఇప్పుడు వేసుకున్న టాబ్లెట్ ఏమైనా ఉందా? Sorry.
So, an allotee has been given that benefit. So, an OC, by getting an allotment, gets that benefit which otherwise was not available to him, only because of a default. And a consideration in kind, does it make that? So, that is the contra to the argument that an operational creditor who begins life as an OC, whether by assignment or by payment in kind, will remain an OC. That's one argument. The other one says, no, it will not. Okay. As I said, there is no final answer on this. This is one of the questions that has arisen in many CRP of real estate, not fully resolved till now. Okay. Then 6 and 7, again, would they be in avoidance transactions? Possibly, yes. Obviously, it will depend on the facts of the case.
But sir, if for an operational creditor, if the flat was allocated prior to the initiation of, say, ARP, probably, he will be submitting a claim form in Form CA. Then RP has to admit that form in CA only.
No, that is the question here. The question is, first of all, see, if the RP accepts that he is an allotee, it has to be Form CA. But if the status does not change, number one, and allotment of a flat is not a final payment, it's only a promise to pay because the flat is not yet handed over. So naturally, we are talking of something which happened before CIRP. After CIRP, this thing cannot happen anyway. The RP doesn't have the power to do that. So this is prior, okay. But does it change the state? See, the validity of claim is not being questioned. Claim is there. But is that person an allotee or only on account of default, the payment is being made in kind? That is the question. Okay. The jury is still out on that. As we said, both views as of today seem valid and logical. Okay. If you have got an allotment, you become an allotee. The other view is you did start. The intent was not to be an allotee. Allotee as an FC is a special dispensation. It's not general. And hence, an OC cannot become an FC by a backdoor.
Sir, situations are very interesting. Are there any case law, any type of any NCLT regarding?
Not there. We are talking. All questions today have no final answer. That's why they are here today. For us to discuss, think about. See, case law क्या है? वो तो लॉलीपॉप दे दिया ना, खा लो. तो थोड़े दिमाग की बत्ती जलाने के लिए सेशन देना चाहिए.
I think underlying nature of the claim has to be considered, because even if an OC has an arbitration claim, for example, imagine an OC has an arbitration claim for, say, 50 lakhs. By virtue of having an arbitration award, he cannot become an FC. Yes. Because he is an underlying nature of the claim is OC.
Absolutely. Absolutely. That is the right example. A money decree does not change the character of the underlying debt.
But sir, subsequent action on the basis of such decree or right to receive money in form of debt asset swap does create a new relationship. And in that new relationship, if the creditor becomes allotee, then he has to be recognized as an allotee.
As I said, that is also one.
We see debt asset swap happening all the time, even with banks. In JP case also, banks have been proposed debt asset swap in lieu of their credit money. So this structure also is a type of debt asset swap.
Yeah, it is an swap, yes, or rather promise to pay, because swap has not happened. See, where it has already happened is anyway not in IBC, because that deal is done, over. Okay, flat constructed, handed over, khatam. But where it has not happened, it is in insolvency. The flats have yet to be completed and handed over. In which case, does that person get a right to vote as an FC or as a OC? I mean, that's the limited. Now let me put the same question slightly differently.
Sir,
एक मिनट
before you
let
go
me.
forward,
हाँ बोलो.
I just wanted to change. You spoke about the airlines and ship. Somebody had to has paid huge advance towards purchase of ship or an airline, and he is unable to pay. He becomes an OC, right?
Not unable
But
to pay.
assuming
Does that customer become an FC?
No, I'm coming to that. Yeah. Assuming that the CD is unable to deliver that, so he says that, okay, instead of me giving you, because I'm not in a position to give you either a ship or an aircraft, I will return your money with X amount of interest. Now, the nature changes because he had originally given an advance. That becomes an X. It is a similar situation here where I had supplied, he did not.
Mr. Narayana,
Yes, sir.
Mr. Narayana, the money refundable which has been received as an advance, except in the case of real estate, is treated as operational debt. Okay? It's not a financial debt. Advance received for the purchase of goods or services, when it is to be refunded as a claim, whatever be the refund amount, we are not getting it. It is classified only as operational, not as financial. That's why I said allotee is a special class. It's a class, it's a created fiction. They are not FCs. Okay. They don't lend money for the purpose of the business of the corporate debtor. The CD is not a borrower. He is only taking advance as security. Yes, he is using it partly to fund his, construction business. He need not. He might have all the money and still take advance, because that is to tie up the customer, not necessarily for funding his same project.
But sir,
yeah,
carry on. Yeah. But sir, before the commencement of CRP, if the new relationship by signing a loan document with the party who has given advance for ship has already happened, so old relationship has finished.
Yeah, now I was going to come to that variant in this question. Now, suppose instead of that, I am not able to pay you, hence take this.
Yeah.
They terminate the original thing or say, okay, you have to pay me 100.
Yeah.
I say 100 received. Now I am giving back the 100 to you for booking a flat.
Yeah.
Now does it change? So that was what I was going to come to. So it is the intent of parties which usually determines the nature of the transaction, as evidenced by whatever is on record. So if like you gave the example very rightly, if it gets converted by a deliberate act from an operational debt to a loan. So in the books of the CD, there will be two entries. The operational debt there will be an entry saying paid off. Okay. That account will be closed. A new account will be opened as a loan account in that same name.
And without exchanging money or
money doesn't have to be exchanged. Even today, where does money actually get exchanged? Some electronic data in bank from one. It's only a entry in the bank.
That is what I'm saying. Without even electronically transferring, even accounting entry. Is it okay, or we have to first pay off and then get the money?
If you ask me, on the face of it, a conversion of such a thing is a separate transaction by itself and can be considered as a change in nature.
Yes.
But again, Spade Financial will come into play. Corporate veil. What was the intent of parties? If it was deliberately done to hoodwink certain objective of law, then it needs to be gone into depth.
That is for every transaction. Intent has to be seen.
Yes.
As we rightly said, anybody can be corrupt. Intent
Yes.
can be bad. That is to be seen, looked at differently, from different perspective.
Yes. Okay. Anyone else wants to say anything, please, on this or connected to this?
I would like to.
Madam, yes, go ahead.
It's very difficult for me to keep quiet.
I know you.
Yeah. See, with respect to this FC and OC, see, the law and the provisions are very clear. FC means with respect to financial transactions. OC is supplier or service of goods or services. That nature, I think that we have to follow here. The second aspect with respect to allotment of flat, it is the nature of payment, how he is going to be paid in cash or in kind. That is the second aspect. Now, when somebody has been allotted a flat, he has not brought in money. In the case of home buyers, they have paid money in the form of advance, and the court rules that though he is a debtor in nature, he has to be treated as a creditor because he has advanced money towards construction of the flat. He is a financial creditor. But this guy has not brought money at any point of time here. It is only the supply of the goods. In my opinion, he continues to be an OC. And the flat, anyway, that's a separate issue. But I will admit him as OC. This is my first thing. Second thing, with respect to the preferential transaction, anyway, there's no, though the flat is allotted, there's no flat. He has not got it. So there's no preferential transaction. And the discounted price, again, it's not coming into picture because he didn't get the flat. So since he is OC, based on the OC claim, I think we need to admit that this is
No, madam, on the last 2 points of the avoidance transaction, okay, preferential.
Yes.
See, the payment to the extent of the amount outstanding as on the date of that allotment is deemed to have been paid. So there is a preferential payment. Even a book entry is a payment. Okay, that is there. There you can see recent judgments, especially in NCLT Mumbai. Discounted price, if at that point of time X rupees per square foot was the rate, and this was, let us say, at 80% of that, and that is back calculation, right? There will be a allotment contract. What does it say? It can also be actually undervalued. It can be. But yes, these are factual things. These are not general, because each case will have to be looked at by the RP separately. Whether something actually happened or did not happen.
Yeah, only thing is, my further clarification here is that, see, as an OC, when he is going to be admitted, the treatment of the OC, the resolution process will be for the OC as per the section 53 waterfall mechanism and all that. He is not treated as a project allottee. So, and hence this discounted price and all, I think it may not come into picture. That's how I...
No, those are two separate issues.
Separate issues. Yes.
Yeah, because irrespective of anything that happens in resolution, RP has a duty to determine avoidance transactions and take appropriate action. Okay.
Yeah, sure.
Okay. Couple of more, again, typical tricky questions. Now,
to make it interesting and lively.
Most projects, if not all, start life with a project finance from an institution. Okay. It could be a bank, it could be a financing HFC or LIC for housing, any one of them. Now, one of the conditions there is that they have charge on all the assets, etc., including land, construction whenever it takes place, receivables from the future allottees, and also that, that there is a requirement of an NOC from the original lender. If a charge in favor of a housing finance company is to be created for that allottee, suppose the allottee is taking a housing finance, that company will like a charge to be created. Now, the original lender says that my NOC is required. Now, in such a case, sometimes developers don't do this. They create the charge without taking an NOC. Now, what happens to the claim in that case? Is the allotment valid? is the creation of charge in favor of that second housing company valid? Because it did not have an NOC from the original lender. Now this hits in a way section 48 of the Transfer of Property Act. Okay. And how will the RP treat such a claim? So original lender, project lender, then a second lender who is not lender to the project but lender to the allottee. The borrower is the allottee in this case, but a charge is created on the assets of the corporate debtor. That's standard practice. Now, how will the RP treat that claim? A claim which is invalid, should it be accepted? Invalid by contract, okay? And in a way, in violation of law too, because section 48 of Transfer of Property Act is being violated.
But here you are asking the claim has to be admitted at all or not to be admitted at all?
If yes, how, what character, how will it, what priority, what category?
Since the money has already been received, only thing, the legal process of taking approval and charge creation has not happened, it will be treated as an unsecured creditor.
No, the charge has been created by the corporate debtor in favor of that housing finance company.
Okay.
Which has given the loan to the allottee. But the corporate debtor who was, because see, the original agreement is between CD.
Only NOC has not been obtained.
He has not taken NOC.
Okay.
People have faced where is it mentioned, sir, that NOC is mandatory in agreement, or where is it there mentioned?
The NOC mandatory condition is between the original lender, project lender, and the corporate debtor, even before any allottee came into being. This is very common. Huh? These are practical issues that have been culled from different people actually faced by them.
But if the new lender has lent money in good faith in the ordinary course of business, but he should have also made sure that the NOC is not obtained.
Yeah, that's one argument. Due diligence you should do.
So he has been negligent and he has given money. So why the first party should suffer? Let it be treated as unsecured debt. If you are not careful of lending money.
That is one way. But what will happen is then they in turn will now harass the borrower. See, at the end, the individual फंस जाता है. The corporate gets away, the individual gets sucked into the problems.
Naturally, it is always.
These are questions which are affecting allottees.
It is always the grass suffers, elephants fight.
Yes.
So only the poor and weak people have to suffer. The rich and mighty enjoy.
Yes.
Courts are for them.
Okay. So this is one. Again, there is an issue there.
I think quite English, but
yes. The next question is that this also happens quite frequently. Allotments are done to related parties of the corporate debtor. They could be against actual money received properly, no undervalued, nothing preferential. The booking amounts have been received. One can see, at least the books of accounts show that money has come. Now, how are such claims to be addressed by the RP? As a related party or unrelated?
They are related party. If they are covered in the definition of related party, so they will be considered as a related party. They will not have a vote to write.
No, because here they are not having individual vote. They are having vote as a class. Okay. That means their individual vote is not swaying the COC. They are part of a class.
So they will not be part of that class. Na?
So should they be removed from such class? Would that be, does it mean that in a way, indirectly, because this is not about business ultimately, remember, allotments and allottees are looked at separately because they are supposed to be personal transactions.
Yes.
They are not business transactions. Okay.
Sir, I'm sorry, I'm Rajesh Kurup. I would only say that in as much as it is an arm's length transaction, so it is only, further subject to scrutiny only. So, insofar as that arm's length relation is maintained, I think that intricacy has not to be added into this case. It has not to come as a spoke in between.
That has to be, yes. That is also right, because if it has been done at arm's length in normal course of business, they happen to be relative, that is different part as per law,
Yes. So exactly what Mr. Kurup said is that because treat it as a personal transaction, not a business transaction. Effectively, that's what you're saying. And hence that strictness of related party and COC should not apply here. That's one view.
Yes.
Okay. Again, as I said, question mark, because as of today, the literal reading of the law will say related party out, no voting right.
So, but in that case, justice will not be done to them.
Exactly. So, is justice done by literal reading? That's why all these questions. These are questions which are related to justice side, not so much as law side. All the answers have already been given in last 7 years. Now we are going to the next step.
Similarly, sir, let me stop you for a moment. Similarly, the earlier that issue which you broached, that regarding that NOC matter, that also can be seen from a different perspective, because consideration has not to be moved to the same party. So far as that consideration is to a third party, also, it's a matter to be fought between them. I mean to say that if from the original, that banker whom you cited, an NOC has not to be obtained, that is a matter further to be looked into. It has not to, taint the, on the face of it. I think that has not to change the capacity. If you get my point, I was only saying in this.
Okay, let me just say the allottee is not affected here. The allottee's lender is affected here. Okay, not the allottee. Allottee per se has got the allotment. There is nothing, no doubt about it. Money has come in. The allotment has been given to him. X money come, Y is back. But the allottee's lender will file a claim because he's been the, he has got a charge here. And maybe, especially for interest subvention, they never do it for the entire principal amount because that's not allowed. The subvention amount, when they file the claim, will it be treated as secured or unsecured? Okay.
Sir, here what would be the status of an allottee who has got an NOC also from the financial lender? To that extent, the charge would be released in his favor, sir?
No, sorry, I couldn't understand that. Allottee who...
Allottee also has an option. For example, an allottee at the time of allotment insists for an NOC from the lender. At the time of
if the allottee is aware of it, yes, this is again, because these are not strict point of law. Allottees being individuals are generally not even aware that such things may exist between the developer and a previous lender.
They give, sir, they give.
Huh?
They give, sir, NOC.
I know they give. When you ask, it will be given. I'm not saying that. I'm saying where it has not been received, then how do you tackle them? Where it is already there, there is no question. No, it's done. But where the promoters of the project have fraudulently not taken it because of their own issues with the original lender, it usually happens because of that. They might have defaulted there. And the lender might be refusing to give till that default is corrected. And that is when they create these charges and they do it all the time. Then what is the status of this second lender?
Sir, I have one query in relation to the allottees who has received the possession, but the registry is pending, and sometimes even they got the possession without occupancy certificate or other legal norms. So how to deal with these sort of allottees?
Okay, you are raising questions which impact different laws and how they will apply. So any transfer of a flat or any such unit cannot be done without complying with all applicable laws. That would include the municipal laws which relate to CC and OC. Okay, completion certificate and occupancy certificate. So if something has been done in that manner, it's an illegal transfer.
Yes.
It's a transfer void in law. Okay. Now again the question will come justice. Law says allotee does not have the right yet of taking it. Justice might say, but he has paid everything. He has got it. Wrongdoing is of the promoter and they should be proceeded. So IBC cannot answer this question. This is civil law. Maybe RERA can to some extent by passing appropriate order, maybe deeming allotment on their own. They have the authority. IBC does not have the authority to do anything which relates to other laws.
No, sir, we can segregate, for the sake of better discussion. The allottees who received the possession after obtaining occupancy certificate, registries is still pending. One category could be this. And another category could be that they got the possession without complying with local laws, which is no doubt is an illegal position. So to my limited
understanding, distinguish between, okay. In the first case where you are saying everything else is okay, only registration is done. Now registration is one way of looking at it is it's only a formality that is to be completed, legal formality, and of evidentiary value, and also tax implication because stamp duty will come. Stamp duty has to be paid. So an occupation where the document of title is not clear. Now, how will that be treated? Will that even be a legal occupation? The answer would maybe no. In IBC, at least to the best of my knowledge that I am aware, there have been cases where RPs have executed the registration after taking approval of both COC and NCLT. NCLTs have allowed that registration be completed when everything else is done, because somebody should not be put to suffering for the procedural requirements of another proceeding.
Yeah, so and the company has to maintain going concern status
also. When we are treating possession without OC as illegal, in that case, the RP should claim with 100% value.
Without OC is now a question mark. The first where other laws are complied with, it is only a paperwork. Now, where the law is not complied with, which means the possession is illegal, it is this, the status of that person is that of a, like an encroacher, not exactly on his own, but with the, being pushed to be an encroacher by the original developer. Now, in that case, if the payment has been made in full, and OC and CC and OC can be obtained during CIRP, and the RP is able to do that, then that should be done. And this has happened. JP Infratech is again a classic case where they have done all these things, and they have given hundreds of, possession and registrations done during the CRP itself.
Because it has to be done. CRP continues for years. The company has to be maintained as a going concern. The life will not
it's
stop.
Not just about going concern. This is whether you are in a position to do such things.
No, you have to, whatever approvals are pending, you have to obtain, because
no, the approvals might require work to be done. For example, completion of the construction, then all the amenities that are required, etc., etc. And whether the RP has that funding available to do all those things.
Sir, that is a part of maintaining the company as a going concern, na?
पैसे लगते हैं ना बोलने के लिए
पैसा इकट्ठा करना भी part of the going concern है ना? You have to mobilize funds. Everything has to continue.
किसको मिलता है? Can you tell how many examples are there where money has been raised for operations? Not minor CRP cost like legal fees, etc., but for actual operations, working capital funding. It will be probably fingers of one hand would be more than enough to count.
Anyway, sir, my question was restricted to the collation of claims, not related to the going concern. That will be dealt by respective.
I think collation of claims में तो आपको claim ही पकड़ना पड़ेगा, even if the possession is there. This is like your property is in somebody else's custody or something like that, and claim is there. Claim तो आपको admit करना पड़ेगा.
ठीक है.
Claim doesn't vanish, but with a remark. it will become a classification where possession has gone, and in a way, that's a claim where there might be money receivable but not payable. In fact, ulta ho sakta hai. It could be, yeah. It could
Thank
be.
you, sir. Thank you.
Okay, we talked of related parties, both sides. Yes, we know that. If they are related party, voting right issue, etc., they are related. Now, suppose this related party allottee is not an individual but a corporate. LLP ho, company ho, and there are quite a few of such which are, let us say, incorporated by the developer himself, and to whom flats could be allotted as a means of raising money. Maybe even sold, but definitely allotted. And such allottee companies go into CRP or liquidation. Now they also file a claim. The RP or the liquidator will file. Would that be treated as a related party claim? Or should it be treated as a related party claim? Kya lagta hai? Okay. So there is developer A, corporate debtor. There is company B, related party of the corporate debtor, which also goes into insolvency but happens to be an allottee of one or more units in the same project. Now A and B are both undergoing CRP separately for their own defaults. Now in this situation, the RP of B files a claim with the RP of A. So RP A should they treat that claim as a related party claim or as an unrelated party claim?
So the CIRP or liquidation cannot change the nature of the related party. Related
That
party
is one
always a
approach.
related
That is the
party.
easy one. Yeah. That is the easy one. That's the easy thing to say. Okay. Now I will tell you. Okay. I will add to that. The RP or liquidator of a company holds the assets of that company in trust. So in a way, that person is acting like a trustee. For the benefit of whom? Not the promoters. For the benefit of all stakeholders, especially creditors. That is understood, that when the RP takes over or liquidator, subsequently, all the assets of that are firstly for the benefit of the creditors of the company, in that order. Now, when the benefit is primarily for creditors and not the related party, promoter, then does the nature of related party continue during such a situation? One can extend the same thing to an asset under receivership. Same thing. Same concept.
Related party. Related
Yeah,
party.
Haniji. Madam, 1 second. Haniji, bolo.
An LOT, the definition is that of a person. Person can be an individual or a corporate entity or a LLP. Whatever rights are available to a person or individual should be available to an entity also.
The question was not whether that right is available. Claim will be filed. Whether the RP of the developer will treat him as a related party or not.
It will not. See, you asked this question in the earlier thing. The related party, this entire issue of an LOT, is a kind of a construct which is only on social grounds it has been, kind of created. And they are specially given a certain amount of right via the other creditors. Now, that LOT is actually a person. The person could be a corporate person also.
That is okay. No, that was not the question. The question was not whether it can be. There are many cases where they are corporate persons. And when in such a case, if a claim is filed with the project where the project developer is a related party, then will the RP of that the project company treat this claim as a related party claim? Or because it is under CRP and liquidation, does it lose the related party status?
Correct. So in the discussion in point number 9, you had talked about the allotment done to related parties.
Yeah.
Where the same discussion, that same conclusion that particular conclusion will be applicable to the point number 11 also.
Slight difference, because in 9, they are still, those allottees continue to be related parties because they are in that status. In 11, this originally related party is now taken over under NCLT by the RP or the liquidator. The promoter or the original has no say in it, nor entitlement to any proceeds from that except as the residuary right at the bottom. And because an RP or liquidator is considered to be equivalent of a trustee, assets held in trust in a way. So, because trustees and trust assets are exempt from the related party status, even under IBC. So, will RP and liquidator be treated as a trustee, and hence any claim filed by them in that capacity cannot be treated as a related party claim? This is still a live question, no?
Yeah, exactly. So, from my experience, you have been, at least in my cases, even if the entity who has filed a claim is now being represented by an RP or a liquidator, the status of it being a related party does not change.
Yeah, that's yes.
We have been going ahead on that basis. So I guess the same principle can be held in this.
These are all open-ended questions because there are no definitive judgment. That's why we are talking about it. What could, what are the arguments for, what are the arguments against? And both sides are right, but one ultimately will be more right than the other. So which one is that? And that also changes with time. We know that. Judgments get overturned all the time.
So in case of an IBB inspection, tomorrow if they say you have treated the claim in one place in so this manner, how are you treating it differently in other? So be consistent internally with myself. At least.
Yes, I understand that. Yes. In fact, this question 11 is related to my cases, and I have taken the stand that I am not a related party. It's still to be adjudicated because the case itself is under litigation. So यहाँ तक पहुंचे ही नहीं हम लोग, but it's there.
Right. I have encountered the situation in a normal operational creditor situation, not as a real estate.
Yeah. See, when it comes to normal OCs, question doesn't arise too much, but because anyway they are not part of the CFC, related unrelated does not make a difference. Even otherwise in liquidation, it does not make a difference. It's only in CRP because of resolution plans that it might make a difference because an RA might treat the two differently.
Sir, I would like to point out here, as an RP or as liquidator, I have stepped into the shoes of the promoter and running the company because the promoters or directors are suspended.
No, madam. You are not stepping into the shoes of the promoter at all. That's a wrong understanding.
I am representing the company.
No, you are representing the company by as a court-appointed person, which is not stepping into the shoes of the promoter. That's.
I am representing the CD. I am representing the CD.
The company, but not the promoter.
But when the company is a related party, when I am representing the CD, I am a related party. Whether I file a claim or not, I am still a related party, isn't it?
As I said, but that's one view. That is the lateral view. Then there is the one layer below. When such tricky questions come up, that is when you peel off the first layer and see, does the second layer say something different? And then between them tally. For example, now the Chelani judgment. Okay, we will be talking about it later. At that time, we will cover this as to how thought process changes with time and what was thought to be one and held to be so by many orders of NCLT across, and now has been struck down by the Supreme Court saying something else is the interpretation. Okay, so we will go to the next.
Sandeep Singhal here.
Haji, boliye.
Do we have any judgments on the point number 11 related party during CIRP or liquidation?
No judgment yet. Not that I'm aware of. As I said, because my case, so I've been trying to keep track of it. But to the best of my knowledge, no judgment yet.
Because I am also affected. I have already filed a case being a RP, but it has been taken as a related party by the other RP.
Okay. So there is an interesting argument to be made that you are not a related party. But it's a tricky one because if 12A happens, then what? You know? Okay, 12A, forget it. But if it is an MSME, then the promoter is allowed to submit a plan, and then the promoter steps into the shoe, then what? So something similar to 32A. The answer is somewhere there in 32A. When I say that it is in 32A, it is the principle under which 32A has been formulated.
Intent.
Yeah, because it distinguishes between who comes in and who comes out, whether the exemption or the immunity is available or not.
Okay, one more challenge during the CIRP related party was established, and during the continuation of CIRP, one of the other party, which is the related party, goes into CIRP and the RP files the claim later on. Then the position changes.
No, at the time when the RP takes over, does it change? That's the question. Does the relationship sever? Then does it sever at the time of resolution plan? Or does it sever when liquidation is ordered? So these are three different stages. Is this relationship continuing or does it sever at any point of time? Now that is not yet answered. No, there is no answer yet. So we are only talking of what is our thought, our arguments. जो answer है उसमें यहाँ क्या बात करना है? The answer is already there. Why we need a session to read what is already there.
Maybe I thought you had some answers.
Oh, no. I made it clear in the beginning. All the questions that I have are those for which there are no final answers. Or there could be two sides of the coin. And when I say final, I'm not saying right. I'm saying final. Because there is a difference between what is right and what is final.
Yes.
Article 141 is final, not necessarily right. Okay, somewhat related to what we had covered earlier. And this is now the next step. Project-wise insolvency, yes, we talked possible, not possible. But what about separate resolutions plans for each project? Again, part of a discussion paper which was floated about. And sooner or later, I think regulations will come. But we can talk about the practicalities of it. Because what happens to the company as a whole? Okay, there are 5 projects. There are bidders for 4 of them. 5th one, orphan. Nobody wants it because it's got too many problems, too many issues, not enough, upside. Or maybe it is at a very fag end of the completion and nothing much is left for any third party to come in. But an RA will come when there is a commercial benefit that is there. So, should there be resolution plans for each project? If so, who will be holding the baby called the corporate debtor at the end of it after certain projects are hived off? And how will that happen? Demerger? If so, in what manner? Will it be treated as a project sale, slump sale, asset sale? Any thoughts? Okay, we'll come back to it if there are any thoughts on that. Next question, relatively easier, I would presume. Orders of RERA with respect to interest and compensation. How are they to be treated by the RP and liquidator? Then now this is about claim admission, claim verification and admission. How is this being done? I mean, if RERA order specifies a certain rate of interest, and also compensation. Compensation and interest in RERA are two different components coming under two different provisions. How is that treated by NRP while admitting claim? Which part of it is treated as financial debt for voting share purpose? Which is not, if something is not treated as financial debt? What is the actual experience? How are people treating this?
Sir, can I talk?
Of course, of course.
Okay. See, with respect to this interest given by the RERA orders and all that, they talk about 10%, 15%, things like that. I have been seeing the orders.
No,
However,
they follow a certain law. There is a law in RERA.
I agree. I completely agree.
Yeah.
However, with respect to the claims to be admitted, with respect to principal and interest, we are bound by our IBC rules and regulations. In fact, I'm just...
What does the IBC regulations say on interest?
The IBC, with respect to the claims, let me just finish this. See, in the AR part, somewhere it says 8% interest. Yeah, unless otherwise there's an agreement of a different amount between the parties. Now, I also observed, in fact, this is how I follow in my case. With respect to claims by creditors, the documents, what are the relevant documents? It says records available with information utility, and then agreement for sale, letter of allotment, receipt of payment made, such are the documents evidencing interest, evidence of existence of debt. And under the AR part, it talks about 8% interest unless the different rate is agreed by the parties. Now, if I look at the next part, claims by workmen and employees, it talks about with respect to admission, what are the documents? It says order of a court or tribunal, which is missing in the claims by creditors in the clause. So what I take a call is that unless the agreement says 15% or 12%, we allow only 8% interest because 8% is as per IBC. So if there's a RERA document which takes 10%, I don't consider that because the documentation with respect to the admission of a claim does not talk about an orders of a court or tribunal, which is considered in the workman case, but not in the class of creditors case. This is how I go about, sir.
Okay. Any other add on to that?
Sir, this interest and compensation, that is to the allottees, not to RERA.
Under RERA, an allottee who is got a grievance against the developer or promoter can go to RERA for a relief. And RERA can award you interest for delay. It can also award you compensation. Now, compensation is on a different footing than interest. Okay. And they are forming under two different provisions of RERA. They are also determined in a different way. For the purpose of compensation, a particular officer needs to be appointed who will adjudicate how much compensation is required. Where the question of interest, then it is the specified rate, State Bank of India rate or something like that is mentioned in RERA, which will be followed by the tribunal.
Sir, I have the opinion about this, sir.
One second. हम तो opinion सुनने के लिए बैठे हैं. So that is how the interest part is there. So interest and compensation in RERA are two different things. Yes, Mr. Gurjar, बोलिए. बाबूलाल जी, बोलिए. Hello, can't hear you.
Yes, sir. I have opinion.
Come closer to the mic. There seems to be some problem there. Your voice is not coming through. Your mic is defective. Yeah. Hello.
Yes, sir.
हाँ, बोलिए.
Sir, I was telling if RERA order is before commencement of CIRP, then we must consider the rate of interest mentioned in RERA order.
Okay. Okay. You are saying RERA order should be taken, cognizance should be taken of that. Yes.
Why not? That is the regulatory authority.
Yes. Okay. Anything else?
Sir, as per me, suppose there are two allottees, same plate, same amount. One has moved to the RERA, another has not gone. Then due to his order of interest and compensation, his claim will be higher. It means, whereas as per Vishal Chelani, one say allottee, always an allottee, and he is also to be treated even after order of the RERA or compensation or any, then
Yeah,
he will
Vishal
be...
Chelani is on a different thing, but yes, we will come to that. Yeah.
No, but I am to tell that when he is to be treated as a allottee, when compensation allowed, then he is some amount has been allowed, then both should be at par, na? Even if order has been given, I think.
Yeah, I mean, that's also one view.
Actually, orders which are received after declaration of moratorium cannot be entertained. But the order is before
that order is before
moratorium and order confuse mat kariye, dono bilkul alag hain.
That is
okay. Yeah. Order of RERA or any court by in the nature of a decree, the execution is barred by moratorium, not the pronouncement of the decree.
Yes.
Okay. Dono mein farak hai. Don't confuse the two. Orders can always be passed.
But then we will follow that. If it is
No, the thing that one needs to understand is that what is a order of a regulatory authority like RERA? It is treated as a decree. What does a decree do? It settles the claim, crystallizes. Okay, there are two parts to decree. One, crystallization of the claim amount. Second part is execution, which is the enforcement part. Now, obviously, in CIRP, enforcement is barred, but crystallization is not barred. Now, somebody A has gone to a regulatory authority with a grievance. B, having the same grievance, has not bothered to go. So, take any case, general law. The one who goes to court gets relief. Bahar wale ko nahi milta. So, law in general says those who are not vigilant about their rights, the law will not take care of them. So, the discrimination of treatment is not discrimination. It is because of the choice of the person not to take relief.
Exactly, sir.
Okay. So, that part is discrimination is not there. Okay.
Exactly.
Now, coming to which interest rate, whether IBC overrides, because we sort of have been, most of us, which is true for almost all IPs, we are new to law. Any law for that matter, and the intricacies of law, and especially what is called this non-obstante clause. Now take up any act of the last 40-50 years, any state level, central level. Almost all of them will have a section or a clause similar to this. And if you take up Companies Act, the non-obstante clause probably appears about 150 times in the same act. Okay. The interpretation of that is that it overrides only when there is a conflict. Now, is there a conflict when RERA gives a certain rate? Because first of all, the rate in IBC is through regulation, not the Parent Act. The Parent Act, whether it even allows specifying such a rate by IBBI is a question mark. Second, if you read that provision, which talks of 8%, in case no other interest is specified, which means they are giving primacy to the rate agreed by contract. Now, contract is settled in a dispute forum called RERA. So, the decree by RERA or an order by RERA is related to the contract per se. They can't go out of that, plus whatever the stipulations of law. So, when there is and then there is a specific provision in the code that the RP shall comply with all laws. All laws. There is no exception. Okay, RERA is a law which is in force. So, unless the decree of RERA is clearly contradictory to any provision of IBC, then harmonious construction rule will apply. Both should be implemented. So, if somebody comes with a 12% decree from RERA, 12% interest rate, and then it will not apply. Because if you look at that regulation of 8, what is the purpose of that 8%? It is a deeming fiction to place you on par, to take care of the time value of money which was inherently there when declaring an allotee as an FC. How do you bring that time value? That is only to provide, because people would have paid different amounts at different points of time. Somebody has paid in year 2000, another has paid in 2010. Now both cannot be put on the same footing as far as their claim and vote share is concerned. That is why 8% is there. That in the absence of anything, what to do? Okay, 8%, like that.
So we can take the rate of interest as decided by RERA.
A court order supersedes everything.
Yes.
Everything. It has to be challenged by somebody. That it could be set aside. That's different. As long as it is not set aside, modified, or otherwise withdrawn, every order of every court is to be adhered to. One should not look at the size of the court or the level of hierarchy and decide whether which law to follow and which should not. No, that discretion is not available to any citizen. Now we come to Vishal Chilan. Okay, since very recent, I think most people would have read. And what was the issue in Vishal Chilan? Anybody who has read this can please. Yes. Yeah, we have 73 logins and I think how many? Maybe 5 attendees. So 68 are proxy.
Is it so, sir?
Hello?
Is it so that majority of them are proxies only?
Usually, yes.
Okay.
No, it's
They are good listeners, sir.
When a program has CPRs, then this is the problem.
No, they are good listeners, sir.
They are very good listeners. We will be generous and call them good listeners. Yes.
Most of them shy away.
Ganti sir, one question which
हाँ जी श्रवण बोलिए.
घंटी सर अभी हम लोग बात कर रहे थे ना कि जो रेरा के ऑर्डर्स हैं ये दिस कैन बी द प्रोसीडिंग्स कैन बी कंटिन्यूड इन बिटवीन ना इन सीआरपी ड्यूरिंग द सीआरपी प्रोसेस बट कैन नॉट बी एनफोर्स्ड राइट.
A decree of RERA, it depends on what the decree is. If it is crystallizing the claim amount, it becomes claim, nothing more.
But to my understanding, what I was, I am of the opinion that even proceedings cannot continue.
It depends on the type of proceeding. Okay, if there has been a proceeding, actually speaking, the need for continuation of it is not 238 which comes into play. It is the fact that an alternate remedy has been now put in place, and hence double jurisdiction cannot apply. That is the one which applies here. So, what are the grievances of allottees? Bhai, mere flat chahiye, theek hai. RERA to dilwaega nahi because company is under CIRP. It will have to be by way of a resolution here only. Second is, what about my money? So there you are going to crystallize your claim. Here there is a provision which decides how to crystallize your claim. So once this remedy comes into place, it supersedes that. So the general thing that all proceedings should stop, that is not true. But RERA proceedings which are related to this part of it, they would not continue because a different remedy has now put in place. The third one is about compensation. Now, compensation, obviously, such proceedings cannot continue once IBC starts because those are prohibited because they will impose additional burden on the CD, which is not there as on insolvency commencement date. So, indirectly, the proceedings cannot continue. It is not directly that all proceedings stop. No, RERA proceedings will stop because all that happens in RERA is now going to happen in IBC. But any decree received prior to that is a crystallization of the amount due. That's it. Nothing more.
Okay.
But one question remains, how will you treat compensation? So if the decree has a principal amount, it has got an interest component, and it has got a separate decree for compensation. Maybe same, maybe separate. How do you treat compensation in claim admission?
At par with the claim amount?
No, is compensation time value of money?
Okay.
Compensation is in the nature of damages, etc. I mean, compensation for harm done. So it would still be a claim which is admissible.
As OC, as a claim
But
of
it
the,
will be different. Yes, it'll be an OC. Yes, exactly.
We are discussing this treatment of compensation for the purpose of admission of petition or for the purpose of
Admission of claim. Admission of claim.
Admission, because this was discussed in the morning session as well. There were two schools of thought that there's some home buyers have the orders of RERA, they come up with their claim or with the 20 lakh rupees. Some come with the 10 lakh rupees. So this was a question we discussed in the morning.
What is the order saying is important. What are the facts of the order? How much of the principal? How much is interest? How much is compensation?
If I have paid 10 lakh to the company, usually the order says 10 lakh will be refunded along with the interest of this percentage plus this and this. So the point for discussion point in the morning as well was this only, whether RP should admit only the amount which is in the books of the accounts of the corporate debtor, or this order which could have been appealed by the CD had this CRP had not started. We were discussing this only in the morning.
See, the books of accounts of the corporate debtor are closer to fiction than reality in most cases. Okay. Yeah. They are not, see, when there is a court order, it supersedes everything.
Let's assume the principal amount matches with the books of accounts of the company. The question comes whether compensation should be admitted by the RP or not. This was the...
No, just now we discussed that interest, yes. Compensation, also yes, but not as FC. As OC. See, compensation, you have gone, it's like an arbitration claim. You have got an award in your favor. Now, if it is an award of a nature of financial debt, it will be financial. If it is in the nature of operational debt, in which is the case here, because what is compensation under RERA? It is not interest, time value of money. It is very, very specific, not always ordered, very, very rare, and very specific conditions have to be fulfilled. The procedure is different also. There is an officer appointed who will go into the merits of compensation, decide that separately, which is different from the bench deciding on principal and interest. So compensation is for damages suffered. Ultimately, the word itself defines what it is. Interest is time value of money. Compensation is harm suffered being compensated. So that part does not form part of the financial. But it is a claim. And it needs to be admitted if there is an order. Except that it will fall in a lower in priority. It will not form part of vote share also. Okay. It cannot be used for initiating a Section 7 application because only the basic debt is allowed there, not other claims. Because this comes under, actually speaking, it is not even OC, it is Form F.
But sir, other such type of adjudication by RP is required. For example, if the claim is given by a home buyer. Hello?
Yes, listening. Go ahead.
Yeah, if the claim is submitted by a home buyer who has an arbitration award also, and does an RP needs to look into the adjudication of the nature of the claim, because the original nature of the claim itself is a home buyer giving a claim. So by virtue of a home buyer giving a claim,
buyer giving a claim, see, the RP is not doing adjudication, he is doing segregation. Segregation is fully allowed. Okay, you can separate apples and oranges, but you can't decide which apple is better than the other apple or better than the orange. That you can't.
So that means in addition to interest part, any penalty for delay petition will also be in operational category.
See, first of all, the word penalty is not used, it's compensation by RERA. It has to be by the process followed. Now, there has to be an order of the relevant tribunal, which is the RERA having jurisdiction over that project. So, if you have that order, which has all these three components, then principal and interest will form part of the vote share. Compensation will not, because it is not time value of money.
No, I'm talking different, sir. Here, some of the flat agreements provide for penalty for delayed position. Say
Penalty for delayed in the contract you are talking of, the agreement
contract,
itself.
yeah.
Yes,
In
how are
addition
they?
to interest,
How are they to be treated? That
this
is,
separate.
yeah. I have no answer, frankly, because there are arguments on both sides, and a definitive judgment is not there yet on that.
And whether it should be allowed in claim or not.
See, it is a claim. See, the only question remains in which category it will fall. Okay, because that will have an impact on the voting. So
But
if you treat it as operation, see, first of all, penalty for delay. Is it same as interest? Now, there is a recent Mumbai NCLT judgment on the use of the word penalty and whether penalty means something beyond operation, normal operational date. So they have said, don't go by just the word used. Look at what is the intent behind it. If it is compensating for time value of money, then it is interest by other, just using a different name. But if it is going beyond that, like penal interest, for example, or liquidated damages. Now, are they time value of money? No, they are basically what you call penalties for defaults or not following certain. So it depends, facts of the case. What is this penalty? The word penalty used. Is it just another name for interest? Because when does this happen? Usually when this is per square foot. It's not by percentage. Per square foot up with penalty milega. Things like that. Yes, that is when this happens. Is it still interest or time value of money? Facts of the case would matter, but it appears to be time value of money. If it is payable, one, without discrimination to all, that means it's not of a preferential nature, and two, with very clear cutoff or trigger point. It should not be a judgmental thing.
Sir, I am Rajesh Kurup. I have something to add here. In the Indian jurisprudence, I think this penalty in the contractual relation is a misnomer, because there again it is only a question of liquidated damages. That is, whatever loss has been suffered, that is sought to be compensated. So if seen from that angle, what you had earlier referred, that vis-a-vis the compensation, that holds good here also. He might have referred to it as penalty, because penalty doesn't hold good. As again, at the risk of repetition, the Indian jurisprudence doesn't admit that, because it is only liquidated damages. Either damages are agreed to by the contracting parties, or if nothing has been agreed to, liquidated damages concept admits that, you see, whatever loss has been suffered, that is sought to be compensated. So seeing from that angle, whatever you had referred to earlier as compensation, that holds good here also.
That is true, but see, I have seen these contracts, so I am talking a little from experience, where the drafting intends it to be time value of money, not liquidated damage. Intends to be time value of money, in which case it could be. As I said, please refer to the Samruddha Resources case recently, NCLT Mumbai, where the word penalty used in a contract of supply of goods was treated to be part of pricing and not a penalty per se.
Sir, I have one query.
Yes.
It might be a little away from the discussion that we are having. Supposing I am a real estate company, I am into CIRP. As a business, I have also leased out a part of the equipment to another real estate company.
Part of the equipment?
Part of the equipment that we have.
Okay.
The real estate company, as you know, they have.
They use. Yeah.
Now, what happens then? Now the rental payable by the other real estate company is 1 crore per month.
Right.
Now on default of 4 installments of 1 crore each, this company has initiated CARP.
Okay.
Application was filed.
Right.
By the time application was admitted, another 14 installments have become due and payable.
Right.
Now, after admission of the application, commencement of CARP, appointment of an IRP, the promoter pays the 4 installments that are mentioned in the application and says that you withdraw the application. Now, what should the IRP do in this case? Because he is the applicant.
No, it's nothing for the IRP to do.
Yeah.
IRP has no role.
No, the operational creditor is a company under CARP and the application is pursued by the IRP.
No. See, first of all, IRP is a custodian trustee, not an interested party. Okay. So there is a claim made now by the promoter that I have paid that the default no longer exists.
Right.
It may exist, but the default does not exist as on the date of filing of the petition. Okay. That's what his claim is. Now, who is to decide such question? Only NCLT, nobody else.
No. What happens? Let me help you out with a little more specifics of the case. Now, the NCLT held that there is no settlement because all the dues are not paid. And as you know, even NCLT has no power to force settlement once the CARP is
That's okay. Yeah. Okay.
Now, the question of law for consideration is, does the payment of amount mentioned in the application discharge the entire liability of the operational creditor who has paid? Because the liability is...
No, that it doesn't. Okay.
No.
Okay, let me answer that. No, the discharge doesn't happen. Look back at section 12A. Okay, very carefully. There is no mention of the word settlement. There is no mention of what will be the reason for 12A. And it is deliberate. It is not oversight.
Right.
Why you want to withdraw, they don't care. They say, we don't care. That, okay, prior to admission of the petition, NCLT will look into it, payment between the two parties. If the parties are willing to withdraw, fine. Post admission and before formation of COC, again NCLT has been given, extraordinary jurisdiction by judgment of Supreme Court that you can. Okay.
Yeah.
Then comes the third part where COC is already formed. Now, when COC is formed, once COC is formed, it is the prerogative of COC to vote on 12. If they vote by 90%, end of story. It doesn't have to be settlement. Not even a rupee to be paid by one to the other for a withdrawal. Because the law does not require it. It is only people have to agree. And that agreement could be, okay, there is default. This is too small to push the whole company into insolvency. We are not of the opinion that it should be dragged into it. By 90%, we are saying no. You, whoever initiated this, you have a debt. Maybe it is settled, not settled, disputed, undisputed. You have other remedies in law. Go and tap them. Insolvency is not a tool for
recovery mechanism.
So
in this case, can the shareholder or promoter who has settled the application amount mentioned in the application,
he has to apply to the RP for a withdrawal under 12A. RP will put it to COC. COC will decide. Khatam.
Right. So it cannot be a prerogative of any of the stakeholders.
There is nothing, no prerogative exists. 12A is the only, see, there is another which is 65.
Right.
Okay. Section 65 is a different set of facts altogether. That's a fraudulent initiation.
Right.
That's a purely legal issue.
Correct.
Okay. This is a commercial issue. Payment in part or full is a commercial matter.
Right.
That is covered indirectly, not directly, indirectly under 12A. Because 12A does not talk of reasons for withdrawal.
Right. That's a
And
valid
it is
point.
deliberately so. It is not oversight.
Correct, sir. I got it. Thank you so much.
Sir,
Haji.
sir, after admission, before formation of COC, you were speaking, I could not listen properly, sir. Withdrawal.
It is still NCLT jurisdiction. The RP or IRP will take it to NCLT when an application is made. Yeah. Okay. Now Vishal Chalani, we were talking. Anybody has read Vishal Chalani? Huh?
They briefly read, sir, regarding that UP RERA, some penalty has been, decision has been given regarding interest and other things. And RP has treated it as separate from the home buyers claim. That is there, I think, that NCLT,
Okay. Now this is
like that.
Whatever we have been discussing, more or less, this is what is there in this judgment. That this is a case of a particular allottee who has got a RERA order in his favor. Okay. For refund of an amount with interest and maybe compensation, I don't know that. Now the RP said, you have got a refund order. So you have ceased to be an allottee the moment you got the refund order. And Supreme Court said, no. Till the amount is paid, he is an allottee. Or in insolvency, whatever is payable in cash or kind to that person, the person continues to be an allottee. And they had a very interesting sentence. This is very important. That only an allottee can approach RERA. So just by approaching the regulatory forum which gives justice to you, you lose your character, doesn't happen. That is an illogical interpretation of law. And that's why the word is once an allottee, always an allottee is because an allottee is somebody who is yet to get the allotment. So till such time or get the refund. Both. It could either be allotment, actual possession of the flat or refund in case it cannot be constructed for whatever reason. So till that time, you continue to be an allottee. You don't lose your status just because there is a decree of an amount of refund. And they have used these words also that it is only a crystallization of the claim amount, nothing more. No change of status.
That means still that will be considered as home buyer.
Yeah, allottee means home buyer. Home buyer is not the technical term allottee. Okay.
Okay.
The reason why we say allottee and
Got your point, sir. Got your point.
now
another example.
One second. The reason we say allottee and the right way to say allottee and not home buyer is even those who are allotted commercial units within the real estate project are also allottees. Okay, not just home buyers. That's why home buyer only one class of allottees. The entire allotee space.
Another diversion is there.
Become closer to the mic. Your voice is faint.
Yes, sir. Another diversion in this, some buyback arrangement. In case of
buyback arrangement, okay.
Buyback arrangement. Actually, what happens is builder gives advance checks for a refund of money for after a certain time. So the allottee lodges the checks in the bank, and these are returned back. So whether it will continue as a allottee or now it will be unsecured financial creditor.
No, 1 second. You are talking about builder gives a check for what?
For taking back the flat.
You mean as a refund?
Yeah, as a refund.
And the refund check has bounced.
Bounced.
So you are still continue, the status does not change. See, the transaction is not complete. How can the status change just by issue of a check? फिर तो आए दिन लोग check issue कर देंगे और status change हो जाएगा. No. The check has not fulfilled its purpose. It is as good as not having been issued.
Balance sheet में unsecured financial creditor बता रहा है.
नहीं, balance sheet में देखिए, balance sheet borrower बनाता है. Okay. He can't unilaterally change the status of the lender or the allottee or whoever, the creditor. Okay.
Right. Okay. Got a point.
Yeah, no claims, delayed claims. I'm sure everybody has faced this issue. Not an easy thing to find out, but this is where books of accounts generally relied on. Sometimes the books are not available, documents available with RERA, if any, etc. Okay, land owned by third party and leased to the CD. Yes, somebody wanted to raise this issue. Land. You're there?
Yes, I'm there.
Yes. Boli.
No, I had raised initially. You say you will discuss this later on.
Yeah. Either hai. Abhi now the time has come. So you want to say something on that?
No. What I was saying, there are two things. That usually the landowner and the land developers are separate entities.
Yeah.
Of the same promoter.
Right.
You know, at times the land is owned by the government authorities.
Right.
So in that case, the Supreme Court has already decided that the dues are to be treated as operational creditors. But when the landowner is a separate entity owned by the same promoter under the same management,
right.
So my view was that a joint CRP of all entities involved should be initiated. Then only the CRP of the the developer company will be possible. Because if the landowner starts asking for the land back, you know, then the CRP will not be over.
Suppose that the landowner is an unrelated party.
Even if it is unrelated party,
there is no question of CRP, it belongs to the government, some agency.
Then in that case, it has been decided that the lease dues, the lease rentals, whatever is the payable.
Forget that part. Going forward, can they ask for the land back?
No, they cannot ask for land back.
Why?
Because the objective was the rights have been given not for 1 year. The rights have been given for 99 years and onwards. You know, renewable. Even
suppose
after 99 years.
Suppose the lease agreement has the clause which allows them to seek the land back, reversion of that, on certain defaults or whatever occurring in events of default, which have occurred. Okay. Insolvency doesn't obliterate the default. It only tries to resolve it. Okay. Now, I as a land authority, okay, government authority, I want my land back. I say your past whatever behavior is not in line with being a good what do you call debtor.
I am not remembering the judgment, but the objective of the authority is not to get into
self-purchase. I know there is a particular judgment that I'm also aware where they said both should be done together, otherwise resolution cannot happen.
Because the objective of the authority is to develop the area. And perpetuity of the land is a precondition. You know, so if they are not there to sell purchase land, they are there to develop that area.
Okay, that's see there is an equally opposite view. Public money looto or private gain could
that is happening.
That is equally important.
That is happening in most of the aspects of the life.
In fact, most cases that's what happens.
That is if that is the case, 10 lakh crore have been written off by the public sector banks in last 5 years.
Yes.
So that is the public money.
Exactly.
So, billions of rupees government has spent on projects which are waste, which are not completed.
But irrespective of who is the landowner, what is the status of the landowner is like a joint promoter.
Yes. So you because
it is a joint venture which is not necessarily called by that name.
Yes, and it cannot be taken because if you take the land back, whatever you have constructed, will you demolish it? You will not demolish it. It is forever. It is forever. Even in the process, you have looted, some people have looted, that is beside the process. But you will not allow further destruction to happen. Willingly. By law.
Also, by virtue of your agreement with the home buyer, You have already given them the share in the undivided, share of the land to the home buyer also. So land owner cannot.
That share, if it is a freehold land, then the freehold share, and if it is a leasehold land, then the undivided leasehold right. That's it. I mean, that doesn't. No, that is not the argument. The argument is that these two only together make a project.
Yes.
Separately, they don't have. I mean, the project doesn't ceases to exist. And once you have given something for a project, past sins cannot be passed on to future generation.
Whatever may be the technical nature of the legal agreement you have drafted, you are, when you are passing on, giving the land, you are not expecting the land back. Though you are
by virtue, by virtue of that agreement, sir, by virtue of that agreement, you have collected the money, and now it has become CD's property. The landowner cannot claim back.
No, you may not have collected the money. It may only be fees rent payable year.
But here the general public good is required, is to be seen. The destruction of the asset which is created on the land, which is for an infinite period. It is not, you are not constructing project for 30 years or 40 years. The lease agreement can be for 50 years or 99 years, but they are renewable. So they are not to be taken back. They have to be together.
Like so many deeming fictions in law, this is a deeming fiction where, because of the nature of the land use, effectively the landowner becomes a joint venture partner.
So it is not a manufacturing unit where you can say, okay, sell the manufacturing unit to some other promoter. Millions, hundreds of millions of people are living there. They have put up their life there.
So they are not severable.
They are not separable.
That's the concept.
Yes.
Provided there is one proviso here.
Yeah.
Provided the future treatment of that land and use towards that use of land are in line with the existing agreement.
Yes.
Or any modification is agreed by that authority.
Yes.
It can't be unilaterally thokod on them. कि आगे कभी हम वेव करेंगे आधा करेंगे वो नहीं. That would be illegal in law.
Yeah, that because that is the right still yet to be used.
Yes.
And nothing for public good has been created on that.
Yes.
No.
So, but if the landowner is not cooperating with the resolution applicant, a successful resolution applicant, what relief he may have against the landowner? Can the NCLT order be enforced?
Civil court and High Court and Supreme Court.
So NCLT order.
Why not
NCLT has very limited jurisdiction on this matter. It can pass an order. Enforceability kahan hai? Power nahi.
Now, Ganti Sahab, now you see the loot. Why all these loopholes, all these gray areas should be left?
Oh, that's all over the world, huh? It is not only here. Bankruptcy courts are only given civil powers.
But the number of gray areas, unattended areas here is huge.
It is not in the law.
No.
It is in the implementation of the law that we have.
So why implementation could not be seen before?
That is a politician, bureaucratic businessman nexus. Subject.
Again, the loot comes into play.
Subject ही अलग है. वो root
again, the loot comes into play. The loot.
Yeah, absolutely. Chalo, let's get to the next one. We have this part here. Now, what is this thing called reverse CIRP? कोई समझाए? A lot of people talk about it.
Yeah.
But I doubt if anybody really understands it. I have not understood. I can't understand the meaning of this word reverse CIRP.
I have not handled it, but we have just read all those things.
Yes, CRP means an insolvency resolution of a corporate debtor. Reverse means, is it the insolvency resolution of the creditor?
घंटी जी ये बात मैं नहीं मान सकता कि आपको समझ नहीं आ रहा है. आप जानते जरूर है, बताना नहीं चाहते.
बताइए.
ये टर्मिनोलॉजी मुझे समझ में नहीं आ रहा. उसके पीछे का जो ऑब्जेक्टिव है वो डिफरेंट है. Because that is the really project-wise insolvency.
Yes, sir. Yes.
Actually, by using this fancy terminology, confusion create हुआ है.
Sir, I can try. As you rightly said, reverse CIRP is Here you wanted to take control in CIRP, you take control from the developer and then you run it. He is ousted from the process. Now reverse is you are actually putting him in control.
Yeah.
You are putting moratorium. Nobody else will disturb him. Let him do his thing in peace. And that is why maybe we are trying to use the word as reverse
Yeah,
CIRP
it's
in
an
this.
unfortunate use of terminology, but reverse
Actually, if I
CIRP.
understand well, sir,
Yes.
the intent behind it was once a CIRP is announced in a real estate project, when there are multiple projects that are under default in various stages of completion, probably a chance should be given to the home buyers who can say that this particular project we'll do it ourselves.
No, Umang Realtek was not like that. See, the word used first time was in Umang Realtek, 4th February 2020 order. Here, the home buyer didn't say we want to do it ourselves because that right they have under RERA, by the way. They don't have to come to IBC. It exists in RERA. What they said was, IBC aapne kar diya for whatever somebody's application, but we don't want RP Sharpie to do all this. We have faith in the existing promoter. He has promised to do it. Please allow him to do it.
Yes.
Maybe monitored by the RP, but not managed.
Under the supervision of RP.
Monitored, yeah. Okay. So that is what the NCLAT at the time said. Yes, we agree in this particular project that the promoter will be continuing to be in control. Okay. So what is it really closer to PPIRP? That's what.
Or at best modified CIRP, not reverse CIRP.
The good old days of BIFR actually.
Correct.
That are continuing to be in control. But
absolutely.
No, it is closest to PPIRP. If you will see that PPIRP, same thing happens. Promoters continue to be in management, but monitored and supervised by both a COC and an RP. Now, this RP has limited powers. They doesn't get into day-to-day affairs of the company, attends board meetings only as a permanent invitee, monitors whether the management is continuing to be within the contours of IBC. If not, report to the COC and, take away the PPIRP status or change it or whatever. So this reverse CIRP is really PPIRP. And that's how it should be looked at. And then it starts making sense. Okay, debtor in possession, not fully in control, monitored. Okay.
Agreed.
The terminology was unfortunate. It was confusing people. A reverse CIRP. And moratorium, that is the 24th March in the same.
In fact, sir, just to add here, when we say reverse CIRP, then we say that it does not have any hold in the law also, and there is no talk about it.
Yes.
In fact, if we would have used the word like PPIRP kind of, then we know that it has force of law behind it.
Yes,
and
absolutely.
then it would have been much more acceptable also, I guess.
Yes, absolutely. In fact, that is exactly what the 24th March 23 order of NCLAT in the same matter says. A reverse CIRP exactly same words used. So they went on, this was an issue of moratorium. They said it applies to the company as a whole. Though they might only be looking at one project separately, etc. But it will still be treated as a normal CIRP with minor modifications. Okay. Okay, so now we will come to the next question. There is a bit of, having gone through all this, now that we know that real estate is extremely complex insolvency, complex because of the limitations in terms of understanding among the majority stakeholder, which is the allottees. And also the fact that it's a immovable property, but not treated as immovable property. For the builder, it is only inventory, etc. All these issues come up. So, scope for advisory and consultancy role, especially in the stalled real estate project. Now, what I'm trying to say here is that for IPs who are well versed in real estate type, there is good scope, possibly as advisors or consultants to any of the stakeholders, but especially allottees in a real estate project. That was just in passing. And I will come to the next one is about AR. So AR, all the duties, etc. I think regulations people would have read. One question that comes to mind today, the appointment process of an AR is, if those of you will remember, yes, Minister, it is like jobs for the boys. So the IRP selects 3 names of people known to him or her. Those are the ones proposed. The allottees have no clue which name or what. For all you know, they might be voting on the, whatever they like individually as a name, nothing to do with the person. And because ultimately the AR effectively is the person recommended by the RP, though one of the 3, and then appointed. Now it is effectively a member of the COC is the one who is proposed by the RP. Is that a healthy practice? Or should it be that
So this is the only way
AR should be
to ensure
appointed from the
time.
panel?
So time bound for time bound process. I think it's a decent.
No,
but
okay, there are alternatives. Okay, the RP is not selected by all of them anyway. IRP himself is not selected. So, and AR has no adjudicatory role. He is only a consultant, advisor, friend, philosopher, guide for the allottees. So why not appoint the AR from the panel available with NCLT with no role for the RP?
Good idea, sir.
And on the date on which admission order is passed, RP and IRP and AR are appointed on the same day.
That will reduce a lot of time and tensions also.
Independence, big factor.
Yes.
Time,
Yeah.
yes. And the AR becomes a part of the process from the first meeting, which today can happen till the 4th or 5th meeting because of the time taken to appoint.
Yeah, that is what I said. Tension is because of the independence. People challenge, So all
then time to take the consent of the proposed AR.
Sorry?
How this will be
No, I said IBBA panel consent is deemed when you are from IBBA panel.
That's right. But sir, that is because of the independence. Then in other cases like section 7 and in section 10, where the name of the IP.
I think NCLT takes about 2 or 3 days to decide. I mean, they call up 4 or 5 people and say, do you want to?
No, even, sir, even the name of the AR.
My submission is this thing. It's okay. It's for AR. There's no nothing like this in the law. But in the same way, then why only for AR? Why not for every appointment of the IP?
No, that is, we are coming to that. Okay, I'm not, if you ask me personally, I say every appointment should be by court. There should be no proposal by any party. But that's a personal view.
Sir, but in that case, even the applicant can propose, like he's proposing the name of IRP, AR can be proposing the petition itself.
Yeah, I mean, there are different options.
Why should NCLT exercise it from the panel, and the poor fellow may not be interested in the assignment as AR?
They have given empanelment. They have to be